This is the Troll Patrol, live with Justin FREAKIN.
Welcome to the Troll Patrol live special report. It's that morning. The judge has just taken the bench in the courtroom. He is currently delivering instructions. Closing arguments are getting ready to begin in the Derek Chauvin trial. So let's go ahead. We are watching the Washington Post right now. This is live from inside the courtroom.
And you must state your findings as to each count in a separate verdict, uninfluenced by the fact that your verdict as to any other count or counts is in favor
So
of
get ready,
or
deep
against
breath.
The defendant may be found guilty or not guilty of any or all of the offenses charged, depending on the evidence and the weight you give it.
On the left side, you're seeing the judge. On the right side, that is the defendant, Derek Chauvin.
On the law that you are to apply to the charges in the defense.
You might not recognize him without his knee on the back of a black man's neck.
Phrases that appear more than once in the elements of the charges and the defense that follow. The words and phrases being defined are bolded in the written copy of the instructions you will be receiving. You should use these definitions for these words and phrases in your deliberation. Attempted.
The jury was told to pack a bag, but hope that they won't need it.
And more than mere preparation for causing the
We could have a verdict by the end of the day. It is possible. We could have a hung jury. We could have deliberations for weeks.
Charges or the defense.
It's all kind of up in the air right now.
Injury, illness, or any impairment of a person's physical condition. Substantial bodily harm means bodily harm that involves a temporary but substantial disfigurement, that causes a temporary but substantial loss or impairment of the function of any bodily member or organ, or that causes a fracture of any bodily member. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. To cause death, causing death, or caused the death means that the defendant's act or acts were a substantial causal factor in causing the death of George Floyd. The defendant is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not otherwise have occurred. To know, to have knowledge, or knew requires only that the defendant believes that the specified facts exist. Intentionally or intentional means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal, and that are set forth after the word intentionally or intentional. With intent to, or intended, means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause that result. It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act. Police officer means an employee of a law enforcement agency who is licensed by the Board of Peace Officer Standards and Training, charged with the prevention and detection of crime and the enforcement of the general
Really breaking it down in every minute detail here. This judge is really concerned.
A law enforcement agency is a unit of
with not giving the defense a reason to be able to appeal,
and to charge
no matter what the verdict is.
Duties of preventing and detecting crime and enforcing the general criminal laws of the state of Minnesota. The Minneapolis Police Department is a law enforcement agency for these purposes. The definition of any word or phrase with a specific legal meaning that appears only once in the elements or the defenses will be defined where it appears later in these instructions. The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree. It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree. There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault and that George Floyd sustained substantial bodily harm as a result of the assault. Fourth element, the defendant's act took place on or about May 25, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the third degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons. A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element, defendant acted with a mental state consisting of reckless disregard for human life. The defendant's act may not have been specifically intended to cause death and may not have been specifically directed at the particular person whose death occurred, but must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element, the defendant's act took place on or about May 25, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the second degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the second degree. The defendant is charged.
Still reading definitions.
Aiding the commission of this crime. The elements of manslaughter in the second degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Third element, the defendant's act took place on or about May 25, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has.
If you're just joining us, court has been in session for about 15 minutes. The judges
crime committed by another person or persons
currently reading definitions to make sure everybody knows
the following instructions apply to all three of the charges.
to the word of the law what their responsibility
Guilty of a
is.
crime committed by another person or persons only if the defendant has played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another to commit the crime. The defendant's presence or actions constitute intentionally aiding only if first the defendant knew another person or persons were going to commit or were committing a crime. Second, the defendant intended that his presence or actions aid the commission of that crime. If the defendant intentionally aided another person or persons in committing a crime, or intentionally advised, hired, counseled, conspired with, or otherwise procured the other person or persons to commit it, the defendant is also guilty of any other crime the other person or persons commit while trying to commit the intended crime, if that other crime was reasonably foreseeable to the defendant as a probable consequence of trying.
Looks like I've got a cat that wants to go outside.
The defendant is guilty of the crime under this theory of intentionally aiding in the commission of a crime by another person or persons only if the other person or persons commit the crime. The defendant is not guilty for aiding, advising, hiring, counseling, conspiring, or otherwise procuring the commission of one of the charged crimes unless that crime is actually committed. The defendant, or the state rather, the state has the burden of proving beyond a reasonable doubt that the defendant intentionally aided another person in committing the charged crime. No crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable.
Now there's the key.
Determine if the
How many cops have we heard testify against him?
Look at those facts which a reasonable officer in the same situation.
There's your slam dunk for the prosecution's case.
The officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer, and without regard.
I will admit I was feeling very good about this case
Motivations.
throughout the trial, but after hearing Benjamin Dixon from the Ben Dixon program
as authorized by law,
talk about the possibility of a hung jury,
the state must prove beyond a reasonable doubt that the defendant's use of force was not authorized.
that might be the most likely outcome.
You are the sole judges of whether
You've got one or two people on the jury that are just looking for any reason to let Chauvin off.
In determining believability and weight of testimony, you may take into consideration the witness's interest or lack of interest in the outcome of the case.
Looks like Washington Post freezing up here. Okay, we're back.
Their age and experience, their frankness and sincerity or the lack thereof, and the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, any impeachment of the witness's testimony, and any other factors that bear on believability and weight. You should rely on the last analysis upon your own experience, good judgment, and common sense. A witness who has special training, education, or experience in a particular science, occupation, or calling is allowed to express.
Also, remember, a lot of people don't seem to know this. Chauvin wanted to plead guilty over the summer.
Consider the education.
Chauvin tried to enter a guilty plea and was rejected by William Barr and the Department of Justice.
The sources of the information, factors already given you for evaluating the testimony of any witness.
That kind of leads me to believe that Trump felt his re-election chances were better if there were unrest in the streets.
The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified.
Okay, so there's the statement that he read on Friday and asked Chauvin.
In deciding the believability and weight to be given the testimony of a witness, you may consider evidence of a statement by or conduct of the witness on some prior occasion that is inconsistent with present testimony. Evidence of any prior inconsistent statement or conduct should be considered only to test the believability and weight of the witness's testimony. In the case of the defendant, however, evidence of any statement the defendant may have made may be considered by you for all purposes. You have heard evidence of an occurrence involving George Floyd on May 6, 2019. As I told you at the time the evidence was offered, it was admitted solely for the limited purpose of showing what effects the ingestion of opioids may or may not have had on the physical well-being of George Floyd. This evidence is not to be used as evidence of the character.
As people pointed out, opioids would cause somebody to not feel like they were choking. You give opioids to respiratory patients so they don't feel like they're choking.
This information was presented to assist you as an aid in your understanding of
opioids would cause you not to resist arrest. It would sedate you.
By the records, other documents, testimony, and other evidence that was received.
So the defense's argument that opioids caused his death
not consistent with the facts or figures
isn't consistent with reality.
As you find them, you should disregard the chart or summary or animated video and determine the facts from the underlying evidence. Earlier during these instructions, I defined certain words and phrases, and you are to use those definitions in your deliberations. If I have not defined a word or phrase, you should apply the common, ordinary meaning of that word or phrase. During this trial, I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the rulings, since they are controlled by rules of evidence. By admitting into evidence testimony and exhibits as to which objection was made, I did not intend to indicate the weight to be given such testimony and evidence. You are not to speculate as to possible answers to questions I did not require to be answered. You are to disregard all evidence and statements of attorneys that I have ordered stricken or have told you.
Ohio.
And with that, I'd ask you to put your instructions under your chair as we listen to the closing arguments of counsel.
Here we go.
Is the state ready to proceed with closing?
So,
Mr. Swisher, you may proceed.
Prosecution first.
May it please the court, counsel, members
Now,
of the
content warning, fuckers. We are probably going to have to watch the video one more time.
his name.
We're probably going to watch all 9 minutes and 40
George
seconds of
Henry
it.
Floyd Jr. And he was born on October 14, 1973, in Fayetteville, North Carolina. To his parents, George Floyd Sr. and Larcinia Jones Floyd, Sissy, the matriarch. Now, you met George Floyd's brother, Philonis, and you heard all about Sissy Floyd. She was George Floyd's mom. She was.
It's a little more complicated than that. So conservatives believe in hierarchies.
And you heard about
So
the
they believe that
special
anybody that gets out of their place in the
she and George
hierarchy
Floyd shared
deserves whatever was coming to them by
during
the
his
power
life.
that keeps the hierarchy in place.
You heard about.
Does racism play into it? Abso-fucking-lutely. Do I believe that all conservatives are overtly racist?
To be with his
Not
mom.
necessarily. They are all are okay with racism.
In the fetal
That's for
position.
fucking
You
sure.
heard that. And from George Floyd's brother, you learned all about.
But the argument I make is that BLM, Antifa, they are standing up for the Constitution.
George
George Floyd's constitutional rights were taken from him by the state. The literal state had its knee on the back of the man's neck and snuffed his life out on an accusation that is a violation of his Fifth Amendment rights. Supposedly conservatives believe in the Constitution. I can't tell.
George Floyd was surrounded by people he cared about and who cared about him throughout his life.
And I'm certainly not high enough for this shit.
That house, through his adolescence, into his adulthood. On May 25, 2020, George Floyd died. Face down on the pavement, right on 38th and Chicago, in Minneapolis.
If I were the prosecutors, I'd probably finish up with the video.
9 minutes and
Last 10 minutes of my presentation, just play the
9
video.
minutes and 29 seconds.
Speaks for itself.
During this time, George Floyd struggled, desperate to breathe, to make enough room in his chest to breathe. But the
Medical
forces
examiners
too
testified it
much.
was like
He
a
was
lung
trapped.
had been
He was
removed.
trapped with the unyielding pavement underneath him, as unyielding as the men who held him down, pushing him. A knee to the neck, a knee to the back, twisting his fingers, holding his legs for 9 minutes and 29 seconds. The defendant's
And as we saw from the never-before-seen video, pulled his arms while they were doing it.
To expand because there wasn't enough room to breathe. George Floyd tried. He pushed his bare shoulder against the pavement to lift himself, to give his chest, to give his lungs enough room in his chest to breathe, with the pavement tearing into his bare skin. As he desperately pushed with his knuckles to make space so he'd have room to breathe, the pavement lacerating his knuckles. The defendant stayed on top of him for 9 minutes and 29 seconds. So desperate to breathe, he pushed with his face. To lift himself, to open his chest, to give his lungs room to breathe.
The man just trying to take a breath.
Tearing
Cops
his
saying
skin,
he's
George
resisting.
Floyd losing strength. Not superhuman.
Truth.
There was no superhuman strength.
Right-wingers are morons.
There's no superhuman strength because there's no such thing as a superhuman.
Exactly.
Those exist in comic books. And 38th in Chicago is a very real place.
It was an attempt to dehumanize him.
Only humans. Just a human, just a man, lying on the pavement, being pressed upon, desperately crying out. A grown man crying out for his mother. A human being. And in that time, and in that place, while he was surrounded in life by people he knew him, faces he could pick out, there was no one there he knew. He was surrounded by strangers. Strangers, all of them.
And people on the
9 minutes and
street
29 seconds.
yelling for the cops to get
Surrounded
off
by
him.
Strangers, not a familiar face to say his final words. But he did say them to someone. He said them to someone who he did not know by name, but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defendant. He asked for help with his very last breath. But Mr. Officer did not help. The defendant did not help. He stayed on top of him, continued to push him down, to grind his knees, to twist his hand, to twist his fingers into the handcuffs that bound him, looking at him, staring down at times the horrified bystanders who had gathered.
With a smirk on his face, his glasses sitting on the top of his head, looking like a total Chad.
The police department is to protect with courage and to serve with compassion. But George Floyd was not a threat.
To put their lives on the line if necessary to make sure the people in their charge get home no matter what they are accused of.
That did not require 1 ounce of courage, and none was shown on that day. No courage was required. All that was required was a little compassion. And none was shown on that day. George Floyd said, "I'm not trying to win." This was a call about a counterfeit $20 bill.
Which over and over again, old ladies get caught with a counterfeit 20 like, "Oh dear, you just got passed a bad bill.
People.
Let's take care of this for you."
But more fundamental than that, and more
The
practical.
black man got executed over it.
What George Floyd needed was some oxygen. That's what he needed. He needed to breathe. Because people need that. Humans need that. To breathe. And he said that. And the defendant heard him say that. Over and over. He heard him, but he just didn't listen. He continued to push him down, to grind into him, to shimmy, to twist his hand for 9 minutes and 29 seconds.
Because he enjoyed it.
He begged, George Floyd begged until
The fucking
he could say
sadist.
no more, and the defendant continued this assault. When he was unable to speak, the defendant continued. When he was unable to breathe, the defendant continued beyond the point that he had a pulse. Beyond the point that he had a pulse, the defendant continued this assault. 9 minutes.
Pushed a paramedic back that wanted to administer
When the
help.
ambulance arrived. The ambulance was here. And the defendant continued. He stayed on top of him. He would not get up. He would not let up. He stayed on him, grinding into him, continuing to twist his fingers, to hold him down. He had no pulse. He was not breathing. He was not responsive, and the defendant had to know what was right beneath him. Right beneath him. You saw the video. You saw the point when the ambulance arrived, and finally, after a paramedic got out, and the defendant still did not get up, and the paramedic tapped him, and finally the defendant got up, and they lifted Mr. Floyd onto that gurney, and you saw the way he was not, there was nothing there. His head had to be held to prevent it from falling to the ground. He was completely limp. The defendant had to know that. He was there. He was on top of him. And he was on top of him. On top of him. Sometimes you ask for the truth, sometimes you insist on the truth. And the truth is the defendant was on top of him for 9 minutes and 29 seconds. And he had to know.
A murder we all witnessed.
The medical examiner would find the cause of George Floyd's death to be cardiopulmonary arrest, complicating law enforcement subdual, restraint, and neck compression. Well, what you saw the defendant and the other officers doing to George Floyd caused his death. The medical examiner ruled the death a homicide, death at the hands of another. What the defendant did to George Floyd killed him.
Mm-hmm. Without question.
Ruled a homicide. The defendant is charged with murder. He's charged with murder and he's charged with manslaughter. The defendant at the time was a police officer. Okay? It may be hard. It may be hard for any of you to imagine a police officer doing something like this.
What?
Remember,
I sit here and play videos of cops breaking the law
bias, and we talked about setting biases
every fucking day.
Well, imagining a police officer committing
It is not hard to
be
imagine.
the most difficult thing you have to set aside, because that's just not the way we think of police officers. We trust the police.
I don't know why. How many of them have to be proven to be child molesters? How many of them have to plant meth on people?
Going to listen to
How
us.
many of them have to have toy guns that they're planning on children that
And
they
this
shot?
song, this
Before
runs
we
deep
start
into
actually treating
political
cops like the
society.
criminals they are.
That even after, with the bystanders, after they saw what they saw, after they saw this shocking display of abuse of police power and a man murdered in front of them, Genevieve Hansen, she called the police. Donald Williams, he saw this. You heard
Called
him.
the
He
police.
testified.
On the
He
police.
called the police. A 9-year-old. Judea. What did she suggest? We need to call the police on the police. That's our expectation. Even after seeing this, even after witnessing this, our expectation is that the police are going to help. And with reason, and with good reason, right? Because policing is a most noble profession. It is. It is.
Fuck
And
you. No, it's not.
clear. This case is called the State of Minnesota.
Nurses, doctors, pizza
This case is
delivery
not
people,
called
pot
State of
dealers,
Minnesota versus the police. It is not.
sex workers. There are so
Policing
many more
is a
noble
noble
professions than being
And
a
it is a
police
profession.
officer.
You met several Minneapolis police officers during this trial.
I don't like this prosecutor anymore.
Stand, they testify. Make no mistake, this is not a prosecution of the police. It is a prosecution of,
It should be.
and there's nothing worse for good police than a bad police who doesn't follow.
There are no good
Doesn't
police
follow
because the good
procedure.
police
Doesn't
sat
follow
around and
things.
watched him commit murder.
Ignores the
So
policy.
they aren't good police. They're bad police.
The motto of the department: to protect with courage, to serve with compassion. Chief Arredondo, the chief of police in Minneapolis Police Department, he took the stand and he testified and he told you what that badge that he wears over his heart means. It's a public service. It's a public trust. They're there to help us. It's a professional organization. There are standards, there are rules, there's a code of conduct, there's a use of force policy, there's extensive training.
I've got issues with all of those things.
First responders, they're who we call for help, and they help us. They have CPR training. If there's more training than simply use of force. There's more to policing than putting handcuffs on people and hauling them away.
I can't tell.
There's other kinds of training. There's procedural justice. There's crisis intervention training. There's medical training. And there's defensive tactics. And there's de-escalation. All of this training. Hundreds of hours of training. You met the people who staff the training center. And they told you, we don't train this. They told you that.
I call bullshit.
Sanctity of life and the protection of the public, those are the cornerstones of Minneapolis Police Department's use of force policy.
Because we know of other cops doing the exact same thing.
All of the human beings that make up the public. The defendant, he didn't do that because that day his badge just wasn't in the right place. The defendant was a police officer. He was. And again, you need to set aside the notion that it's impossible for a police officer to do something like this. The defendant...
I don't have that notion. I live in reality.
It's not the state versus the police. He's not on trial for who he was. He's on trial for what he did. That is what he did. That is what he did on that day. 9 minutes and 29 seconds. That is what he did. He didn't follow training. Those hundreds of hours of training that he had, he did not follow the department's use of force rules. He did not perform CPR. He knew better. He just didn't do better. He just didn't do better. Remember during opening statement, counsel said that the defendant followed the rules and followed his training. Did you hear evidence of that? Did you hear evidence of that from the stand?
Nope.
Or did you hear something quite different? The chief of police testified. He violated their use of force policy. He violated their de-escalation policy. He violated the duty to render emergency aid. No. You heard the trainer, Lieutenant Mercil. We don't train this. This is not who we are. No. That representation was simply wrong. That's just a story. What the defendant did was not policing. What the defendant did was an assault. I'm going to discuss the law with you in a bit here and explain. The court's already provided you some instructions on second-degree murder, and you know, done in the laws of this state, if you commit a certain level of assault, a felony level assault, and a person dies as a result of your assault, you're guilty of murder. It's as simple as that. And what the defendant did here was a straight-up felony assault. This was not policing. It was unnecessary. It was gratuitous. It was disproportionate. And he did it on purpose. No question. This was not an accident. He did not trip and fall and find himself upon George Floyd's knee and neck. He did what he did on purpose. And it killed George Floyd. That force for 9 minutes and 29 seconds. That killed George Floyd.
I'm going to open up the Justin Chan message board.
And everything it stood for. It's not how they're trained. It's not following the rules. This is not an anti-police prosecution.
I'm going to breed the next QAnon.
It's a pro-police prosecution. The defendant abandoned his values, abandoned the truth.
I want to put this prosecutor on trial now. Sucking cop cock.
Why? Right out in the public, right out in broad daylight, in front of several bystanders as they looked in shock and horror. And why? Well, this all started over a call of an alleged counterfeit $20 bill. But George Floyd's life was taken for something worth far, far less. Far less.
By a man who was committing fraud in the tens of thousands, by the way.
Body language. You can learn a lot about someone by looking at their body.
Chauvin still facing fraud charges.
Defendant facing down that crowd.
He is a tax cheat.
They were pointing cameras at him, recording him, telling him what to do, challenging his authority, his ego. His pride. Not the kind of pride that makes you do better, be better. The kind of ego-based pride. But the defendant was not going to be told what to do. He was not going to let these bystanders tell him what to do. He was going to do what he wanted, how he wanted, for as long.
Call that a cop with a little dick.
There was nothing they could do about it because he had the authority. He had the power of the badge and the other officers. And the bystanders were powerless. They were powerless to do a thing. The defendant, he chose pride over policing. Charles McMillan,
I'd love to know what he's writing
interesting
over.
man. Right? You remember when he testified? He
Probably
had
scribbling
glasses.
or some shit.
If any of you in the front row, when he walked by, happened to notice his shoes, if you looked at his shoes, you probably saw your reflection in those shoes, right? He dressed for court like it was the most important day of his life. Interesting man. He was there. He's sort of narrating this horrific scene throughout. You hear him in the video. And he called out to George Floyd. He said, "You can't win. You can't win." And George Floyd replied, "I'm not trying to win. I'm not trying to win. I'm scared." But the defendant,
He's just trying to
the
breathe.
defendant was trying to win. He wasn't going to be told what to do. He wasn't going to take a challenge to his authority. He was trying to win.
It was the Eric Cartman respect
George
my
Floyd
authority.
paid for it with his life. Now, also need to be clear, this is not the trial of George Floyd. George Floyd is not on trial here. You've heard some things about George Floyd, that he struggled with drug addiction, that
Who hasn't? It's
being
America.
investigated for allegedly passing a fake $20 bill, that there was never any evidence introduced.
Everyone
that it
in
was
this
fake in
late
the first
stage
place.
capitalist hellhole is on
He
drugs.
is not on trial. He didn't get a trial when he was alive.
I'm drinking a heavy dose of black tea right
He's
now.
not on trial here.
Certainly killed that dude. Case closed. We all
Defense
saw it.
claims that he was non-compliant. Non-compliant. Well, let's revisit what happened before.
I think there's only one of two options. It's guilty or it's a hung jury.
It's Memorial Day, right? May 25, 2020.
I think there is absolutely no way the jury comes back with not guilty.
In the driver's seat with two friends. Now, previously he'd been in Cup Foods. He'd been in the store. He was walking. He was talking. He was
I'm also
breathing.
interested about this Cup Foods
As
place.
alive
Is it
as
like a ramen store? You go in and you
In
get
this
your
room.
cup of ramen and then you put your different,
back to the car. with his
you put your
friends.
meat or your
And there's a tap
vegetables in
at
your
the
ramen.
window.
Is that what a Cup Foods is?
He looks to his
Interesting name.
left and a start. This is what he sees.
Yep.
This is what he sees. Within seconds of the approach, Officer Lane have tapped on the window. Within seconds, he pulls his gun and holds it inches from George Floyd's
Everything comes in a cup.
and
Interesting.
starts shouting.
So it's not just specifically ramen,
me
or are you just
your
making
hands.
that up?
"Show me your effing hands."
It's the same thing we saw with Lieutenant Nazario in Virginia.
You can tell a lot about someone by looking
Cops
at
go from 0 to 100.
How
Come
does
out
Mr.
just
Floyd
guns right in his
look in this
face.
photo. Terrified?
And then we blame humans for having flight or fight.
Officer
Fight or flight.
on the driver's
Fight or
side,
flight
officer on the
reactions.
passenger side. Lane orders Floyd to put his hands on the steering wheel. He does. That's not resistance, that's compliance.
Mm-hmm.
Lane orders Floyd to get out of the car. He does. That's not resistance, that's compliance. They order him. They want him handcuffed. He is handcuffed.
For the
That's not
accusation of a $20 bill, remember. They approached him with guns drawn,
Properly double locked.
handcuffed him over the accusation of a
So they
$20
continue
bill.
to ratchet
And that's why I say that's a violation of his Fourth Amendment rights.
Throughout, and you listen to the videos, throughout the videos, you can hear
Unreasonable search and seizure.
ratcheting tighter and tighter. Mr. Floyd is trying to explain to the police that his wrists hurt. Impervious to pain. Please. His wrists hurt. No one listens to him. But it continues. They tell him.
Well, hey, like it's whatever.
go over to the dragon.
Whenever right wingers want to claim anything they don't like is bad, they're gonna say like trans people are superhuman.
Not resistance, compliance.
They're super athletes that are taking all the scholarships, even though that's never fucking
Not
happened.
trying to assault anybody, shoot anybody, stab anybody, punch anybody. No, compliance. Sits down on the ground.
Of course, they're gonna call it George Floyd superhuman to justify their murder.
That's not resistance, that's compliance. They ask him to get up, he gets up. They ask him to go across the street, he goes across the street. Right, where's the resistance?
Exactly.
Where's that?
Even though they were in the wrong from the beginning.
They take him over to the car. Okay? They take him over to the car.
This is not a police state.
He's a big guy. Right? You can see here, I mean, he's almost as big as Officer Lane. He's a big guy. He's a big person. The back of the squad car is not.
No, it's not.
They wanted him to get into. And to George Floyd, he looked at that. What do you think that looked like? Like a little cage. He tried to explain himself to the officers that he had anxiety, that he had claustrophobia.
Totally reasonable.
Over and over. They wanted him to get in the back of this little car. And, you know, he just wasn't able to bring himself to do it. He wasn't able to bring himself to do it.
Man, I'm scared as fuck, man. That's a breathing's gonna go out on me, man.
Pull your legs in.
Okay. Let me count to 3. Let me count to 3 and I'm going in. Please.
So he's trying to work up the ability to get in the car
Need to address cops being triggered.
repeatedly. And you can see...
Well, I have a idea that I think a lot of them are on speed,
We'll look at what they saw.
steroids, shit like
They
that.
start to come to the scene. Right? A 19-year veteran of the police force with all of the training that involves, over 800 hours of training, 40-hour crisis intervention training course, a scenario-based training where they're taught to recognize the signs of someone who is experiencing a crisis. A crisis. You know, he couldn't bring himself to get in. And sometimes people can't bring themselves to get in. And this is not new. This is not groundbreaking. Okay? People have emotions. People have things happen to them. The police train for this. They recognize this. You don't get to meet the police on your best day very often.
Nope.
You don't call the police and say everything's fine, just wanted you to know, right? That doesn't happen. Okay? No, there's a whole
Well, even if you did do that, they'd still come over and shoot your dog.
issues. I mean, it could be anything. It could be a death in the family. Right? That can cause an extreme emotional response. You know, recall when Officer Lane approached the car, George Floyd talked about losing his mother. He'd lost her in 2018. Those wounds still right there on the surface. Emotion. It could involve a divorce, finding bad financial news, right? Mental illness, mental health issues, like drug and alcohol abuse. All of those things can cause someone to not resist, but just not be able to bring themselves to comply at that moment, at that time. And this is nothing new. They train for it, they plan for it, they prepare for it, they have a policy.
Honestly, I doubt it. That you bring up a very good point. That is something that should be researched, but cops are so...
He testified that they have...
Cops don't give out data.
1,000 calls for service.
Like, it wasn't until the Obama administration that they even forced cops to start reporting who they kill in their custody.
They're there on a $20
Imagine that.
counterfeiting charge. They train for this. They know about this. Now,
And I mean like the end of the Obama administration. It's only been like 6 or 7 years that they've had to report to the feds the people they kill in their custody.
with opioid addiction. You knew that. And this is nothing new. The difference, though, on May 25, 2020, the officers just wouldn't listen to him, wouldn't look at the signs, wouldn't recognize the signs of what they had prepared for. And a reasonable officer in the defendant's place, with all his training and all his experience, including that 40-hour crisis intervention course and a subsequent refresher course, should have known that.
He complied the entire time.
Floyd was trying to get into the car. He was trying to work up the courage. He said he'd count to 3.
Mm-hmm.
But he just couldn't do it.
And seeing his, and that was the defense presented one of his previous arrests from like 2019, but it was the same damn thing. The cops, guns pointed, got right in the motherfucker's face, yelling at him, threatening him. Why are the cops just after this man constantly over a supposed fake 20? And the cop that killed him was committing fraud in the tens of thousands.
He know it. He know it, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
If you get in this car, we can talk.
I am claustrophobic.
I'm hearing you because you're not working with me.
God, I'm claustrophobic, man.
And they are incredibly small. I've been on many a ride along.
Okay, man, okay. I'm not a bad guy, man. In the car. I'm not a bad guy. You ain't gonna win.
So, they don't.
Anytime I was in the back of a cop car for a ride along, I had to sit
back seat. You saw
very,
the look on his
like,
face.
smushed sideways. And I'm not that big of a guy.
Looked like he'd seen a monster looking into that car. Clearly. This trained officer should have recognized that and understood at that moment and that time, well, what is your goal?
The
critical thinking
The prosecution has not brought that fact up. Apparently, they did know each other. The prosecution referred to Floyd calling him Mr. Officer while his knee was on his neck. And he did. Floyd did not act like he knew Chauvin during the interaction. He kept calling him Mr. Officer. But apparently, they were bouncers at the same club.
They decided to shove in the car. The predictable thing to happen happened, right? He just couldn't be in the back of that car. And so they pull him out. They pull him out. And watch what happens. They pull him out of the car.
What? Please, man.
Here, come on out.
Look at you. Thank you. Thank you.
Get him down the ground. Yeah, on the ground.
Content warning. This is very hard to watch.
All right, folks. They get him out of the car. He is handcuffed. He is on his knees. He is not going anywhere. There are 4 officers there. 4 officers. And what did George Floyd say once they pulled him out of the car? Thank you. Thank you. Now, a reasonable officer in the defendant's position at that time should have recognized and understood he wasn't trying to escape. He wasn't trying to punch anyone, stab anyone. Well, wasn't trying to do that. The problem was the back of the car, just like George Floyd tried to explain over and over. The problem was the back of the car. So if you can give them the benefit of the doubt that they made a bad judgment call and shoved him in the back of the car, at least
But Chauvin has been riding the entire
in
time.
the struggle, it was over.
I hope he's not doing like Mattingly from the Louisville Metro Police Department,
It could have been over there.
writing a fucking book.
But what did they do? They took
If
him
he's
from
convicted, there's no way he can write a book.
handcuffed
Dude,
on
you
his
can't
knees.
profit off of a crime
They
you've been
pushed
convicted
him
of.
down onto the ground. Didn't need to. Not at all. For what? He's handcuffed. They pushed him down into what is, you now know, from watching the evidence in this case, the prone recovery position. Right? When he's down on the ground, he's initially pushed, he is literally in the prone recovery position on the side. That allows the chest to expand and provides room.
If he was going to do that, he should have done it months ago and saved us all
breathe.
this trouble.
That is a step that protects against the
He's not a man. There's no way. Cops are
And they have him
cowards.
He's right there. So then what happens after?
I know people say that suicide is the cowardly way out. No.
Out of the recovery position and prone him.
I'm a coward. There's no way I could go through with that.
For what? The prone position is a transitory position. It's a position you use to secure someone in handcuffs, and when you're done with that, you immediately roll them on their side. Right? That's the position he was in. Proning him was completely unnecessary. And this is where the excessive force begins. Right? This is where the 9 minutes and 29 seconds start, because they didn't just lay him prone.
Apparently, Stephen P. New is not actually that good of a lawyer.
With a knee on the
He's
neck,
somewhat of a yokel, as I've been
the
told.
defendant's weight on Mr. Floyd, pushing down, with Officer King adding to the pressure, pushing down, holding his feet, Officer Lane holding his feet for 9 minutes and 29 seconds. That's when the excessive force began. That's when the countdown began. Now,
I think it was excessive from the moment that they instigated this. Coming up to the man's car
procedures,
with guns drawn,
you have to pull back.
yelling profanities at him was excessive.
But for the defendant's actions, pushing him down, would George Floyd have died that day? Was it drugs? He just miraculously die of a drug overdose in that time?
Nope.
Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense. Use your common sense. Believe your eyes. What you saw, you saw.
Well, if it was a tailpipe, the officers were
No.
still responsible.
Talk
No,
to me.
Smokey is like right there. Do you see him? Right there.
The judge is
He's
already
outside on the patio. Maynard has been going by multiple
It's
times.
necessary to go over this a couple
Oh,
of
Smokey heard me talking about him too. Here he comes.
got to go to medical school here as jurors.
Come on, buddy.
There's so many benefits to being a jury. You got to
Oh, he
go
went to the
medical
other
school,
window.
you
Sorry.
get free parking,
He's over there.
great lunches, fabulous pay. So now you get a little bit of a free law school education. The judge gave you a preview of that. We're gonna go through that again. He's going to give you a copy of those instructions. You have them
Free law school education.
and use those.
Shout out to a couple of my friends who are in law school right now, coming up on finals.
Decide these issues in any order.
I was talking with one the other day. I'm like, where have you been, man? How do you not know about all this shit going on? He's like, dude, it's finals right now. I'm like, oh.
Deliberations and just make the conversation a little easier, a little more focused. But you have these jury
So
instructions.
shout out to everybody going through finals right
It's
now.
important for you to follow.
That's exactly right. He was coming this way, and birds and squirrels caught his attention. He went
the
over
judge
there.
gives you. They mean what the judge says they mean. And know that the state is required to prove these charges beyond a reasonable doubt. Proof beyond a reasonable doubt. He read this to you. Proof beyond a reasonable doubt is proof as ordinarily prudent men and women would act.
Smokey has been confused, like, why haven't the doors been open? It's been cold the last few days.
Common sense.
Or not cold exactly, but just chilly enough to where you can't open the doors.
All possibility of doubt. So reasonable doubt, it's just as the name implies. It's a doubt that's reasonable. A doubt based on reason and common sense. You as jurors are not required, nor should you, leave your common sense at the courthouse steps. As jurors, you must rely on your common sense. That's why you're here. We need you to apply that standard to these facts and to be a
And yes,
judge.
as you can see, the cats are active. They're
Apply
all...
those facts and finding
They
these
sleep
facts.
with me, so when I get up, like, they're up.
Proof beyond a reasonable doubt. It certainly is a high standard. It's the highest.
I don't. People talk about like cats
standard
being
the state
nocturnal
is-
and shit, but like my cats go to bed with me. They wake up with me.
The state does not need to.
They take
prove-
mid-afternoon naps. They'll be in bed here in a
does
little
not
bit.
Need to prove its case beyond what I'll call an unreasonable doubt. Not required to prove beyond an unreasonable doubt. An unreasonable doubt is a doubt not based on common sense, but based on nonsense. And you're not required to accept nonsense. You're not required to accept the notion that after the defendant kneeling on Mr. Floyd for 9 minutes and 29 seconds in the dangerous prone position, handcuffed, restrained, pressing down on him, that after that, as he was writhing in pain and suffering, that's not even a use of force. There's no force there because it's not likely to produce pain. A witness testified.
We are what? We're about 40 minutes into them, 35 minutes into them. Prosecutors have done a good job. I don't really care for the way the prosecutors have been sucking up to the cops, but then again, they've got to do that.
Not likely to produce pain.
Multiple times, he's like, the cops aren't on trial. We aren't putting the cops on trial here. This is one man. Bad apple argument, but I think it is cops on trial.
You're not required to accept the proposition that the car did it.
I will return in 1 second.
You're not required to accept that or to consider that it is the bystander's fault for distracting the defendant. You're not required to believe this amazing coincidence that after this 9-minute and 29-second prone restraint, that at that point in time, even though he was walking and talking, even though he was breathing, interacting with people, that he chose that moment to die of heart disease? To die of heart disease? Is that common sense or is that nonsense? Or that it was a drug overdose? You know that George Floyd struggled with drug addiction and drug use. You know that. You know he had developed that requires a tolerance. You know what the toxicology report says in terms of the levels, and you know what the testimony was about that. You die of a drug overdose. That's not common sense. That's nonsense. Believe your eyes. What you saw happened. It happened. The defendant pressed down on George Floyd, so his lungs did not have the room to breathe. Dr. Tobin told you that. Dr. Smock, Dr. Rich, the experts who testified, you can rely on them. Dr. Smock, Dr. Rich, Dr. Eisenschmidt. It's like that commercial, right? They know a thing or two because they've seen a thing or two. They know a thing or two. Dr. Tobin knows a thing or two about how this works. So looking at the charges, and this is a little bit of a different layout than you see in your printed jury instructions, and they're not intended to replicate the instructions completely, but it's meant to be sort of a guide for you to look at the different elements in a particular context. And so the charge of murder in the second degree, murder in the third degree, manslaughter in the second degree, the judge read you what the law says those things are. And the law breaks down these different charges into things called elements. First element, second element, third element, fourth element. And each of these has to be proved beyond a reasonable doubt by the state in order for the defendant to be guilty of those charges. Those are the elements that are required. Those are the only elements that are required. Again, like other preconceived notions, you may have some ideas, from watching TV, about other cases and shows and things. You might have some other ideas as to what the law requires.
Leave your law and order at the door is what he's saying.
You know how it's lunchtime in court? The judge tells you it's lunchtime. You know when it's time to go. The judge tells you it's time to go. Same thing. You know what the charges are. You know what the elements are because the judge tells you what the elements are. So you need to follow that. Okay? So talking about murder in the second degree, first, the death of George Floyd must be proved. Right? And then it must be proved that the defendant caused the death of George Floyd. And the fact that other causes may have contributed to George Floyd's death does not relieve the defendant of any criminal liability. It just does not. And for murder in the second degree, that the defendant at the time of causing George Floyd...
So he's going over the charges right now. It is possible for the jury to return not guilty on murder in the second, guilty on third, guilty on manslaughter, or any combination.
To show the defendant assaulted George Floyd, that he intentionally applied unlawful force to Mr. Floyd without Mr. Floyd's consent,
obviously
resulting in bodily harm.
Not likely that he's going to get convicted on the more serious charge and then not guilty on the
and that the
lesser
defendant
charges.
inflicted substantial bodily harm on George Floyd, and that this act took place on or about May 25, 2020.
That's also a possibility that we get, guilty on manslaughter, not guilty on murder.
As to the first element, that George Floyd died. Well, that was established.
It's also possible that
established.
there is somebody in that jury that has a hard-on for cops
At the Hennepin
and
County
is looking for
Memorial
any
Hospital,
reason, any fact that they can hang on to
that element is met.
to not
And
throw
again,
out a guilty
you
vote,
can consider these
and
elements
we'll
in
get a
the
hung
way
jury.
you want to
Yes,
consider
killer
them.
pigs are always
Suggestion is
guilty.
that you consider them in the order as listed here.
Our legal system affords them great leeway. I think it should be the opposite, that we should hold them to a higher standard, not give them leeway.
There are a lot of exhibits that were offered, and it's easy to talk about everything.
Oh, you killed a 13-year-old who had his hands up? Automatic murder charge.
Focus
I'm
your
sorry.
deliberations, if you look at these different elements in order, to have sort of a logical way to focus your deliberation. So I encourage you to do that, but you can do it any way you want.
And I like how with the cop in Chicago, I can't even remember his name right now.
George Floyd.
It came out that was the first shot he had ever fired from a service weapon. They made him seem so
Is
innocent.
it the defendant's act or action?
Turns out he'd had a bunch of use of force complaints on him.
Substantial causal factor.
It may have been the first time he ever fired his gun.
Liable for all of the consequences of his actions that naturally occur.
But it wasn't the first time that
Those
he had been
consequences
accused
brought
of
about
using
by
excessive
intervening
force.
causes. The fact that other causes may have contributed to George Floyd's death just as
But cops love to get out in front of everything and try to dominate the narrative.
you have to find is that 9 minutes and 20
Mayor
minutes
Lori Lightfoot helped them.
on his knee with
The
his
fuck
knees
her.
on his neck and on his back being held down was a substantial factor in George Floyd's death.
I do not want to see what
Now,
happens if this
there was a
motherfucker
superseding
walks.
cause, then the defendant wouldn't be criminally liable. But the superseding cause those are causes that come after the defendant's acts and alters the natural sequences of events and is the sole cause of death. And we don't have that.
And of course, we've had multiple shootings over the weekend.
How George Floyd died. This is the use of force. When we talk about use of force, that's been defined by the
The
different
shooting
witnesses
in
that
Austin was a former police officer.
from the point the knee went to the neck and back, right, and the unlawful restraint, the assault started, and how long it lasted, 9 minutes and 29 seconds. Right. That's what George
Not to be confused with the shooting in San Antonio
That's why he died. Believe your eyes.
or the shooting in Kenosha.
Unreasonable force pinning him.
No,
to
not that shooting, not Jacob Blake. No,
That's-
not Kyle Rittenhouse. No, the one that happened this weekend.
This was a homicide.
This is
you've
America.
heard this from forensic pathologists, the experts. You've heard this, and the experts have weighed in. And Dr. Langenfield told you that Mr. Floyd died. Dr. Baker ruled this a homicide. And told you the cause and manner of death, the unlawful, the restraint and subdual by law enforcement. What they did killed him. Told you that. Dr. Tobin, remember Dr. Tobin, he told you specifically how it happened. He walked you through that, the asphyxia. Right? He told you how it happened. And the other doctors who testified, Dr. Smock, Dr. Rich, Dr. Eisenschmidt, they told you how it didn't happen. Right? It wasn't a sudden cardiac event. It wasn't a heart attack. It wasn't a drug overdose. It wasn't any of those things. Right? Dr. Tobin came back and explained it wasn't carbon monoxide. Right? No. So you know how George Floyd died, and you heard this, but specifically.
Now, I'm so interested to see exactly what the fucking defense
very
says.
extensive detail, and was
It's
very
probably going to be after lunch if I know the way court
as a result
works.
of a low level of oxygen. This low level of oxygen caused a brain injury and a PEA arrhythmia, which caused his heart to stop. That's not a cardiac.
We're about an hour into the prosecution's presentation. They'll probably take less than another
caused him
hour.
to die.
A break for lunch, and then we'll be back after
It was
lunch,
the
probably.
low level of oxygen. It was the asphyxia that caused him to die. Right? And we know that happened. We know that happened because they observed during the restraint at 20:24:21, right? What they observed? They observed an anoxic seizure, right? A telltale sign of oxygen deprivation. Dr. Chauvin told you that. Even Dr. Fowler told you that. And after Mr. Floyd experienced a seizure, he passed out. After his pulse stopped, his heart stopped. That cardiopulmonary arrest, that was the result of the police
I'm with you, Residue.
restraint and the neck compression. We know from Dr. Chauvin, George Floyd did not die primarily from a cardiac event, as has been suggested. Now, George Floyd, he was not in perfect health.
So what do you guys think in chat? Are we going to get a verdict today?
He was, no question, he was experiencing.
Closing arguments are almost certainly going to be wrapped up by 3, 4 o'clock this
Shoved him onto
afternoon.
the sidewalk unnecessarily, gratuitously, disproportionately. But none of this.
How long do you think the jury deliberates on this?
Not. His heart failed because the defendant's use of force, the 929, okay, that deprived Mr. Floyd of the oxygen that he needed, that humans need to live. And Dr. Tobin knows because he is a pulmonologist. He's a lung doctor. He's a lung doctor. He's also a respiratory physiologist. He's the only person who testified who was able to calculate lung capacity, lung volume. He could do that. Dr. Baker couldn't do it. Didn't do it. He deferred to the pulmonologist, Dr. Tobin. Dr. Fowler couldn't do it. He said he would defer to a pulmonologist.
I don't believe it's going to go on for another day.
A critical care physician. He spent years treating patients.
I would expect the prosecution to take a couple hours. I would say the defense takes less than an hour.
Respiratory failure. And Dr. Tobin literally wrote the book on the subject.
And then I believe the prosecution gets another word.
What this looks like, what he was able to observe,
Another one?
he was able to observe was oxygen.
We've got dozens.
It was asphyxia. Because under the conditions that Mr. Floyd was being restrained, that the defendant put him in,
And I am for the family of Tamir Rice wanting the Justice Department to reopen that case.
that were used in the situation, right? It involved multiple factors. George Floyd was handcuffed.
Bits thinks we're going to get a verdict today.
He was placed prone, shoved prone.
I think it's possible.
Sidewalk. The knees pushing on his neck.
I think it's either it comes fast, that they're all in agreement, or it's a hung jury.
It was like he was in a vice. That he was.
There's always another killer pig.
Vice. And he calculated, right, between Chauvin,
It's a sad day in America.
Officer King, pushing down on him approximately 90 pounds of force. And the position and the force combined such that it was as if George Floyd's left lung had been surgically removed. That's how much of a reduction of air capacity there was here. To the point that Mr. Floyd was desperately trying to make space to breathe.
I don't think Minnesota is a capital punishment
Space
state.
against the pavement to lift up, to give space to breathe. His lung capacity, based on Dr. Tobin's calculation, had just being in the prone position, even though you heard some studies from the defense saying, you know, the prone
And I think if it
position
was a
is
capital case,
dangerous.
we'd already know.
Dr. Tobin disagreed. He said that the lung capacity was reduced by 24% just by the prone position, 43% when you consider the additional pressure.
Yeah, death penalty has been abolished in Minnesota since
Corroborates
1911
Police training. And what the police have
after a
known
botched
for 30 years.
execution.
That there's a danger to the prone position, and the danger is positional asphyxia. And the danger, the worst thing that can happen with positional asphyxia is death.
Yeah, you're correct about that, Curiouser.
And it wasn't just the lungs, the pressing up against the neck. Remember when you touched that it reduced the capacity of airflow.
So I said on Friday night stream, like the party lights were missing because it's not a party in the USA right now.
Right? These shallow breaths did not produce enough oxygen. Not enough oxygen could get to the lungs. And that's what killed George Floyd. And here's what didn't, right? Here's what didn't. This wasn't a sudden cardiac arrhythmia, right? Dr. Smock told you that. Dr. Thomas, Dr. Rich, Dr. Tobin, they agree. Not a sudden cardiac arrhythmia. That's not how this looks. Dr. Baker, no medical evidence of a heart attack. Right? We heard from Dr. Rich. Dr. Rich actually treats people who have heart attacks.
I will never underestimate their ability to fuck things up.
In his review, nothing in George Floyd's heart.
I don't think nothing is going to let up.
originated from the heart.
And honestly, if this pig walks, I think that like,
You know,
what that
of
ignites,
course of this case,
I'm not looking forward to.
That didn't happen, and
I think it's going to be a long, hot summer
right, you know why George Floyd died.
coming out of our dark winter here.
You heard a lot about drugs. You heard about his struggle with addiction. There's some things, George Floyd was obviously not a perfect man.
Shit's already popping off, and it's not even 420 yet.
Right? So you heard about drugs, some pills in the car, in the squad car, in his car. You heard questions about, is he chewing gum? Does he have a pill in his mouth based on this free? None of that matters. Because you know what his level, the drug level was. You know that from the toxicology report. If drugs are found
Trace
in the
amounts.
car, they're not in George Floyd's system. So there's no point in talking about those. Right? Let's talk about what was in his system and the toxicology report. And you heard
Bicycle
from
day.
Dr. Eisenschmidt, right? And what he testified was that
It's 419. It's like one of the most infamous days in all of history.
well below the ratio.
I don't know about bicycle day.
Who die from a fentanyl overdose. It's even below the median. And George Floyd's
If I'm not mistaken, it's like Hitler's birthday, Columbine,
then the group
our invasion of Grenada or some shit. Like, I mean, it's like a long list of shit has happened on 419.
they've treated patients who are under the influence of both
Bicycle would be pleasant.
methamphetamine, and they testified these drugs did not kill George Floyd. They didn't. We know that he had a tolerance because he used.
Also, happy birthday to
and the experts all agree.
one of my former
George
colleagues,
Floyd
Molly
did
Mayhem.
not die the way someone who dies from a fentanyl overdose dies. His breathing, it didn't slow down. Right? He didn't fall asleep. He didn't go into a coma. No. This looked nothing like a fatal fentanyl overdose. Dr. Tobin
Oh, I'm sorry. Hitler was born on April 20th.
calculated George Floyd's respiratory rate, and the best doctor to do so, given his training and given his experience, right, he stated that the fentanyl in George Floyd's system did not depress his respiration. It didn't. He did not die of a drug overdose. That's
The
not
19th is the
Didn't die
day
of
of the
excitement.
Oklahoma City bombing, the Waco assault,
right. Dr. Smock
the Warsaw Ghetto
testified about excited
Uprising,
delirium, told you, explained to you, he didn't.
the date The Simpsons launched, and the Boston Marathon bombing.
One of which
Oh,
being
no, I'm sorry, not the Boston Marathon bombing.
nonsense. There's no superhuman strength.
The Boston Marathon itself,
No
not the bombing.
superhumans. Right? Impervious to pain. Nonsense.
Anniversary of LSD,
You
cool.
heard him. You saw him.
And that has been today in history on the Troll
He was
Patrol.
not impervious to pain. It's nonsense. Paraganglioma. Suggestion that this tumor, which is literally called an incidental tumor, relatively rare, maybe causes headaches, that caused his death at that particular moment in time, at that place, after the restraint, after the subdual, after the 9 minutes and 29 seconds, the tumor that causes headaches, that killed him? No. That's just a story. And Dr. Rich specifically testified that he looked in George Floyd's medical records and he did not find references to headaches. And you heard about carbon monoxide. The car killed him. Well, Dr. Tobin came back.
Well, if the car killed him, that's still the cop's fault.
Which had a catalytic converter that was outside, that was a hybrid, and there's no evidence was even on. Right? that did not kill him. Right? He explained carbon monoxide saturation level, oxygen saturation level. And based on his calculation of oxygen saturation level at 98%, right, at most there could have been a 2% carbon monoxide, same as anybody else.
Now, I will say, I feel sorry for this prosecutor.
Talking, breathing.
Like the pressure this man is under. Ooh,
That's just a story.
I would not want his
Something
job.
wrong.
Maybe feeling sorry is not the
don't have to
word.
be
I'm not envious of his
Dr. Chauvin
position.
To recognize this. It's probably nice to be Dr. Tobin, but you don't have to be Dr. Tobin to recognize this. You can see this with your own eyes. You could see what happened, that he couldn't breathe. He said he couldn't breathe. The defendant was on top of him, on his back, on his neck, with his knees pressing down. Of course. You saw how his body just sort of deflated into the ground, past the point of consciousness. There were multiple moments in time, ladies and gentlemen, multiple moments in time that things could have gone different, and George Floyd would have lived. CPR. If they would have left him in the side recovery position in the first place, or just placed him in the side recovery position shortly after the restraint, he wouldn't have died. Their own force witness testified that putting somebody in the side recovery position is pretty fast, pretty easy thing to do, not complicated. No. Professor Stoughton said you just rotate them 90 degrees, quick. Could have done that. Relieve the pressure. Could have done CPR, chest compressions. Was supposed to, had a policy he was supposed to follow. Right? A duty to provide medical aid. You're not just supposed to phone that in. You're actually supposed to use your training, provide the medical aid. Even Dr. Fowler was critical. No one starting CPR. Said that should have been done. Defendant knew how to do it. He had the training. He knew better. He just didn't do better. George Floyd didn't have to die that day. Shouldn't have died that day. But for the fact the defendant decided not to get up and not to let up, George Floyd died. And these actions were a substantial factor in George Floyd's death. And these actions, make no mistake, these actions were not policing. These actions were an assault. So, as the judge instructed you, for second-degree murder, and it's actually very simple, if you find that the defendant committed this third-degree assault, while committing the assault, he caused George Floyd's death, defendant's guilty of murder. That's the way felony murder works in Minnesota. So there are two elements. Right? That the defendant assaulted George Floyd. And what does that mean? Assault is the intentional infliction of bodily harm upon another, or the attempt to do so. Intentional infliction of bodily harm, that requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that the act resulted in bodily harm. Okay? Intentional. He did it on purpose. He did the thing on purpose. Bodily harm, physical pain, illness, or impairment of a person's physical condition. So again, to be very, very clear, the state does not have to prove that the defendant had an intent to kill George Floyd. This was an intentional act that you see before you. He did this on purpose. And that's clear. He didn't, again, trip and fall and find himself there. And this was also unlawful force. Officers are only authorized by law to use reasonable force. And this was not reasonable force, as I'll explain. And George Floyd clearly did not consent to having the defendant's knee on top of him for 9 minutes and 29 seconds. When you hear someone gasping for breath, calling for their mother, begging you to get off, what How could you think anything else? That he did not consent to this. Now, the state does not have to prove what we don't have to prove about intent. We don't have to show that the defendant intended to cause George Floyd harm. We don't have to show that. You don't need to find that the defendant was trying to cause harm or had the purpose to cause harm to conclude that this was an assault. You do not. The state doesn't have to show that the defendant intended to violate the law. We don't have to show that. We don't have to show that the defendant intended to kill him. The only thing that the only thing about defendant's intent that we have to prove is that he applied force to George.
Me too, residue. Me too.
This wasn't an accident, and it's pretty simple. You know, if you're doing something that hurts somebody, and you know it, and you keep doing
Clap
it,
your hands.
you're doing it on purpose.
Hey, breathe. Breathe, anybody. I can breathe here.
Somebody's telling you they can't breathe, and you keep doing it, you're doing it on purpose. What else is going to happen when you push somebody down on the pavement? Everybody knows this. Everybody knows what happens when you push somebody against the pavement. Right? You learn this pretty early on.
Wow. Look at the abrasions on his
Learn this pretty
face.
early on.
Oh my God.
Assault in the third degree requires that the defendant inflicted substantial bodily harm on George Floyd. Right? Substantial bodily harm meaning a temporary but substantial loss or impairment of the function of a bodily member or organ. Organs, the lungs, the heart. Temporary loss of consciousness qualifies as substantial bodily harm. Certainly a permanent loss of consciousness would constitute substantial bodily harm. You'd look at this point in the restraint.
I had someone on the comment
You see
section
the
said his knee
absolute
wasn't on his neck. I'm like, what the fuck? Here's the picture. Look at it. Where's his knee?
He's unconscious. He's lost consciousness. That's substantial bodily harm. He did that. That's
But I don't know that right wingers even believe the shit that they say.
So when you consider the charge of second-degree murder, try to break it down into parts and find an order. The defendant caused George Floyd's death. He did. The state proved that beyond a reasonable doubt. And at the time of causing the death, the defendant committed or was attempting an assault in the third degree. And that's been proved beyond a reasonable doubt. With those being proved in the venue, right, second degree felony murder, the defendant is guilty.
Uh-huh.
So going back and talking about murder in the third degree, you can see that there's some elements in common. Right? There's some differences. We've already discussed the first element, the death of George Floyd, the substantial causal factor with the second element, and then the fifth element about the venue element, I'll call it, May 25, 2020 in Hennepin County. So for third degree murder, the difference for third degree murder is that the defendant had to cause George Floyd's death by committing an act that was eminently dangerous and performed without regard for human life.
That's
Again,
that's
the state is
policing
not
in
required
general.
for this charge either to show that the defendant intended to kill George Floyd, that he committed an act that was eminently dangerous and performed without regard for human life. And it must prove, the state must prove that the act was highly likely to cause death, that the defendant acted with a reckless disregard for human life, that he was consciously indifferent to loss of life that his actions could cause. The defendant's act was eminently dangerous to others. It was likely to cause death to Mr. Floyd. And as if common sense in and of itself would not suffice, the dangers of prone restraint of positional asphyxia has been known in the law enforcement community for about 30 years. Right? This is known. If common sense wasn't enough. Defendant's own use of force witness admits that. And again, when we talk about danger, what is the danger? What's a potential danger of positional asphyxia? It's death. Right? The medical experts who know a few things, who know a thing or two, right? Dr. Tobin, Dr. Smock, Dr. Rich, they agreed. Right? The defendant's actions created a high risk of death. And the defendant consciously disregarded the loss of life that his actions could cause and did cause. He knew the risks of positional asphyxia due to this position. Everybody in law enforcement knows that, but he had other warnings, not just from his training. He had other warnings from people.
He's not even resisting arrest right now, bro.
Pass out.
That's what happens to him. He's breathing right now, bro. You think that's cool? You think that's cool, though, right? What's your badge number, bro? You think that's cool right now, bro?
Look at the concern on the bystander's face. All of them.
That's cool, though, bro. You're a bum, bro. You're a bum for that. You're a bum for that, bro.
You damn right he's a bum.
Stopping his breathing right now. The dude's about to go out right now, bro.
Right. It was plain and apparent to everyone who was there what was happening.
It was plain and apparent to all of us who have seen the fucking video.
He's not talking. What are you doing? Now we know that the defendant chose not to listen to bystanders, not to these bystanders, but how about to fellow officers on the scene?
Roll him on the side.
Roll him on his side, staying put where we got him. That's what the defendant said. He's staying put where we got him.
For what reason? What was...
Every position. He could have listened to the bystanders. He could have listened to fellow officers. He could have listened to his own training. He knew better. He just didn't do better. He knew...
No, I can't.
His neck, in addition to the positional asphyxia, just the pressure, is dangerous.
And I will be gobsmacked if this motherfucker walks with all this evidence.
Conscious indifference? Indifference?
I don't know what's going through his head. Once again, he wanted to plead guilty. He was rejected by William Barr in the Justice Department last summer. So he knows he's guilty.
My stomach hurts. My neck hurts. Everything hurts. There's water or something. Please.
Even if he walks in this case, he's still facing 20 years? Tens of thousands of dollars in tax fraud.
Takes a heck of a lot of oxygen to...
Come on, man.
Indifference. Leisurely picking rocks out of the tire. Commenting about the smell of the man's feet, who you're pressing down, grinding on, as his voice slows and fades.
There was somebody on the internet pointed out
I can't
his
breathe.
his sunglasses stayed on his head the whole 9.5 minutes.
My neck
How is George Floyd resisting if the motherfucker's sunglasses stay on top of his head the entire time?
Indifference.
I would think if he does go to prison, they're probably going to
medical attention.
put him somewhere special for his own safety, because I don't think he would last long.
Decision, the failure to give CPR, not even Dr. Fowler. This isn't protection. This isn't courage. And it certainly is not and was not compassion. It was the opposite of that. So back to the instructions.
This is a state trial. He will be in a state facility.
When you're deliberating, ask yourselves, did the defendant cause the death of George Floyd by an intentional.
But then again, a fucking killer cop probably gets in with the Nazis once he's in prison.
Absolutely.
And they protect him.
The state proved that. Did the defendant act with a mental state consisting of reckless disregard for human life, a conscious indifference to the loss of life that the eminently dangerous act could cause? Yes, he did. And you will find, based on that the state has proved the defendant is guilty of third-degree murder as charged.
I wonder why they would be so violent in prison. Oh, absolutely, they should have to face the prison system.
Manslaughter in the second degree, and again, you can see that there's.
Oh, I'm with you. I'm just stating what's probably going to happen.
Third is in common with the other charges. So what's different about manslaughter in the second degree is that the defendant caused the death of George Floyd by culpable negligence. Culpable negligence, where.
And if they did want to make special arrangements for him, for his safety, how about solitary confinement?
And again,
just like Kim Potter in.
That he intended to.
I was trying to think of the area. It's Minnesota. It's right down the street from where we're watching right now. Kim Potter's house surrounded by fucking barricades. If she needed special protection, they should have denied her bail and put her in solitary confinement for her own protection.
Recognize as involving a strong probability of injuries to others. You can look for yourself.
Well, if it's just a facility for cops and pedos, you're taking them away from the rest of the population who would deal with the cops and pedos in the proper manner.
They took video. You saw it. It was plain to you. Strong probability.
Killer cops and pedos are the two groups that I don't think do very well inside of prisons. But once again, a cop could join up with the Nazis and probably get protection.
There's a strong probability of injury. He knew that too. Great bodily harm, bodily injury that creates a high probability of death.
Here comes Maynard.
Permanent or protracted.
I love it. He ducked down so that he wouldn't be on camera, but just his tail went by. What, did you not? Are you shy?
Lungs. The loss of consciousness. Would an ordinary and reasonably prudent person know that this is dangerous? Everybody who watched knew it was dangerous.
Yes!
The 10-year-old saw that it was dangerous. And the defendant knew exactly what he was doing because he was right on top. He was right on top of him. But his negligence goes beyond his intentional assault of Mr. Floyd. His negligence includes his failure to act. In your custody.
Yep.
Means in your care. In your custody means in your care. There is a duty to provide medical assistance. That duty includes not only calling the ambulance for somebody else to do.
Well, technically, the courts have ruled that the cops have no duty to protect
As
you.
a first responder, you're required to perform CPR.
That's actually a pretty bad argument.
It's a requirement. He failed to do it. He had the training. He knew how to do it. You've seen his training records. It's Exhibit 119. You can take a look at all of the in-services, all of the hours. Okay? He knew what to do. He just didn't do it. He knew better. He didn't do better. He wouldn't even let Genevieve Hansen, the off-duty firefighter, do it. If he wasn't going to do it himself, he would let somebody else do it. But he didn't. He had the knowledge, he had the tools, he just ignored it. So when you consider this charge, that the defendant caused George Floyd's death by culpable negligence, where he took an unreasonable risk.
Just in case you guys think I'm lying on this, the Supreme Court has ruled police do not have a constitutional duty to protect
beyond a
someone.
reasonable doubt.
They have affirmed it in multiple cases.
Second-degree manslaughter, guilty of
The police aren't there to protect you.
So after all of this, you have another question you have to address. After seeing all of this, finding the assault, finding the murder was committed, the manslaughter was committed, You have another.
So I ask, why do we even have police? If they have no duty to protect us.
Was this fine? Is this okay? Because the defendant was a police officer?
They're protected from
authorized use
civil liability.
Was it justified? Was it justified?
That means we have an unregulated gang
Let's look at the instruction.
with unlimited power.
The degree of force a police officer may lawfully use in executing.
That
his
is
duties.
not what the founders
What a
intended.
reasonable police officer in the same situation would believe to be necessary, and force beyond that is just not reasonable. You look at the facts that a reasonable police officer in the same situation would have known at the precise moment that the officer acted with force. Right? You're looking at all of the totality of the facts and circumstances to see whether these actions, the defendant's actions, were objectively reasonable. Was this objectively reasonable? No. We just saw
No.
the instruction that the law does not provide
Municipal revenue mafia hitmen.
for police abuse. It does not. Let's start with the most basic of premises.
To serve and protect is written on lots of their
Restraining
cars.
George Floyd in this manner. On the ground, prone, handcuffed, knee on the neck, knee on the back, body weight on top of him. Start with the premise that that, in fact, was a use of force. The defense called a witness who actually testified that that was not a use of force because that is not likely to produce pain. No.
What?
No. Not true. Likely to
What an
produce
idiot.
pain, actually produced pain. You know, the problem with terms like superhuman strength, you forget that those people don't exist. Humans feel pain. Human beings feel pain. Human beings need to breathe. Don't accept.
I mean, technically their purpose was to round up
You
slaves.
need to reject
Remember,
that testimony. You need
at least
to
in the
reject
South.
And let's discuss the standard. What would a reasonable police officer do?
And a lot of people
Police officer do. You
don't realize this,
George
but
Floyd's perspective.
after the civil rights movement through the 70s and
You
80s,
don't look at it from
lots of police departments, especially the LAPD, hired cops from Alabama to come in and train their cops.
You look at it from the perspective of a reasonable
100% truth. I swear to you.
has shown over and over that the defendant is not that officer because he did not act as a reasonable officer would. Remember Charles McMillan? Right. Well, the defendant explained his actions. He explained the basis of his actions to Charles McMillan. You recall that. Here's what he said.
Yeah, and I tried to get in the car. Looks like he's probably on something.
That was his justification for using this level of force. He's a big guy. He's a sizable guy. He might be on something. We have to control him. Control is the restraint. So that's the force.
Or he might be having a goddamn panic attack because you guys fucking rolled up with guns in his face.
That he might be.
He probably didn't even know. If it was a counterfeit 20, he probably didn't fucking know. People pass off counterfeit bills all the time. It's incredibly common.
To use force to respond to a threat. They're not authorized to use force to respond.
Usually stores don't even look at 20s, it's 50s and 100s they actually look at.
Potential risk. Big, small, in between.
Yes, that actually happened.
Not everybody's a threat. Being large,
And we wonder why the Rodney King riots happened.
It's not a crime. It's not a risk. Sorry, it's not a threat. It's merely a risk. Being on something. It's not a threat. It may be a risk.
You damn right you don't need to die for it, and you definitely don't need to have guns pointed in your face over it.
Merely because they're on something.
From the moment they got on the scene.
Their force expert, witness, conceded that the combination of the two
That's why I've repeated it over and over again. That it is a violation of Fourth and Fifth Amendment rights.
It just isn't. That's not what they get to do. Right? So the defendant's entire basis.
I think the verdict will be a hung jury or guilty. I think there is absolutely zero chance of a not guilty verdict.
And tossed him onto that gurney and walked away like it was nothing.
Oh, Chauvin is guilty. I mean, he is guilty of murder. There's no
Good enough.
finding it, like just stating facts. He's guilty of murder.
It's not the use of force policy. Is not following the rules.
A hung jury is when, like, one of it. See, a jury has to come to a unanimous decision. They all have to say guilty, or they all have to say not guilty. So if 8 of them say guilty, and one of them goes, I don't think he's guilty, that's a hung jury. And they can't. If they can't, they'll deliberate and they'll keep trying to resolve it.
Resisting, he just wasn't able to comply. They should have recognized that. They should have.
But I want to bring it up. The Fourth Amendment of the United States Constitution.
They had plenty of resources. They had 4
The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. Now, does a supposed counterfeit 20 warrant him having guns pointed at him?
Compliance.
It does not. I think that was a violation of his Fourth Amendment right.
Pain. Not a reasonable use of force. And that's not authorized by the Minneapolis Police Department. Kneeling on top of someone, on their neck and their back, effectively they were using a maximal restraint technique. Effectively. Remember the
Fifth Amendment says no person shall be held to answer for a capital or otherwise infamous crime unless a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any crime case to be a witness against himself. Nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation.
Talked about that. So they just held him.
George Floyd had his Fourth and Fifth Amendment rights violated.
A reasonable officer wouldn't do that. A reasonable officer follows the rules. A reasonable officer follows the training.
So anyone that is not upset about what Derek Chauvin did doesn't believe in the fucking Constitution.
The defense tactics and control guide. Like, deadly force is just not authorized in this situation. No force. When someone is...
Well, if Crowder is saying they teach cops to do that, then he's directly going against what the testimony that we've heard here in the trial, and Steven Crowder is a dumb fuck. But hey, we knew that already. Right-wingers are morons.
Charles McMillan, he kept saying...
We watched the video of Steven having somebody kneel on the back of his neck. Dumb fuck.
I can't.
He had the dude like kind of like sitting on his shoulder blades. He's like, look at me, this isn't a big deal. I'm Steven Crowder.
At least an attempt to comply. Force must be reasonable. It must be reasonable at the point it starts, at the point it ends, and all points in between. Officers are required to reassess the situation, to reevaluate the situation, to take in the information. And
yes, the cops should be held accountable for their actions, but they should be held to a higher standard.
The defense has made the argument that the crowd justified defendant's use of force, like the blame should fall on the bystanders.
Cops should get double whatever the mandatory minimum is, whatever a civilian is facing.
What? But this was a distraction.
They'll declare a hung jury and it's a mistrial, and they'll have to have another trial.
Too concerned. It wasn't the bystander's fault. A 19-year police veteran, a field training officer.
That would be the worst thing for the country. Declaring a mistrial, there had to be another trial. And we do this all again fucking 4 or 5 months from
There's a
now.
policy about
Oh, God.
They understand that civilians can film them. Like, they know that. It's right there. This isn't something new or earth-shattering or even particularly noteworthy. Sergeant Steiger.
But I don't...
Call him from LA.
The idea that it's going to be a hung jury is also...
On Skid Row,
They've got 3 different charges.
rocks and bottles.
They don't have to return a verdict on... You know, they can do not guilty on murder 2, murder 3. They can return guilty on manslaughter.
For an assault, for murder.
So that might be likely.
Defense suggested in their cross-examination.
So there's a pool of like 100, 150 people that will be called for jury. Like, people are constantly called for jury duty. If you're called for jury duty, you're not going to know exactly what the case is that you're going to be on. You're just like a pool of people at a courthouse.
The testimony as a whole.
So they did jury selection. That's the first thing you do in a trial. And the defense and the prosecution all get so many strikes, they call it. So they'll question potential jurors, and the prosecution can strike them. The defense can strike them. They both agree. They go and they be on the jury pool.
Violated his duty of care. He failed to render aid. Remember, Commander, now Inspector Katie Blackwell,
a jury of 9
was in charge of all training.
And then they have like 3 alternates.
I don't even know what this is.
So it's like 12 altogether, I think.
Is. This isn't how they train.
And then the alternates are used if one of the jurors gets sick or something.
Lieutenant Mercil looked at this, and he said,
welcome to everyone that is joining in on the stream.
An MPD
we are about an hour and a half deep into the prosecution's closing arguments.
You can present 1,000 hypothetical situations. You can talk about what...
Yeah, it's 9, and then I think it's 3 alternates.
But when you talk about what did happen on that day, at that time, that's what they said. Use of force, unreasonable. Supervisor, Sergeant Pluger. The force should have ended right after Mr. Floyd was on the ground.
Lex Pluger! It's a total package. Sorry.
Lieutenant...
I'll try not to be too flippant about things. This is a very serious matter.
The most years of service on the Minneapolis Police Department, longest serving member of the department. What did he say? He looked at this.
This is all a bad reality show.
Totally unnecessary. A use of deadly force. Not reasonable. Only reasonable force is
they're finding any reason they can to justify it.
Expert witness.
But once again, right-wingers don't believe in the rule of law or democracy or anything like that. They say they do. They don't.
This is objective.
They believe in hierarchies.
Unreasonable force. Professor Stoughton.
And to them, the cop has a certain place on the hierarchy, and everybody below that cop has to do exactly what the cop's told.
Law school professor.
That's the mindset of these dumb fuck right-wingers.
It was disproportionate, and it violates national standards. The experts agree. Because the force has to be reasonable when it starts.
Well, he should have just complied. Well, we watched video of him complying.
What is happening? If you look at the bottom, George Floyd is handcuffed and on the ground. Right? What is
class system justice indeed?
I can't breathe 27 times within the first 4 minutes and 45 seconds.
Fascist as fuck. But they don't know what fascism is. They think fascism is Facebook banning them for violating terms of service.
George Floyd says, into the restraint at 8:22:24. My stomach hurts, my neck hurts, everything hurts. Defendant heard that. He heard those words. Was George Floyd resisting?
Says, I can't breathe 27 times.
No. And the defendant heard it, and he acknowledged it, and all he did was mock him.
And that's just, I encourage you guys, if you argue over these matters, always frame it as constitutional to the right-wingers.
It takes a lot of oxygen.
How is George Floyd's 4th and 5th Amendment rights not violated?
Gave his final...
I thought you hated the state, bootlickers.
Defendant, please, I can't breathe. I can't breathe. Crying out for help by the man in uniform. The defendant stayed right on top of him, ignored it. continued doing what he was doing, facing the crowd, grinding his knee, twisting his hand. I think he's passing out, Officer Lane says. Officer King can't find a pulse. Now, the greatest skeptic
And still, Chauvin's still on his neck.
among you.
Yes, some people shouldn't be cops, and that's everybody. Nobody should be cops. There should be no cops whatsoever.
This man,
I don't actually believe that. We need some sort of police force. However, our actual policing system must be abolished, and we must start from the ground up.
pushing him down and crushing
I can
him
show you evidence
out of him. It wasn't too
of where that's what it takes. You have to completely fire all the cops,
past the point,
rehire them again.
past the point where the ambulance arrives. Past
I think
the
it was
point where
Camden,
he
New
takes
Jersey.
out of the ambulance. What's the goal? What's the plan here?
Wild. Don't even talk about RoboCop now. There's an uproar over the police dogs in New York City,
Allegedly.
talking about how it's RoboCop-esque.
What is going on? Why hold him that long past that?
We need some sort of
crossed. Oh,
we
unreasonable.
need some sort of enforcement that enforces court orders. Yes.
Not proportional, excessive. It
Oh, there's a
violated
Smokey.
policy. It violated the law. It violated everything
But we definitely need to move to a system of
it stood for.
no more traffic stops at all. All of that needs to be automated.
Awful but lawful. Right? But force that is not
What we have right now is just organized pedophile rings and drug traffickers. All cops are bastards. They're all fucking dirty. Look up Boston child molestation
guilty
cover up.
second degree.
Look up Louisville Police Department child rape. Google
Because
it
this was
right
not
now if you don't believe me.
You cannot justify this use of force. It's impossible. Not if you apply the rules. Not if
You can't justify the existence of police departments that do things like cover up child molestation like they did in Boston.
that oath that they take.
The dude was an official in the police union.
You know, at the beginning of my comments, I talked about
Serpico tried to tell us.
surrounded by people who cared about him.
And then Charlie Day tried to fucking pull a Serpico 20 years ago.
That at his death, he was surrounded.
How about that spin doctor's mix, Mar?
They were strangers, but you can't say they didn't care. You can't say that. These people were randomly chosen from the community. People from the community randomly chosen by fate. And they were coming from different places, and they were going to different places, and they had different purposes. All of them. Random members of the community. All converged by fate at one single moment in time to witness something. To witness 9 minutes and 29 seconds of shocking
So do your stamps and your keys come in a cup too?
of authority. To watch a man
Also, were you being facetious when you said everything comes in a cup?
because
You
they
never
were
answered that for me.
powerless. They were utterly powerless because even they respected the badge. Even seeing this happening, they cried out at first, pointed out, hey, you can get up off him. It became more and more desperate as they watched this go on and on and on, and there was nothing they could do. All they could do was watch and gather what they could.
The stamps and the keys and everything too come in a cup?
Thoughts and impressions. Gather those precious recordings. And they gathered those up and they brought them here. And they got up on the stand and
I can't tell if you're fucking with me or not.
to what they saw. They bore witness to this outrageous act.
I know there's not a Cup Foods where you're
What
at,
they had.
but I also know you've been out west and could have actually stopped at a Cup
Recordings,
Foods.
So you can see this. You can see this from every single angle. They gave that to you. They were powerless to do anything but that.
Seems like a good concept.
They gave it to you. randomly selected people from the community. You got a summons in the mail. And here
I
you
don't know. Why do I call my show the Troll Patrol when it's a news rundown?
Now, our system, we have power. The power actually belongs to us, the people. And we,
So they do, like it is like known for their ramen.
for us to hold and to use appropriately. But sometimes we take it back. Sometimes when something is really important, we reserve those decisions for ourselves. The state,
It makes total sense. So why hasn't the concept caught on and cup foods a thing nationwide?
but he cannot.
It seems like a really good idea.
That power belongs to you. You have that power, and only you have the power to convict the defendant of these crimes, and in so doing,
I mean, Sheets puts everything in a cup. They're kind of like the East Coast.
was unreasonable. It was excessive. It was grossly disproportionate. It is not an excuse for the shocking abuse that you saw with your own eyes. And you can believe your own eyes. This case is exactly what you thought when you saw it first. When you saw that video, it is exactly that. You can believe your eyes. It's exactly what you believed. It's exactly what you saw with your eyes. It's exactly what you knew. It's what you felt in your gut. It's what you now know in your heart. This wasn't policing. This was murder. The defendant is guilty of all 3 counts. All of them.
So you've been lying to me the whole time.
And
Fuck.
there's no excuse. Thank you.
Oh, that was it. I thought it sounded like he was getting ready to bring it on home. I figured he would end with just the video.
Take a 20-minute break, and just for your information, we'll also take a 20-minute break after the defense argument, before the state's rebuttal and the final instructions.
Okay, so I was wrong about them breaking for lunch. We're only going to get
the
a
trial of Derek Chauvin.
20-minute
After
break.
Millions marched in the name of George Floyd.
So we'll keep
Today
it
is
right
the day
here.
That George Floyd's death will be put into the jury's hands, and whether or not Derek Chauvin is found guilty, he's being charged on 3 different counts, and we'll go through all of those.
Yeah, what the fuck's name is King Super?
Libby Casey. With me now, Rhonda Colvin.
But then again, you like
Scott.
where you're from. There's a store called
Beth
Badcocks.
Albright with us. Let's go first to you, Rhonda. You know, so many powerful.
I, as a man of refined taste,
Rap.
only
I want
accept
you
good cock or
to
higher.
Bring out for us what stands out the most to
No
you.
bad cocks
What
around
is
here.
Prosecutor Steve Schlescher most hoping sticks in this jury's minds?
I think it's that ending right there. He, of course, spent most of his time going through the charges and how each one was proven.
I did like his
It was
ending.
really that ending that took everybody back.
Believe
to
your
that
eyes.
stage and the
Believe your
eyewitnesses
eyes.
that we met. And he said that these people were members of the community who were randomly selected to witness this and bring you this evidence. And I think by showing their pictures.
Overall, I think the prosecution did a really good
them alive
job
on the scene, and the group of them
presenting their
together,
closing argument.
brought it all back around to that first week, those emotional testimonies where each person.
I didn't
said
like
in
his
ways
sucking up to cops, but
and that you could see the trauma that they went through of
I
sitting
understand
on the
why he did
sidewalk,
it.
knowing something was wrong.
I do not believe his
having the
statement
ability to
about
stop it
cops
while
was
it's
correct
happening.
in
So he
any
brought
way.
that back around, that emotion that really captivated that courtroom, as we've learned when we've talked to Holly Bailey, our reporter who's been in the pool rotation in the courtroom. That emotion from that first week was very present among jurors and those hearing those testimonies. So that was potentially a very effective end to this first closing argument that we've heard. But as I said, the prosecutor did discuss.
So currently on a
how they
20-minute
prove
recess.
their case, how they feel
Probably
each
that's
charge,
give or take a few
they
minutes.
laid out with their expert testimonies and their 38
As I know,
witnesses that they
courtrooms.
called.
Probably going to be
One
about
of
a
the things that
30-minute
stood out to me
recess.
as well is he started off by humanizing Floyd. He talked about how he had a family, that they all met his brother, Philonis, who testified last week. And he also talked about how George Floyd did not have this so-called superhuman strength. He needed oxygen just like all of us.
And just I don't know if you guys know this, but George Floyd's girlfriend who testified during this trial was one of Dante Wright's teachers.
He said a few times that this is not about the state against the police.
And how shitty would it be if it came out that both of them ate food served by Philando Castile?
And he even said, Schlescher said, this is...
Because that happened just minutes from where this trial was taking place.
We don't want this one individual, this one bad actor, to represent all of policing. So those were some of the points that he made that stood out to me.
Yes, George Floyd's girlfriend was a teacher.
A point that Rhonda made that we heard a couple of times.
Or a teacher's aide, or some member of the administration at one of the schools Dante Wright attended.
Right, and this risk. And that really hits directly, Eugene, into this sort of...
Also, Minnesota had another cop-involved shooting yesterday, but apparently it was an armed robber
was out of control.
Who actually really probably did deserve to die because he was firing at people.
And really deserved being met with a strong force, Eugene. Talk to us more about that.
Right. We saw Steve here really trying to humanize George Floyd and, point to video showing that he was not this large, out-of-control individual.
I guess that is promising, but there's just the fact that the state...
But was a human being with challenges and...
I don't know who put up the barriers around Potter's house. I would assume it had something to do with the local government there.
Or not, he would have even been...
The county put up a barrier, because I don't think you can just get those barriers that easily.
To him in the way that Chauvin responded to.
If the government put up those barriers around...
that the prosecution is trying to make.
Accused cop, that's just
down on these witnesses.
That just shows the double standard we have.
Show who Floyd was.
Now, if it was a bunch of yahoos from the neighborhood,
jurors can know that
throwing in money to buy, but where do you buy cement barricades like that? You buy them from the local government, right?
He was responding to a human being who was in need of more help than he received, and that society had given him in general, considering all.
In case you guys don't know what I'm talking about, let me find the picture here.
James, the prosecutors really having the jury put themselves in the shoes of a lot of different people here. Number one, George Floyd. Number two, his family. Number three, those bystanders, and to connect the helplessness that those bystanders...
These are the barricades around Kim Potter's house, the officer who killed Dante Wright.
Evidence has now been turned over to the jury.
These cement barricades with fencing.
That was pretty compelling.
Apparently, there are other cops who are protecting the house.
He ended with talking about the bystanders because he knows that Eric Nelson, when he gets up after this break, is going to say...
I understand. I understand we're moving forward and everything, but I look back on it and I'm like, and this is looking at my grandfather's generation and shit. How the fuck did you guys believe this shit?
Derek Chauvin standing there with the...
How in the world did this ever happen?
Him say, this is not clearly intimidating to him.
This is not the only charge that Chauvin's facing. He is also facing charges of tax fraud in the tens of thousands. He's not going to be a free man.
So he tries to get out front of that argument.
Even on the slim chance that he is found not guilty in this case, he'll move on to the trial for the tax fraud, and he will go to jail because
on the ground.
Uncle Sam don't play about shit like that.
We saw the picture that we saw from the testimony early last week from his brother, George Floyd's brother. And one of the things that makes the Minnesota legal system unique is that they actually have something called the spark of life doctrine. And in most states, it's not relevant who the person was that died, but Minnesota actually uniquely encourages and allows prosecutors to humanize the victims. And I was really struck. I thought the underlying through line of that whole speech was about making George Floyd into a human being, and to what you were talking about, Libby, with Eugene, pushing back on this idea that he was superhuman strength and saying, no, he was human. George Floyd wasn't.
Yeah, it is going to be interesting to see exactly what the defense says in response to this.
And that really seem
The prosecution has done a great job of cutting off all the arguments they're making preemptively.
Presentation is making George Floyd's humanity central.
Let's go now to outside the courthouse where our national reporter Hannah Jewell is taking in the scene there. Hannah, what is it like in Minneapolis today?
Tense.
Well, as Rhonda
Tense
just
as fuck.
mentioned, Libby, the prosecution was careful to say this case is not called the state of Minnesota versus the police. It's the state of Minnesota versus Derek Chauvin. But certainly outside, you can see how it is a bigger case than that to the people who have gathered here to watch. And to that end, we actually saw earlier the Reverend Al Sharpton with Attorney Ben Crump and the family of George Floyd. They walked up in a procession to the courthouse with their fists raised in the air and went into the courthouse, and we're expecting them shortly to come and speak to us, perhaps on a lunch break, to hold a press conference, and we expect the Reverend to lead those families in a prayer, including with the mother or the family of Daunte Wright, as we heard in press conference similarly last week. We saw very emotional these families coming together between the Floyds and the Wrights, showing how to them this is obviously not a case of one police officer or one man, but a much bigger problem with policing in America. And I've been speaking to many of the protesters out here. There's not too many of them, and it seems that their opinions are split on what they think will happen. Some were very convinced that Derek Chauvin will be acquitted, and a man just said to me that he basically said cops don't get convicted, and he was so convinced that Chauvin would not be found guilty. But another young man who was much younger than that man said that of course he will. He's been watching the entire trial and cannot imagine what will happen if not. I spoke to another woman who is very afraid, who said she could imagine that he would be found innocent or a mistrial, and that
yes, the prosecution gets the last word.
What signal that would send to police that in a case with all this video footage, that if Chauvin could not be found guilty in that case, it terrifies.
I always thought that it was
reporting live outside
the prosecution goes first throughout the trial,
James, I want to continue
and then I thought it was flipped during closing arguments.
The relationship to the police, and
that the defense went first in closing arguments and the prosecution goes last. That's the way I always thought it was laid out. This could be just a Minnesota thing that they do, because I've never heard of a rebuttal before in closing arguments.
From what Derek
I could be wrong with. Maybe where I'm from Kentucky, when I was doing news, maybe they're doing it the odd way and everybody else does it this way.
Witnessed this called the police. That a 9-year-old who saw it believed that the police should be called on the police. So let's talk here about how he is trying to say.
But the layout during the trial is to always, the defense gets to counter what the prosecution presents, because it's the prosecution.
How is he
it's their job to make the case.
Yeah, he even called it a pro-police prosecution. And Libby, that is central to what they need to prove. The standard is, what would a reasonable officer do? And we saw in that closing argument the pictures of all the different Minneapolis police officers who were all outranking.
I'm going to have to move on to something stronger
on the
than
stand, saying this isn't what we trained him to do. This isn't what we are taught to do. This isn't who we are. This isn't what we would have done. You heard a former police officer also testifying about use of force, and that is kind of essential to. It was striking during jury selection. There are 2 black men on the jury. Both said that they actually haven't interacted with police. They're immigrants.
No, it was the. I believe this prosecutor is from the Attorney General's office.
Crime has been way up
in order to not.
Police have pulled back. There was
local prosecutors are obviously going to have connections to Chauvin.
It's important for prosecutors to.
So I believe that the Attorney General of Minnesota took over the case, which is Keith Ellison. And then this prosecutor is from the Attorney General's office.
Prosecutor Steve Schlesser gave for Derek Chauvin's actions. He blamed Derek Chauvin's his pride. And basically he said the defendant was not going to be told what to do by bystanders, by other police, and even by the EMS that ultimately came to the scene. What did you make of that?
Also, tomorrow is 420. Be sure to tune in for our 420 and 1 year anniversary spectacular.
To stop, to check a pulse.
I'm going to smoke a different bong each 420. We're celebrating 420 across the country.
Symptoms that
I'm going to smoke a different bong for each 420.
she said it felt like Chauvin was becoming enthused.
Also going to break out my gas mask. I've never used my gas mask on the stream before. I'm going to get stupid stoned tomorrow.
Of many people who've been watching these proceedings is what
we may get a verdict tomorrow.
Show this lack of compassion, and Schlescher said that the only thing that he really could have done at that time that he was trained to do was to.
Boy, what a deflating
somebody said that they can't
day it would be to get a shitty verdict on 420 and just completely destroy the party.
You know, the prosecution may have been doing to show the jury that could have changed.
We're going to try to have fun tomorrow anyway.
Would have stopped and just showed
4 o'clock Eastern time.
Eugene, you know, as James pointed out, part of that use of the bystanders, part of the prosecution talking about the bystanders is to have
tomorrow's show is going to include my first stand-up set in over 2 years.
Threat or less of a danger that Derek Chauvin had to be responsible.
You're going to get to see my little stage set up over here on the flip side.
How do they portray this scene in their closing arguments?
Well, I think what the defense is going to have to do is to try their best to show that Chauvin was in a situation that...
We're going to watch Reefer Madness, the classic propaganda movie, tomorrow.
The best decisions possible given the situation, that he was not as aware of what he was doing despite constant claims and yells from the crowd informing him of the pain that Floyd was under, and that he was under threat, and that he felt unsafe, and that he made an action that he believed was in the best interest of the public safety of everyone that was involved. He's going to try his best to humanize Chauvin and try to take away any suggestion that he acted in a way that was maliciously, intentionally harmful, that with the goal of, ultimately leading to Floyd's death.
Well, the prosecution pointed out that those eyewitnesses...
So we're probably about 10 minutes into a 20-minute recess
here. Begged Derek Chauvin to stop. Let's listen.
9 minutes and 29 seconds. He's surrounded by strangers.
Prosecution has presented their closing arguments. We will hear from the defense when we come back. This should be interesting.
He said them to someone who he did not know by name, but he knew him from the uniform he wore and the badge he wore. And he called him Mr. Officer. That's what he called him, Mr. Officer. Mr. Officer would help. We call the police when we need help. And he pleaded with Mr. Officer. George Floyd's final words on May 25, 2020 were, "Please, I can't breathe." And he said those words to Mr. Officer. He said those words to the defense.
See, once again, this is Mr. Officer. Curiouser alluded to the fact that apparently they knew each other because they were bouncers at the same bar.
Did not help. The defendant did not help. He stayed on top of him, continued to push him down.
The defense from Chauvin's attorney is that
twist his fingers into the handcuffs.
Chauvin was doing what he was trained to do, and that
staring down at
Floyd's death was caused by a combination of his enlarged heart
and watch this unfold.
A drug overdose, and apparently carbon monoxide from a nearby car that he was breathing in air from. That's the defense's argument.
Yeah, and obviously it's difficult to, as he said, imagine.
They had an expert that testified that
we think of officers as
the knee was proper,
and that was about.
And they had an expert testify that
one, he wasn't resisting arrest. I was actually struck by how far on a limb he went.
Floyd died of a heart attack, I think he said.
He wasn't wanting to get in the squad car because he had anxiety when they stopped trying to push him into the squad car.
A heart attack induced by fentanyl.
That he actually was being respectful.
I think speedballing, actually.
Anxiety, and even if he was on
because that's where the superhuman thing comes from. Because you can't claim that opioids cause somebody to be superhuman, so you have to claim that he was speedballing.
Officer Chauvin was afraid and nervous.
But he had meth and opioids in his system.
And that once you humanize.
Now, he did have trace amounts of amphetamine in his system, but the motherfucker was recovering from COVID.
That was in that same section.
He very well could have had Benadryl in his system, would give you a positive for trace amounts of
George Floyd
amphetamine.
was saying these things while he's breathing his last breaths and saying his final words. Derek Chauvin is picking.
Somebody with more medical expertise could tell you there's several over-the-counter medicines that could give you a false positive for amphetamines.
Definitely gets behind the one of the standards, which is kind of disregard.
Which one would expect somebody to be on if they're having respiratory issues from a lingering case of COVID-19.
Let's go now to our colleague Nicole Ellis, who is reporting from George Floyd's hometown. Nicole, thanks for joining us. Tell us about how Houston is reacting to this trial.
So I love there are a bunch of idiot right-wingers on comment sections calling lethal amount of fentanyl, they say. It was a lethal amount of fentanyl, and I was like, no, it's trace amounts. And they're like, oh, well, even trace amounts can be lethal. And I'm like, you motherfuckers, see the way you're framing it.
Watching George Floyd's death. So there is a new police chief here, Police Chief Troy.
You're exactly right, but like they put him in handcuffs because he cooperated. They talked to him. He cooperated the entire time. We saw it.
Floyd is from historically black neighborhood, 3rd Ward.
But he was having an anxiety, a panic attack or some shit. They tried to put him in a little ass back seat of an SUV.
By the mayor.
If you've ever been taken into custody by cops, it's insanely small.
Here in Houston, and is the first sort of police chief to come.
I am not a big man, and I had to sit sideways because you have to sit on one side, and your legs kind of have to go this way because you can't sit like this. Your knees will be up like this. And this is me. This is me, a small person. I am not a big person at all. I know exactly what the back of a cop car looks like.
That the city is watching and communicating.
So you had to sit kind of like this, scrunched up. I can't imagine how tall was George Floyd? Like 6'5", 6'4", or something like that? He was a big old boy.
To Floyd's death and thinking about how to navigate relating.
Should have assisted with an EMS. Yes.
That is hands-on and also of.
But then, like, the motherfucker had his knee on his neck. All the way up to the fact that they couldn't detect a pulse, and he still had his knee on his neck. It's murder. It's murder.
Is George Floyd. So what do they think about their former high school football star becoming now a rallying cry for racial justice?
To kind of put things into context, Libby, that's such a great question. 3rd Ward, where George Floyd is from, is actually where I'm from. I walked my dog this morning, and I talked to 2 people who also went to Yates High School and have a sense of optimism after watching and consistently watching the trial every day and see that sort of shift in how this conversation is happening, how the state is representing, really, as Rhonda is very pro-police and also kind of acknowledging and bringing in this level of accountability that we haven't seen.
The cops ain't dealing with it because they're little dick-gabbing motherfuckers and they want everybody to comply.
So many people, every, third neighbor per se.
They want unwielding power.
Had a family member go to Yates High School, be it
and submission from everybody around them.
Or a cousin or sister or brother. There's this immense amount of grief and
the prosecution countered that argument of it being his training by the fact that his supervising officer testified against him.
Social life in a neighborhood that has withstood centuries, be it Reconstruction, emancipation, civil rights movement.
Yes, they are weak. They're weak as fuck.
There's a sense of that could have been me, that could have been my brother, that could have been anyone here. And we heard that earlier when I showed some interviews with the city council representative here, Representative Carolyn Evans-Shabazz, who said,
I said earlier, I feel sorry for the prosecutor in this case. That's not necessarily like I am not envious of his position. Holy shit, the pressure that man is under.
Community about what happened to George Floyd and about how you can better protect your life and livelihood. And Representative Shabazz said she didn't have the answers to that and is looking to the outcome of
it's a supervising officer saying that no, that is not the way he was trained. And there were other officers this is one of the first cases where there have been cops that testified against a cop.
city, community.
Usually they go by what is called the Blue Code.
Right here in Houston.
And they won't dime on each other. They protect each other.
While this is
one of the absolute first trials.
In many ways, something that our country and the world
where cops testify. And if you look up, I believe it was Baltimore.
A lot, and it's something that
a cop was ready to testify against his department. He was found dead of an apparent suicide from his service weapon.
Thank you so much, Nicole.
That's what happens to cops who are ready to testify against other cops.
So, Mary Beth, the prosecution went through in great detail, sort of a
the fact that there were cops that testified against this cop in this trial is just amazing.
Then you got to find him guilty, right? If you hit these qualifications, A, B, C, D, you got to find him guilty of this charge. I think the judge is coming back now, so we'll go to you later.
All right, here we go.
We hear the defense in this trial.
Getting another look at Chauvin. There is somebody brought it up, like he's got some sort of cross or something.
I want to take this opportunity first to thank each and every one of you for your service, your diligence, and your attention to this matter. We all recognize the disruption that jury service places on your personal and professional lives, especially in a case of this magnitude and duration. And so on behalf of Mr. Chauvin, I want to thank each and every one of you for your attention and service to this jury. I'm going to apologize if I get a little long-winded, because I get one bite at the apple here. The state has an opportunity to rebut my statement after this. There's so very much we need to cover. There's so very much we need to talk about, and it is all
interesting, because I was kind of expecting him to take less time than the prosecution. The prosecution went about an hour and 40.
Before I begin my review of the evidence in this case, I would like to address two very crucial points of law, and they were touched on by the state. The presumption of innocence and what proof beyond a reasonable doubt means. The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges.
I'm not sure about the judge, but he has taken great pains
throughout the course
to make sure everything is by the book.
Throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point.
You are correct, sir, and I believe the state has proven their case against your client.
He starts at the presumption of innocence.
Well, I mean, he starts at the fact that we've all seen the video and he murdered the guy.
Here's the definition that the judge just read you. Proof beyond a reasonable doubt.
See, this is his play. Reasonable doubt. You have a reasonable doubt. You have reasonable doubt that he didn't kill him, right?
Is a doubt that is based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The law recognizes three standards of proof. The preponderance of the evidence is the first and lowest standard. Clear and convincing evidence is the next standard. And the third standard is proof beyond a reasonable doubt. And the way we lawyers sometimes illustrate what these three standards
I don't have a reasonable doubt at all. He murdered that guy.
Of justice equally balanced. When you apply the standard of the preponderance of the evidence, it's also called the scintilla of the evidence. A single grain of sand tips the scales in the favor of one party or the other. And this burden of proof is used in many civil cases. If the state wants to take away your driver's license, for an example, that is the burden of proof that the state has in that type of a case. They have to just ever so slightly convince the finder of fact that their evidence supports their action.
The next standard is clear and convincing evidence. I mean, that's pretty self-explanatory, right? It is clear evidence, and it convinces you, the finder of fact, that the action is correct.
Well, there's all this back and forth because, you know, we have an awesome legal system. That's good.
Your children. Clear.
I love that we have a system that is set up to protect the accused.
It tips the scales more in the favor of one party over the other.
So I'm fine with going through this.
In this country is proof beyond.
My issues with the legal system aren't
proof
actually trials, it's everything getting to trial.
Essentially, what the state has to convince you is that
how does he not know the result of his actions? That's what I'm saying. I brought it up when we were watching one of the videos from the side of the vehicle.
Or in other words,
the one where he's picking the gravel at it. What was he trying to do? What was his end result if it wasn't to kill the motherfucker?
Capricious doubt? Capricious means unpredictable. Fanciful. Space aliens, fluid.
Oh, he wouldn't get in the car, so I'm going to put my knee on the back of his neck for 10 minutes.
And cause this death. That's fanciful. Beyond the reasonable doubt. It is the highest standard in the law. Doesn't mean beyond all possibility of doubt, because I suppose space aliens may have been inhabiting his body, but that's obviously fanciful and capricious.
Oh, god damn.
So these two standards, the presumption of innocence and proof beyond a reasonable doubt, work in concert with each other. You start...
He is correct, but sir, it is your job to put that reasonable doubt in our heads, and you have failed to do so.
Substantial evidence.
But hey, it's not your fault. You can't do it because the facts aren't on your side. But the man deserves representation because we live in a constitutional republic.
As you analyze the evidence in this case, you would simply have to find that any defense that has been advanced is unreasonable. That's what this standard is all about.
Yes.
I want to take this opportunity also to talk to you about the importance of reading the entire instruction. Because I've seen, and lawyers, and I'm going to do it too, right? We pick and choose.
And if you don't realize that, you really have no business being a cop, don't you?
Help us make our case and help us argue our case. That's our job as lawyers, is to point out words and phrases within the instructions that make the difference in the case, and to take that evidence and present it to you in such a way that it supports our proposition. That's what we do.
How do you think this dude felt when he woke up this morning? You think he's feeling good about his case? You think he's feeling like it's about to be a white boy summer for him?
Law is what applies. But take the time to carefully read the entire instructions.
I swear to God, if I get taken down or demonetized for mocking white boy summer, I'm gonna be pissed.
A second here, a second there, a screenshot here, a screenshot there. You need to review the entirety of the evidence in this case during the course of your deliberations as well. And I can tell you that some of the videos that we've seen, they're much longer than what was presented in court. There's additional information, and you're going to see some of that as we go through this case today. So
you can't present new information in closing arguments. What are you talking about?
Of the facts of this case, compare it to the law as the judge instructs you, and the entirety of the law. That's why the instructions tell you, consider the instructions as a whole.
In the legal realm, there is a saying, I might butcher it here. When the facts are on your side, you pound the facts. When process is on your side, you pound the process. If neither is on your side, you pound the table.
intellectually.
This guy's going over process
evidence.
because that's what he's
You have
got.
to
He thinks he's
present
going
it
to try to
in
get this
an
off on
honest
a
and
technicality.
intellectually cohesive and coherent manner. And I have to address something that I think is important.
If they bring back not guilty, isn't that the official start of White Boy Summer?
Obligation to do.
Doesn't that mean the Nazis
look at
won?
evidence in light of all of the other pieces of evidence, right? So you heard during the
That means it's White Boy Summer for Derek Chauvin if he's not guilty.
One of the things that he considered is the possibility that carbon monoxide.
I hope that Facebook page fucking posted a picture of Chauvin sitting at the table today. White Boy Summer.
You heard that testimony. In rebuttal to that testimony, the state brought Dr. Tobin back.
My favorite's still the picture they posted of a hole in the wall that somebody punched. White Boy Summer.
We know, as a fact, we know conclusively that Mr. Floyd did not have carbon monoxide because his oxygen was saturated to 98%. And you just heard the state say, just like I am right here, right? So it stands to reason. I could get up in front of you and I could argue to you, we know this wasn't asphyxiation because George Floyd had a 98% oxygen level. How could he have been asphyxiated at the hospital with a 98% oxygen level? But that's not intellectually honest. It doesn't stack up against the
Can
rest.
you explain? I don't even know what he's saying.
Can
you explain that medical?
We heard the testimony of Seth
Lavender
and Derek Smith, the paramedics. We heard the testimony of Dr. Langenfeld. They came in and they said they began resuscitative efforts.
Wouldn't the oxygen level be the amount of oxygen that he?
They're manually breathing for him. They're reoxygenating his blood.
Oh, he had too much oxygen in his system, so he couldn't have been suffocated.
When you look at a piece of evidence like that, you have to compare it against.
Wouldn't because he said 98% oxygen? Isn't that the amount of?
You can't come in and say
whatever was in his lungs, 98% of it was oxygen, but that doesn't take into account that they were restricting his breathing.
Oxygen level, right? His blood is oxygenated.
98% oxygen level. I'm not exactly sure what that means.
Is true as well. You can't come in and say, I can conclusively prove that Mr. Floyd didn't have carbon monoxide in his blood because he had this high oxygen saturation. You test one statement against the evidence of other people and you compare it. That is what you as jurors are obligated to do and what I am asking you to do. Compare the evidence against itself. Test it. Challenge it. Compare it to the law. Read the instructions in their entirety. Start from the point of the presumption of innocence and see how far the state can get. I submit to you that the state has failed to meet its burden of proof beyond a reasonable doubt.
It sounded like he was saying his oxygen level was taken at the hospital. And that's how they knew he didn't have carbon monoxide
poisoning.
poisoning.
Charged, as the state indicated, with these 3 charges. And the judge has instructed.
And it would have had to have been after they were already
while committing a felony.
after he was already dead.
The felony murder rule in Minnesota.
So surely they would have been trying to pump him with oxygen, right? And doing chest compressions and shit.
I'm intending to rob the liquor store.
Because that's what he died of. They were trying to get oxygen to him because he died of being deprived of oxygen.
And murdered that person.
Is that what he's saying?
The death of that teller occurred while I was committing a felony. That's the felony murder rule. He's been charged with murder in the 3rd degree for performing an intentional act that is eminently dangerous. Right? You've seen the instructions, you've heard them.
The thing his supervisor said he shouldn't have done.
Again, the law has all of the words. It defines the words you need, and the instructions should be considered in their entirety. Whenever I meet with a client I try to explain what the elements are, and this is the analogy that I use. I say that a criminal case is kind of like baking chocolate chip cookies. You have to have the necessary ingredients. You've got to have flour and sugar and butter and chocolate chips and whatever else goes into those chocolate chip cookies. If you have all...
So his argument doesn't hold any weight.
But if you're missing any one single ingredient, you can't.
But it sounds good if you don't know what the fuck you're talking about. Is that what you're saying?
Analogy. But the criminal law works the same way. We say we call the ingredients the elements.
That's how they know he didn't die of CO2.
Proving each and every element.
But they were pumping him with oxygen because he died of being deprived of oxygen. So that's why his oxygen level was so high. So he's trying to use that as evidence. Well, he couldn't have died because his oxygen level was so high when he got to the hospital. That's fucking dishonest as shit, isn't it?
But if they are missing any one single element, it is a not guilty verdict. And you saw the spreadsheet that the state put up, right? The elements are a little different.
But hey, that's the way Republicans get elected all the time.
Will take less of your consideration.
Saying shit that sounds good.
You have to look at the evidence, and you will have to, for example.
But once you're informed, like, whoa, that doesn't make any fucking sense.
Minneapolis in the county of Hennepin is Hennepin County in the state of Minnesota. Did this happen on May 25th, 2020? Right? It's going to take less of your consideration, but nevertheless, you have to do that. You have to go through that process. Two of the elements that I want to focus on during the course of my discussion here today, two of these elements.
Also, I'm going to clean this motherfucker before 420 because it tastes horrible. Like, I take a hit and it tastes bad.
All three counts. And so I want to focus.
I've changed the water, but
on those two
the
issues.
gunk or something must be.
The first, were Mr. Chauvin's actions an authorized use of force?
I'm not sure. Hopefully the prosecution will tell us.
Because in the instructions, it specifically tells you no crime.
But the prosecution should counter that.
It was an authorized use of force. Period. End of discussion. The second is an element that is and does appear in all three counts.
Warlord, welcome to the shit show.
Death. What caused Mr. Floyd's death? And we're going to talk about that second. So, let's start with the concept of reasonable force. As the instructions read in their entirety, no crime is committed if a police officer's actions were justified by the police officer's use of reasonable force in the line of duty in effecting a lawful arrest or preventing an escape from custody. The kind and degree of force a police officer may lawfully use in executing his duties is limited by what a reasonable police officer in the same situation would believe to be necessary. Any use of force beyond that is not reasonable. To determine if the actions of the police officer were reasonable, you must look at those facts which a reasonable officer in the same situation would have known at the precise moment the officer acted with force. You must decide whether the officer's actions were objectively reasonable in light of the totality of the facts and circumstances confronting the officer and without regard to the officer's own subjective state of mind, intention, or motivations. The defendant is not guilty of a crime if he used force as authorized by law, and to prove guilt, the state must further prove beyond a reasonable doubt that the defendant's use of force was not authorized by law. So, if you remember from my opening statements and how I talked about reason and common sense, right? The reasonable police officer standard. I want to just briefly add one thing here, is the standard is not what should the officer have done in these circumstances. It's not what could the officer have done differently in these circumstances. The standard is, what were the facts that were known to this officer at the precise moment he used force, and considering all of the totality of circumstances and facts known to the officer, what would a reasonable police officer have done?
Not that. The exact opposite.
Heard from numerous experts.
We know this because we know what the other cop said. We know what his supervisor said.
You've heard from police officers, street police officers, Sergeant Edwards, Sergeant Pluger, right? So you've heard from these people, and they have given you their opinions at various stages as to the reasonableness of the use of force. But one of the things that
Oh, it's some sort of ID card.
Police officers.
Somebody pointed, like they thought he had a cross on or something, but like they've all got like ID cards or vaccination cards or something.
Police officer do, knowing the facts of the case. There are things that a police officer is entitled to take into consideration above and beyond the facts, right? Their training, the training that they receive, their experience as a police officer.
I think his shirt is an interesting, like,
and all of these things kind of,
because when you're not taking the stand, your clothes, they speak, and he wore blue on blue every day, I'm pretty sure.
Police officer at the precise moment the force was used.
Blue tie on blue shirt.
So you can start at a very high level, right? What were the reasonable police officers'
and it's the deep navy royal blue.
High crime location? Is it a low crime area? Those are things, those are facts that a police officer would know. What are the specifics of the location of arrest, right? Am I going into a densely populated urban environment, or am I in a kind of a secluded backyard, right? Officer is calculating these pieces of information and assessing the risk, assessing the threats.
And notice how he's focusing everything on process.
Kind of take into consideration things that you and I don't think about. Their tactical advantages, their tactical disadvantages.
He's not talking about the actual facts of the case.
Consideration the scene security, keeping the scene secure, and security of the scene, right? Those are two different concepts.
So that tells you that he knows that the facts aren't on his side.
What facts were known at the precise moment force is used. You can then take into consideration kind of this mid-range level of information. A reasonable officer wants to keep his fellow officers safe. A reasonable police officer takes into consideration the safety of civilians.
The civilians were all scared of the fucking police officer killing the guy.
The safety of the person.
That's a bad argument, dude.
They take into account, what resources do I have based upon how close am I to a hospital? What's the expected time if I call EMS? Because a reasonable police officer at times, they got to put the person in their squad car sometimes and take him.
He's struggling. He's struggling, and I don't blame him.
Calling for help, bringing help in would take.
You know, as not envious of the prosecutors I am, holy shit, I would not want to be in this guy's shoes.
That a reasonable police officer would have at the precise moment force was used.
Because if I had not been a broadcaster, I would have been a lawyer, and I would have been a criminal defense lawyer. I would have defended criminals with pleasure. I would have never taken a case like this just because of personal principles.
Take into consideration whether they suspect the suspect.
But everybody deserves
was under the influence
representation.
They can take into consideration.
Holy shit, I'm not envious of this dude. And I love taking the other side. I mean, I love arguing like the shit I believe in, obviously. But I like taking the other side.
Count their experience with the
I take it as a challenge. I could argue right-wing talking points better than right-wingers could.
A reasonable police officer tries.
If I turned right-winger, I would be on Fox or OAN, Newsmax within a year or two.
based
motherfuckers. So you better fucking support me. Shop at the freaking store.
The reasonable police officer's analysis too, because sometimes
subscribe to my Patreon or shit, or I'm gonna turn right winger, and I'm gonna be like really good at it.
Problem, and suddenly they become a problem. It can change in an instant.
He's not being. It's that reasonable doubt. He's trying to drive home that
consideration. His immediate surroundings.
He's trying to drive home that word, that phrase. But I mean, that works against his favor because we've heard from the other cops.
Who he is at the scene.
And that's what bringing up the bystanders was a bad idea, because all the bystanders were sitting there like, he was talking about their safety, and they're all like gawking like, how's this motherfucker doing this? They called the cops on him.
So
multiple people called the cops on him, and this motherfucker is going to get up here and make an argument about how he's worried about the safety of the people on the sidewalk? Holy shit.
The proper analysis is to take those 9 minutes and 29 seconds and put it into the context of the totality of the circumstances that a reasonable police officer would know. And the proper analysis starts with, what did the officers, or what would a reasonable officer know at the time of dispatch? Well, these are records that are kept. They've been introduced.
Well, that's a horrible argument.
This is Exhibit 151.
And clearly he wasn't a reasonable officer because he pulled up with guns drawn.
You heard the testimony of Jenna Scurry, the 911 dispatcher. This is information that they are passing out to the officers.
None of which warranted the response that he had.
The initial information that a police officer has in his squad car, looking at his computer or hearing over the radio, was that on May 25th, 2020, at 20:02:13, so that's 8:02:13, a business, Cup Foods, who police officers have the obligation to respond to these calls, whether it be from a person or a business.
You keep using that word.
The citizen of the state of Minnesota, Minneapolis, runs a business, and they called for assistance. And they told the officers, the reporting party, there is a male who provided a counterfeit bill to the business. He's 6 feet tall or higher. He's sitting on top of a blue Mercedes ML320 SUV. The license plates also appears this subject is under the influence. So the analysis of what a reasonable police officer would know in this circumstance is that A, a business is requesting its help. The suspect...
By your own admission, did any of that shit warrant pulling up with guns drawn?
Of alcohol. Or something else. So the analysis begins at 8:02 and 13 seconds. You may recall the testimony of Jenna Scurry as well, and it's not reflected in this exhibit pretty well, but in the evidence, exhibit number 10, you can hear the audio recording of the dispatch, Jenna Scurry to the officers. Jenna Scurry informed you that initially Officer Chauvin was assigned to this call on a Code 3 Priority 1 basis. It's Code 3, get their lights and sirens, get there fast, right? It's Priority 1 because the suspect is still on scene. So per the Minneapolis Police Department policy, get there fast, the person is on scene, right? That's what she testified. And then very quickly after that, that occurred at 8:04 and 28 seconds. Then what you see is what she told you, was that the sector car 320, that's the car that patrols this part of the city, said, hey, we can take this call, and Officer Chauvin and Officer Tao were canceled from the call. Right? So they were canceled from the call. And Sector Car 320, Officers King and Lane.
Oh, sorry, I slipped.
8:05.
Looks like we're not Looks like we're not on
When
the
Officer King and Lane took it over.
trial anymore. I don't know how that
Again, you
picture
can
got
go back
there.
and you can listen to that audio.
That's not relevant at all.
And you can hear them talking to each other. Officers King and Lane arrive at the Cup Foods at 8:08 and 20 seconds. So now we see police officers are responding. They're on scene at 8:08. Both Jenna
If you're just listening to the stream, I have no clue what he just did or what that noise was.
During the course of the initial interaction between...
It looked like he pressed play on something and was proud of himself.
Through dispatch, they heard what sounded like the sounds of a struggle. Jenna Scurry described she's trained to listen. She heard these sounds of a struggle, and she aired out on her own. Other officers need to respond, code 3, to assist Officers King and Lane. Right? So a reasonable police officer. He's going emergent to a scene. He gets canceled from the scene. He's now being told that other officers need assistance and step it up. Get there fast. So you can see again.
Oh, yeah, I forgot that Chauvin's not the first on the scene. That's right.
8:10:08, 20:10:08. Backed up 3:20 with 3:30. Right? So now 3:30 is Officer Chauvin and Tao. They're backing up Officer King and Lane. And you can see Peter Chang respond at 8:10 and 21 seconds.
That's wild. The dispatch, like, it sounds like a struggle. What the fuck does that mean?
3:20, taking one out. So that means they're removing someone from the vehicle at 8:11:02. The scene is ultimately C4, code 4, all clear at 20:12:21. So literally, this demonstrates to you a couple of things. How quickly a situation can change from second to second, minute to minute. They went from get there fast, back off.
It demonstrates to me how the cops constantly treat American citizens like they're criminals.
And it's fluid. They're provided with information.
Remember, this motherfucker went over the presumption of innocence at the beginning of his statement.
About the sound of a
Did the cop give the presumption of innocence to George Floyd?
Sergeant Steiger specifically said all of this information would be known to a reasonable police officer. And it goes into and factors into the reasonableness of the use of force. Ultimately, Officer Chauvin and Officer Tao arrive at Cup Foods. Just pause this for 1 second here. Sorry. When we look at Officer, I just have to give you a little piece of information. When we look at Officer Chang's video, Officer Chang arrives first. You see the time is 1:16:33 Z Zulu. That's Greenwich Mean Time. Subtract 5 from 1 a.m. get you back to 8. So Officer Chauvin and Officer Lane pull up. 8:16. Go over there.
Okay, just stay put, all right? I don't want anybody near his car.
Information gathering in terms of this assessment and reassessment.
It blows my mind the amount of resources we waste on investigating a supposed fake 20.
Officer Chang says, go over there. They need your help. Because what at that point, at that precise moment, they don't know what's happening over at the squad car. They don't know that officers King and Lane struggled with Mr. Floyd, getting him out of the car, that they sat him down, that they stood him up, that they walked over. They haven't seen any of this information, and there's no evidence to suggest that they had. So that doesn't factor into the information. It's, again, a reasonable police officer. What do they know? And they don't know that. But they're starting to get some indication, hey, go over there, right? Go over there. You can see right at about 8:17, and I apologize for the quality of the picture, Officer Chauvin is arriving and walking up to the squad car. So what would a reasonable police officer see in this instance? What a reasonable police officer would see could be defined, because again, a reasonable police officer has to be aware of his department policies.
And even in that picture they just showed, he didn't look like he was acting with any urgency.
Resistance. Let's call it active resistance. A response to police efforts to bring a person into custody or control for detainment or arrest. A subject engages in active resistance when engaging in physical actions or verbal behavior reflecting an intention to make it more difficult.
It's just amazing to me, like, what little itty bit constitutes resistance.
Walks up to this scene.
Or malfeasance on the part of the citizen. But when it comes to the cop, like, oh, no, you can't call that murder, no.
He knows his department policy on the difference between active aggression, active resistance, passive resistance, based on policy, training, etc. This is an officer's consideration of, again, the use of force. All of these things factor into it.
And in the picture you just showed, it looked like he was just out for a stroll and wasn't acting with any urgency.
Struggling with Mr. Floyd, attempting to put him into the car. He hears the words that Mr. Floyd is saying at that point. I'm claustrophobic. I'm a good
Notice
guy.
he's just showing still video or still pictures. Because we saw the video, and the video is Floyd complying.
He's observing with his eyes.
But they pause it on stills that make it look like a struggle.
And his ears.
But that's the reason why Chauvin doesn't look like he's acting with any urgency in the picture you just showed. Because Floyd was complying the entire fucking time.
So let's watch. What does Officer Chauvin see when he walks up? This is from his body camera from 8:17 and 21 seconds to 8:18 and 15 seconds. Just shy of a minute.
You can't win. I'm not trying to win. Don't get in the car. Don't get in the car. He know it. He know it too, Mr. Officer. Y'all hear me? Don't do me like that, man. Please. Okay, can I talk to you, please?
So he showed you still pictures all the way up to this point. This is the only piece of footage he's showing to justify what's getting ready to happen. But we watched the whole thing before this, and Floyd is complying. See, look at the way the cop is treating him. Any reasonable human being would have a reaction to being treated like that, manhandled, if you're having a medical emergency. So even if their argument was that he was having an OD, he was clearly having a medical emergency, and you motherfuckers are manhandling him.
By 8:18 and 15 seconds.
So they stop it there and don't show him
Mr. Floyd. But he's observing.
Sitting next to the vehicle and saying, "Thank you for taking me out. Thank you, Mr. Officer."
He sees active resistance occurring, potentially active aggression occurring. He has two other officers.
It's called selection bias.
But again, based on the policies and the training that you have seen, what were his options available to him at that time?
But we all just watched the video.
Actively resisting in the center. Distraction techniques, controlled takedowns, conscious neck restraints. Can you clear that in? Right. These are options.
What does it say if they're having a medical emergency? What does it say if they've been compliant the entire fucking time and start having a medical emergency, sir?
These techniques.
Does it say you can murder them? Because if so, we need to fucking change some shit now, don't we?
Would be making these observations. He would observe the white foam around Mr. Floyd's mouth. He would consider the possibility that this person was under under the influence of something.
The foam.
Using the information.
It's like a little piece of spittle on his lip.
Observations. How is he analyzed?
And they used that picture to make him look all crazy-eyed and shit as the cop is like shoving his head down.
A reasonable officer
Disgusting.
would look at the size of the person.
But what else do they have? The man deserves a defense under our legal system. What else does he have to go to besides slander?
Right? That we've heard about so much. A reasonable officer would.
What else does he have to go to besides deceptive editing?
Putting this man in the car. In fact, as the evidence established, Mr. Chauvin trained one of the officers.
Well, what does that tell
A
you?
reasonable officer may step back at this point to see if these two guys can get this under control. A reasonable officer will hear the words that the suspect is saying. I'm a good guy, I'm a good guy, I'm a good guy, I'm claustrophobic. And he's going to compare those words to the actions of the individual. Right? Because this is part of the analysis.
He was acting exactly like that was the truth, now, wasn't he?
But if my behavior is inconsistent with what I am saying, a reasonable officer takes that into consideration.
But it wasn't.
In fact,
that's why he's not a reasonable officer, sir.
Of his department policies knows the de-escalation policy that is in place. And part of what a reasonable officer has to do is to consider whether a subject's lack of compliance is a deliberate attempt to resist or an inability to comply based on these factors. Medical conditions, mental impairment, developmental disability, physical language, language barrier, influence of drugs or alcohol, or behavioral crisis. So an officer, a reasonable
The considerations that I never see cops make.
And assess, is this suspect purposefully or intentionally, deliberately trying to thwart our efforts to take him into custody, or are they experiencing one of these other types of factors? But such consideration, when time and circumstances reasonably permit, shall then be balanced against the incident facts when deciding which tactical options are the most appropriate to resolve the situation safely. So again, reasonable officer, based on the totality of these circumstances, is going to take all of this information in, all of these policies, all of these training ins, and a reasonable officer at that point would conclude that the amount of force that was being
needs to kill the guy
was insufficient. It was not enough use of force to overpower Mr. Floyd's resistance to getting into the car. He's seen it.
Remember, sits down next to the car and says thank you.
And so, at precisely 8,
and we see we saw the pictures of the abrasion on Floyd's face after Chauvin shoved his face into the
Officer Lane and Officer
into the
Short
sidewalk.
Struggled, fought, whatever adjective you want to use. They struggled with Mr. Floyd from 8:18 till 8:19 and 12 seconds. About a minute, little over a minute. It doesn't really seem that it's that long of a time, but again, the amount of physical exertion. Remember how Sergeant Jody Steiger described this.
Because he's superhuman.
Apparent attempts to get him into custody were futile. I wrote his quote down. The futility of their efforts became apparent. They weren't able to get him into the car. 3 Minneapolis police officers were not able to get Mr. Floyd into the car. They themselves are experiencing that surge of adrenaline. A reasonable police officer will be experiencing that surge of adrenaline. And again, balancing all of the evidence against each other, right? Let's look at 3 different angles of this struggle. This is Officer Floyd's body camera.
Come on down. Get in the squad. Come on down.
So he's going to play you the same 1 minute that is deceptively selected of a man having a medical emergency and a panic attack.
I can't go, man. I can't breathe.
Not showing all the other video around it, showing that he was complying.
Is he going to jail? He's under arrest right now for forgery. I tell you.
For forgery.
For what? Please, man. I can't fucking breathe. Hey, come on out. Look at you. Thank you. Get him on the ground. Yeah, on the ground.
You giving out the band hammer to the jury?
He's under arrest.
You're already drunk with power.
This is the video of the same time period from Officer Lane.
And how is he charged with forgery? Being charged with forgery. He could have every bit accidentally picked up a $20 bill that was counterfeit from somewhere else. It might not have been fucking counterfeit. These motherfuckers are already charging him with forgery, pulling up with guns in his face. How is any of this fucking justified? I read the 4th Amendment earlier. Gross violation of his 4th Amendment rights.
He's under arrest right now for forgery. I tell you. What's going on? What?
Let's take him out and just.
For what?
MRE.
I can't fucking breathe. Here, come on out. Look at you. Thank you.
Yeah, just when you get up
on the ground.
I appreciate that.
Officer.
Also, remember, he had COVID. He probably has decreased lung capacity because of it.
I'm going down. I'm not going to run, man. Right. I know I can't breathe. I can't breathe. You're talking.
And they played the 2019 arrest, and it was the same thing. They pulled right up on him, threw guns right in his face, started yelling motherfucker at him. No wonder the dude is scared to death and having a panic attack. Every time he's like, please don't shoot me, Mr. Officer. The fuck is wrong with these people?
Let's take him out.
Please, man.
They think they're justified.
Come on out. Look at you.
How? And they stop it right before he thanks them and sits up and cooperates again.
You can see at points.
Intensity of the struggle, intensity of the medical emergency that the man was having.
It knocks off the body-worn camera and the badge of Officer Chauvin in this struggle.
'Cause he's superhuman.
A reasonable police officer would understand this situation. That Mr. Floyd was able to overcome...
And he's talking about a reasonable fucking police officer. Bystanders.
While handcuffed.
On the sidewalk.
And his body strength.
Are you telling me they all aren't reasonable?
Standard can be seen in another way. From the milestone camera. And this is what caught the attention of the 911 dispatcher, Jenna Scurry. She said she observed the struggle and the vehicle rocking back and forth, back and forth. Watch the vehicle.
I'm not even seeing it shake. There, it moved a little bit. And he's presenting this as evidence? Holy fuck. That's what a fucking car looks like when you just get in it. Oh, it was shaking so hard. No. You have more medical expertise than I do, though, sir. As I understand it, opioids would make you feel like you can breathe when you can't. That it is given to patients with respiratory issues. Once again, where's this car shaking at? I have made back seats shake a hell of a lot more than that. And this motherfucker has the audacity to present this as evidence in court to a worldwide audience that is watching him. Oh, so now they'll show that part from that camera, but they won't show it from one of the body cameras to where we can hear what Floyd said.
That I think is really important to understand. Two things, actually, at this moment. Not a single use of force expert.
So the opioids, because of that, that's why they have to say he was speedballing.
Police officer who testified said that anything up until this point was unlawful or unreasonable. It was reasonable for these...
I think everything up until this point was unlawful and unreasonable. I read the Fourth Amendment earlier.
Took to overcome his resistance were reasonable.
I think Thomas Jefferson would punch you in the fucking face, sir.
Nothing is contrary to policy, training, defensive tactics, crisis intervention.
Maybe not Jefferson. He was a bit of a pussy.
It's at the point that Mr. Floyd is...
Payne would punch you in the face, motherfucker.
There's a dispute about the reasonableness of the use of force and what a reasonable officer would know. It was Seth Stoughton, the law professor, who said at the point Mr. Floyd came out of the car, putting him on the ground was unreasonable. So,
Franklin would write a very stern letter.
Officer Chauvin or a reasonable police officer to put Mr. Floyd on the ground in that instant. So a reasonable police officer is going to rely on his training and information, his evidence, what he knows, all of the information he's built up to this point. You heard Lieutenant Mercel testify about how about 15 years ago the Minneapolis Police Department went to ground defense tactics. Getting people on the ground.
So earlier they made the argument that he had a 98% oxygen level.
Different types
but we believe that to have been the oxygen level
to create and eliminate
when he was at the hospital. We're not exactly sure. We don't think that was the EMS taking oxygen level.
These are the tactics that have been employed by the Minneapolis Police Department for 15 years. Why?
Because how many fucking innocent people have died at the hands of the Minneapolis Police Department?
People contained, controlled, and confined until they no longer are resisting.
Until they're dead. It's what you just
reasonable
described.
police officer would also consider his department's policies, including the use of non-deadly force policy. Force that does
It
not
is
have
amazing
a
he
reasonable
didn't.
likelihood of causing or creating.
It's amazing he didn't break out a taser just like we saw at the with the dude at the hospital in Columbus.
Physically subduing, controlling,
We've all already closed this case.
restraining,
Hopefully this is just a formality, Creed.
managing a person. This is the policy 5-302 of the Minneapolis Police
I'm
Department.
feeling a lot more confident after hearing the defense's closing arguments.
A person.
Because I haven't watched the trial live. We've kind of covered like the big happening each day
Has agreed that
on the
use of
show.
force up to this point
It's the first time we've been watching the actual
lawful,
live
and
proceedings.
meets the reasonable officer standard. And so we get into the 9 minutes and 29 seconds at this point. And the state has really focused on the 9 minutes and 29 seconds. 9 minutes, 29 seconds. 9 minutes, 29 seconds. It's not the proper analysis, because the 9 minutes and 29 seconds ignores the previous 16 minutes and 59 seconds.
You ignored the previous 16 minutes and 59
in
seconds.
that moment,
You
at
took
that
out
point,
one
nothing else that
1 minute
happened
segment,
before
played it from 3 different angles, and used that to justify.
It tries to
We heard the rest of the 16 minutes, and he was complying with the officer's orders.
A reasonable police officer would, in fact, take into consideration the previous 16 minutes and 59 seconds. Their experience with the subject, the struggle that they had, the comparison of the words to actions, it all comes into play. Why?
Comparison of words to actions. You motherfuckers put guns in his face right off the bat over a supposed $20 counterfeit bill.
1 second and fighting the next. Someone can be fighting and then complying. Nobody knows it better. But reasonable police officers continue to assess and reevaluate. This is the critical decision.
Reasonable police officer is an oxy-goddamn moron.
You assess the threat versus the risk. Do we have an authority to act? What are our goals and actions? Review and assess. Start over. Because this is not a singular cycle. This is a cycle that humans, as humans, we literally make millions of decisions.
It's a cycle of shitty cops
Do I go this way? Do I go that way?
playing into systematic racism.
We're constantly doing this. This is just human behavior. But in the
And their
police
little dick syndrome.
you have to gather the information, assess the risk, assess the threat. Do I have authority to act? What are my goals and actions? Review and assess. And it's constantly rotating. At the precise moment that Mr. Floyd was laid on the ground, a reasonable police officer would know about those previous 17 minutes. A reasonable police officer would know about the struggle. A reasonable police officer would consider the suspect's reactions to the previous use of force. A reasonable police officer
Make them comfortable so they don't buck the vent.
And a reasonable
I
police
assume.
officer would consider whether to use an additional force to overcome the
This
suspect.
wasn't a reasonable police officer.
So 9 minutes and 29
I would argue that there is no such thing. But in this case, there certainly isn't.
I appreciate that. I do.
Does this look like what a reasonable police officer does? Look, they've got him wound up like a pretzel.
Mama.
Pulling his arms.
The risk and the threat. The first 29 seconds, 20 seconds, continued resistance is what a reasonable police officer would interpret.
Oh, I know opioids relax you.
Christ. The kicking.
Never forgetting the story of Jesus, the hero, was killed by the state.
Should we elevate the use of force?
Run the jewels, motherfucker.
And that's precisely what these officers did. They discussed using the MRT, the hobble.
Oh, please, man.
There you go.
And doing a lot of
Mama, I love you.
Are we calling for
I can't do nothing.
Yeah, EMS is on their way.
Thank you, defense, for playing this.
I can't breathe, man. Please. Please let me stand.
Look how calm all those motherfuckers are. As the motherfucker calls out for his mom.
Should we use the hobble? Should we elevate our use of force? A reasonable officer would continue to evaluate whether the suspect is under the influence. Precisely what these officers did in this 9 minutes and 29 seconds.
The clerk's still sitting on the car there.
Look at my face, man.
He said, "Look at my face, man. We saw the abrasions on the side of his." I couldn't believe that. That was the first time I'd seen.
Please.
Two other people with
Please, I can't breathe. Please, man. Please. Mama.
on a weed pipe on him. There might be
Mama.
so that might be like.
I can't. I'm pissed.
Is that the
All right.
shaking of the eyes, right? Is PCP?
My knee. My neck.
Or the eyes like shaking
I'm
back
through.
and forth.
I'm through.
So reasonable police officers discuss the scene. The first clip, they're talking about the two other people that are over at the car, right? What's going on here? What are we dealing with? Is this person under the influence of a controlled substance? These are the actions of a reasonable police officer. A reasonable police officer would rely on his training and experience. Call EMS. Possibility that a suspect who was struggling with us will begin to struggle again. You've heard this testimony from multiple police officers. The risk that the suspect would present to himself if he's not continued to be controlled, and the risk that the suspect presents to others. 2020-11, 8/20/11. Within a minute of the struggle, EMS code 2 for a mouth injury, right? Because they are not observing.
Oh, my microphone's not on. I've been talking.
A reasonable
I don't
officer
know.
is not observing life-threatening.
Asking all kinds of questions about
They just fought
fentanyl.
with the man for a minute. He continued to kick at them when they got him on the ground. They see he's got a mouth injury. We need EMS. So a reasonable police officer would evaluate
A mouth injury.
of the suspect, compare words and
That wasn't. We saw the picture.
respond by calling
It wasn't
EMS.
just a mouth injury.
But again, reasonable police officers evaluate, reevaluate.
The look on Chauvin's face right now is
21.
weird.
1 minute and 24 seconds later. We need EMS here faster. Code 3. 3:30. We need him here faster. A reasonable police officer would take into consideration the anticipated time of a emergent response. You heard from Genevieve Hansen. There's a firehouse a few blocks away, and she would have expected EMS to be there within minutes. 3 minutes is what she said. A reasonable police officer, based on his training and experience, is going to have and take that into consideration. I put this person in a prone position on the ground. I'm holding them for my safety and their safety. I'm expecting someone to be here within 3 minutes to help this person. I have called for that help.
It's not for his safety.
A reasonable police officer will take into consideration.
I'm glad that the prosecution framed it as it was his ego, because it absolutely wasn't for anyone's safety, as this motherfucker is asserting.
It is not uncommon for suspects to feign or pretend to have a medical emergency to avoid.
Oh, you see Chauvin shaking his head over there? This is interesting. I'm glad they put the camera on him now.
That is the reality. Nobody likes to get arrested, and reasonable police officers know that. How many times does someone, oh, my heart hurts, or I'm having a medical emergency, insert whatever emergency, right? Simply because they don't want to go to jail. A reasonable police officer will take his training.
I don't think a police officer is trained to make that decision.
Lieutenant Mercil specifically say that when someone says that they can't breathe, but they are talking, if they're talking, it means they're breathing, right? If they're talking, it means they're breathing.
I'm sure.
Again, compare that to the...
But you should always err on the side of caution.
Who told you that same thing?
Sorry.
That is true. If you are talking, you...
If they're going to expend all those resources and send all those cops out over a $20 goddamn bill, then I don't give a shit if they give somebody a ride to the hospital for no goddamn reason. Fuck it.
Needs relevant to their respiratory processes because they're saying, I can't breathe. And some doctors confuse it for just anxiety.
Yeah, go take them to the hospital. I don't give a shit.
Medical doctors make these mistakes.
Better to err on the side of caution.
A false sense of security.
Because the cop's job, I've said it over and over again, the cop's job is to put their life on the line to make sure the people in their charge make it back safely, no matter what they're accused of.
Training and experience. If you can breathe.
But I showed you where the Supreme Court ruled that cops have no duty to protect you. So we need to change something fundamentally in our laws.
I can't joke. I can't breathe. Please. You're talking. Please. Sit down.
They get annoyed with everything. I've met cops.
Wait. I know I can't breathe. I can't breathe. You're talking and
Because I'll take the opportunity to remember the cop, George Floyd accused counterfeit $20 bill. The cop was committing a felony fraud in the tens of thousands.
You're doing fine. You're talking fine.
I can't breathe.
It is my contention that the cops are the criminals.
Please.
And that in all situations, the American people are to be treated as if they are innocent. That motherfucker, the defense attorney made that argument, presumption of innocence. It was the first thing that came out of his goddamn mouth. Yet he's defending motherfuckers that walked up, had guns drawn on a motherfucker over an alleged $20 bill.
Relevant to their words, their training, their experience. Takes a lot of oxygen.
Oh, I'm sure it was interesting working in a jail.
You're breathing fine if you can talk.
The same way it was interesting being in a mental hospital doesn't mean it's a good experience.
He's talking, so he's fine. Okay. We tried that.
There he said it. He's talking, so he's fine. I mean, he's gasping for air, it sounds like to me.
All right, we're done. Okay, we're done.
And I honest to God think cops repeat shit like that on camera so that they can use it as evidence in court. Oh, well, he said he's talking, he's fine. See, the cops were aware, like, what was going on. They use it for plausible deniability. You can't convince me otherwise. They have stock phrases that they all say on camera.
I just worry about the delirium or whatever.
I've seen it over and over and over again.
I worry about the excited or delirium or whatever. That's why we have EMS coming. It's not just leave them here. It's we have EMS coming.
That's why the policing has to go. We have to completely wipe it out, start from the ground up. We have to reimagine and rethink it.
Control technique.
Because the system that is in place,
the level of resistance. Remember what Sergeant
notices, and it's not well received in terms of reform, compassion,
punching at you or biting at you.
And like we produce horrible results. The recidivism rate in this country is out of control. Because we don't focus on rehabilitation. We don't treat human beings with dignity. There are countries that will not extradite to the United States because we do not meet the minimum humanitarian standards with our jails and prisons. We should be ashamed of that.
This is the point.
Look, just that. Is he struggling?
Testified that Mr. Floyd had an anoxic seizure, right? But it's not. We're not analyzing the use of force from the perspective of a doctor with 46 years of medical experience who had 150 hours of time to watch an event from multiple perspectives over and over.
Oh my God.
Yeah. It's a reasonable police officer standard. How would a reasonable police officer interpret this? Does a reasonable police officer even know what an anoxic seizure is? A reasonable police officer...
No, they don't. Because court okays borrowing high IQs for cops. A man whose bid to become a police officer was rejected after he scored too high on an intelligence test has lost an appeal in his federal lawsuit against the city. Court okays borrowing high IQs for cops. Do encourage everyone to get vaccinated. I'm going to go shortly. I was actually going to go a couple of weeks ago, as it's been open to media in my state.
It includes, but it is not limited to, physically subduing, controlling, capturing, restraining, or
But also, I don't interact with anybody, so I was waiting until everybody that wanted one actually could get one.
These are the Minneapolis Police Department. Reasonable police officers, again, continue to...
But now it's an imperative that I go get one in order to contribute to making sure that we actually reach the threshold for herd immunity. As producer Dave has stated, is it going to just top out at 65, 67%? Is that the ceiling?
Yeah, I need my deals.
Are we going to see it plateau?
I think he's passing out, but he's breathing, right? This anoxic seizure occurs. Reasonable police officers are building and basing their decisions based on all of these factors coming in at multiple times.
These aren't reasonable police officers.
Bystanders, right? Call them a crowd, call them onlookers, call them bystanders. It doesn't matter what term you use for the people that gather to watch what police do. Reasonable.
I like to call them looky-loos.
Are cognizant of and aware.
Rubbernecking, baby.
And before I really kind of start talking about the crowd in some limited detail,
I wouldn't if I was you.
Of this trial, about the difference between perspective.
Honestly, I kind of think you've been working for the state.
Perspective and perception are two distinct concepts. Perspective is the angle at which you see something. It's your perspective. Perception.
But when they had the camera on Chauvin looked very happy with his defense. So
I've thought about this a lot.
If Chauvin's happy, I'm happy for him.
This situation here in the courtroom is incredibly unique, right? It's not the normal setup for a jury trial. So my perspective through the course
I'm not so sure he got his money's worth.
Is that I cannot see.
I bet he paid big bucks.
Very limited opportunity to observe the jurors. They probably can't see me either. Several of the jurors,
I might be wrong though. I might be wrong. There might have been attorneys that were jumping to defend him.
My perspective sitting in this chair.
There might dumb fuck right wingers never cease to amaze me.
So in order for me to see the witness, I have to roll all the way over to the other side. Then I have to look through the plexiglass that has these large reflecting lights. Right? Things block your perspective. Things can affect your perspective. But your perception is how you interpret.
Just all the excuses you make for the cops' actions.
And that is
no leeway whatsoever.
Our experience.
Murder 2, murder 3, and manslaughter are the 3 charges that the jury will be deliberating on when it goes to
3
them.
people in this trial went to the same high school. Me, Darnella Frazier, and Chief Arredondo. We all went to the same high school. Obviously at different...
Sounds like a good old boys club.
My experience, Chief Arredondo's experience, Darnella Frazier's experience, all based
and the prosecution had a very nice PowerPoint.
Saw the same
laid out murder 2, murder 3, and the manslaughter. They filled in all the columns with their evidence and shit. The prosecution did a great job.
Ultimately, at the end of the case, when we're done with these arguments, the court will instruct you on how to deal with these biases.
I yelled at them for being pro-cop.
The court's final instructions
and bootlicking, but I mean,
your biases.
They're the prosecution. Of course they're pro-cop.
What we bring to the table.
And it was a smart decision for them to frame it as this is a pro-cop trial. That was literally a phrase they said.
Let's look at this.
This is about holding a bad apple accountable
and perceptions
and upholding
just 4 of the bystanders. Right?
The sanctity of policing.
Charles McMillan, 61 years old.
I took that opportunity to bitch about cops, but that's just me.
He described himself as a curious
It was a smart move.
He likes to know what's going on in his neighborhood, so he stops and he checks things out, right?
And Chauvin has been writing the whole time.
Dealing with these guys. He has more information because he sees the entirety of the situation. But his perception of the event is affected.
I wonder if he's been drawing.
At the end of the night, ultimately what he said to Officer Chauvin was, I hope you get home safely, because that's what he says to police officers every night.
Can you advise the fire department if they're still with you, they need to go to 36 Park to assist with the
But I feel respect. That's one person's opinion. But no, I gotta get him. We gotta control this guy because he's a sizable guy.
They are all on the table. The jury can convict on any of the counts. It is very possible that we get, a manslaughter conviction and not murder 2 or 3. Possible we get murder 3 and not murder 2.
Darnella Frazier.
I don't see it.
A 17-year-old high school student who, upon seeing the restraint of George Floyd, her response was to pull out.
I do not see not guilty being the verdict.
And then subsequently upload it to
hung jury
Facebook
on.
Her perception
would not surprise me.
And her perspective of the event. She's looking. She didn't even know that Officers Lane and King were there because her perspective was blocked by the squad car. But her perception, her response to the situation was to record it, and that's perfectly fine. But she began her recording at 8:20 and 51 seconds. Donald Williams. He's a
Right, he just made the argument that she didn't know that the other cops were there when she was recording.
He had spent the day fishing.
As if the other cops being there.
Drink when he became aware of the incident. He described his view of this based upon his perception.
Made a difference.
As a mixed martial artist, right? He has a set of experiences that caused him to react in a different way. What he perceived was happening was that Mr. Floyd was being choked with a blood choke. I think we're past this at this point. The paramedic reached in, touched the carotid artery. To have a person rendered unconscious through a choke requires the blockage of both carotid arteries. This was not a neck restraint. This was not a chokehold. He was upset. And that, again, is okay because his perception affected what he was seeing. Genevieve Hansen, right? 27-year-old female firefighter for the city of Minneapolis. She testified
His
that
argument was that the MMA guy was concerned.
She said, I walked into an upset crowd.
I honestly don't know why you even brought that up. That
distracted me from getting the officer's attention. And she testified, again, based on her perspective, that Officer Chauvin appeared to have his hand in his pocket.
He's trying to put reasonable doubt. They testified that it was a blood choke. Oh, it wasn't a blood choke.
She observed fluid.
So he's trying to say these witnesses weren't credible. Okay, I get what he's going for now. At first, I was really confused, but I'm also really stoned.
She testified that nobody ever told her that EMS or an ambulance was on the way. She asked when I asked her about the response time she would have expected, 3 minutes. When I told her that paramedics had been called about 5 minutes prior to her arriving on scene, no way. Because her perception is 3 minutes. But when you look at the things that Miss Hansen saw, whether it be from her perspective or her perception, there can always be more to the story. The blood coming from Mr. Floyd's nose was why they called EMS in the first place. You've seen the pictures. He injured his nose during the struggle, or his face during the struggle in the squad car. The fluid that she described as potentially being urine, we know that that's fluid coming from the undercarriage of the squad car.
I cannot breathe.
Officer Chauvin specifically told her an ambulance was coming when she first came on scene.
Don't come over here. Don't come over here.
And that doesn't...
Yeah, we need you to keep some distance. Yeah, the ambulance coming.
Ambulance is coming. He's got his knee on his neck. He's pulling his arm. The other dude's got his legs in like a fucking Texas clover leaf.
The computer-aided dispatch reports.
He's handcuffed.
What time EMS was called. So Genevieve Hansen has a perspective and a perception. And what she observed was not consistent with the actual evidence. But remember, we don't look at this incident from the perspective of a bystander.
No, it is absolutely consistent. She was concerned that a man was being murdered, and a man was murdered. It's fucking as consistent as it gets.
Police officer.
Just because she didn't have the terminology to describe it properly.
A police officer, when confronted with these bystanders, would know everything that had occurred up to that point. 20 minutes, 25 minutes, 30 minutes. They know all of that information. The bystanders do not. A reasonable
I just don't know if somebody wants to be convinced that Chauvin is innocent. Did this dude give them something to chew on?
Officers wear cameras for a very specific reason, to record their actions, so they know they're being recorded. Officers are aware.
Because that's what it's about, convincing one or two of the jurors.
You're in a high retail...
that want to be convinced, that want to thin blue line, suck cop cock.
High surveillance. Right?
There's a good possibility there's at least one or two on the jury.
They would know if citizens take out their cell phones and start filming. This is the point at 8:20 and 49 seconds when Miss Frazier starts recording. Reasonable police officers are aware when they're using force that sometimes what they are doing does not look good to the general public.
It didn't look good to the general public because it wasn't good. You murdered somebody.
Right? A reasonable police officer will hear the increase in the volume of the...
I love that his argument is that even though everybody was looking on as if we murdered somebody, we weren't actually murdered somebody, even though we murdered him.
They'll hear the cursing. They'll hear this, and they'll take that
wild argument.
A reasonable police officer will rely on his recent training. excuse me. A reasonable police
Once again,
officer will hear what an
supervisor testified he was not trained to do that.
will hear what the crowd is saying. He will compare his actions to what they are saying, and he will determine, I know I'm being recorded, right? I know I'm being recorded. They're saying that I'm doing something that's awful looking.
Chauvin looking around, kind of dodgy there. And he's staring right at his attorney.
He's human, bro. His nose. Whatever, yeah, you can put him in the car. That's some
We
bum
tried
ass
that
shit.
for 10 minutes.
That's some bum ass shit, bro. That's some bum ass shit.
He just said we tried that for 10 minutes. It was 1 minute.
Knee on his neck, bro. He's talking. Bro, he ain't crying, bro. We're done. You circulate like in the jiu-jitsu.
At this point in time, had they even been on the scene for 10 minutes?
You don't think that what it is, bro? You don't think nobody understands that shit right there, bro? I train at the academy, bro. That's some bullshit, bro. Right, that's bullshit, bro. That's bullshit, bro. You fucking stopping his breathing right there, bro.
Okay, he's talking.
He's talking. Bro.
Fucking, what is the defense doing? Thank you for playing this video.
You could get him off the ground. You been a bum right now. He enjoying that. He enjoying that shit. He enjoying that shit. He a fucking bum, bro. He enjoying that shit.
He is. He is enjoying it. Dude's correct.
Bro, he's not resisting arrest or nothing.
You can see Officer Chauvin's body language tells us a lot, right? That's what we just heard. Looking down. Looking
Yeah, he was enjoying it.
around, looking down, looking over, looking around. He's comparing a reasonable
He was into it, and he's an exhibitionist. That's what it looked like to me.
his own actions in response to what the
He
crowd
kind of seems like he's enjoying this.
A reasonable police officer again.
He's got a hell of a smug look on his face right now.
2020, March of
They cut away
2020.
from him again.
Tactics of a crowd. Never underestimate a crowd's potential. Most crowds are compliant. Crowds are very dynamic creatures and can change rapidly. A crowd may contain elements of several types of...
Well, I mean, that crowd had every right to go over and just like punt his head
These
and
are
get him off of him.
But you never underestimate a crowd's potential.
Unfortunately, that wouldn't have ended well for them.
Officer has to be aware and alert to his surroundings.
I think they had every right to do it. However, our legal system probably isn't going to look at it that way.
Department's policies on crisis.
That's why they called the cops. That was the only thing they knew to do.
Crisis. An event or situation where an individual's safety and health are threatened by behavioral challenges to include mental illness, developmental disabilities, substance abuse, or overwhelming stressors. A crisis can involve an individual's perception or experience of an event or situation as an intolerable difficulty that exceeds the individual's current resources and coping mechanisms and may include unusual stress in his or her life that renders
Seriously.
him unable to function as he or she
The whole clip illustrated the
necessarily may but may not
prosecution's argument perfectly.
upward trajectory or intensity culminating in thoughts or acts that are possibly
I mean, I would understand trying to take the wind out of that, but that doesn't seem to be what he's doing.
recognizing that the crowd is in crisis, that all of these things, the members, the bystanders, the citizens, whatever you want to call them, they are in crisis. So a reasonable police officer considers his department's training.
What?
What are these potential signs of aggression that I may be confronted with? Somebody standing tall, somebody red in their face, raised voice, heavy breathing, tense muscles, pacing, right? This is from the crisis intervention training. This is what Kerr
That sounds like every cop interaction I've ever watched on a video.
in a crisis.
That's exactly what a cop has been doing.
Aggression. How do you respond to those? You appear confident in your actions.
Except Chauvin. Chauvin was fucking cool as a cucumber.
You speak slowly and softly, and you avoid...
Chauvin wasn't the one yelling
Again,
shit in Floyd's face and pointing a gun at him.
deal with a crisis.
It is wild that Chauvin is as stoic as what he was.
As this crowd grew more.
Even in the picture that that the defense showed to show his urgency, like he's just strolling along.
Critical thing happens at a very precise moment. And I cannot, in my opinion, understate the importance of this moment, the critical moment in this case. If you recall from Dr. Tobin's testimony, nobody disagreed that Mr. Floyd took his last breath at 8:25:16. 8:25:16. What is happening at the very precise moment that Mr. Floyd takes his last breath?
Chauvin is kneeling on his neck.
And you're comparing it against the rest. This moment, 8:25:16, as Mr. Floyd is taking his last breath.
Get off him now. What is wrong with y'all? What the fuck? He got mace. He got mace.
Oh, he pulled out his pepper spray.
He cannot breathe.
There he got all aggressive. He had multiple use of force complaints against him.
He's not responsive right now. He's not responsive.
Three things happen. Mr. Floyd takes his last breath. You see Officer Chauvin.
The crowd correctly calls it, correctly.
And shake it. He's threatening the use of force as is permitted by the Minneapolis Police Department policy. And Genevieve
as he's murdering somebody
at that time from behind him, startling him. All of these facts and circumstances simultaneously occur at a critical moment. And that changed Officer Chauvin's perception of what was happening. After this point, the crowd grows louder and louder, right? And
well, yeah, they just saw a man get murdered.
Mr. Floyd has
of course they did.
And the question is the rendering of
any reasonable bystander would do that.
When do we stop CPR according to the Minneapolis Police Department's policy? When it's not safe. You heard Lieutenant Mercel talk about this, and you also heard Nicole McKenzie talk about this.
Whoa, 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 whoa. Is he saying they couldn't administer medical help to the guy because it was unsafe because the crowd was reacting to their murder?
She discussed at length the difficulty of performing CPR in what she would describe as, or she did describe as, a hostile environment.
Wow.
Agonal breathing can be confused for effective breathing.
And how many cops did they have on the scene?
People in the area.
And it wasn't probably secured to where one of them could do CPR. Are you serious?
It is incredibly difficult to perform EMS in a loud crowd. Difficult to focus when you don't feel safe. Makes it more difficult to assess a patient. Makes it more likely that you can miss signs that a patient is experiencing something. So the distraction...
Yeah, if I was the prosecution, I'd just get up and fucking laugh.
When we're talking
that
about
was his argument? What?
Decision-making model, right? As Lieutenant Mercel said, he testified, sometimes you have to take into consideration whether it is worth the risk to remove the handcuffs and render medical aid. Because it's unpredictable, right? All of this information is coming at a reasonable officer.
Wow.
The reasonable police officer standard can also be extended to Officer Chang, right? What is his perception of the crowd? You heard him testify, but you can also look at what was he doing during this time?
If I remember correctly, he's just looking around with his fingers in his pockets. I want to say he whistled a few times. Am I more of a centrist? At different times in my life. Right now I'm a far leftist just because that's the... I am fact-based. If you want a channel that is fact-based, you've come to the right place.
Chang, pacing.
I'm sorry if the facts...
Agrees. Right?
Like the facts are overwhelming in this case.
He's focused on what's happening with the crowd. But he also has another job. Right? Reasonable...
The defense has done a
with the crowd.
horrible job. They have played a clip that is...
You can also take into consideration...
not in their favor, not answered the clip well.
Damn, he still won't get in the car. Just sit down, dude.
Well, be sure to give us a sub, a follow, if you so incline.
What is he doing?
If you've got the Amazon Prime and you haven't used your sub, please use it on this channel. You get a freebie every month.
Look, they still fighting. Hey. Oh, man, what is he doing? Oh, they going all around.
Non-police officer and their reactions to what's happening. But also consider the paramedics, right? The paramedics. They did the load and go, right? As Derek Smith testified, he got out of the ambulance. He checked all four corners to gauge what was happening and determined, in his words, that it was an unwelcoming environment. And he told his partner...
Well, yes, the crowd just saw somebody get murdered.
More safe and secure location. Remember, Nicole?
The defense is trying to make the argument that the crowd reacting to the murder that they just watched made it unsafe for them to render aid to the guy they just murdered.
We have all of these different...
It's a weird kind of circular logic.
Right? We have all of the opinions of Seth Stoughton, Jody Steiger, Barry Broad, Zimmerman, Arredondo, David Pluger, Lieutenant Mercel, and they all reach very...
Lex Pfluger, the total package.
When the force became unreasonable.
Oh, I've heard... I spend a lot of time in the comment sections of The Blaze and OAN and Newsmax. I've heard a lot of goddamn dumb shit.
All you have to know...
There's a guy on my personal Facebook page right now arguing with me that was just laughably wrong on his very first point and is still telling me that he's not wrong, even though I had like his words and put the video next to it like, dude, this is the way you describe the video. It is nothing like what you described.
I found the most interesting person to be.
I can't imagine that an EMS would say it was unwelcoming. Remember, we watched the video of the shooting in the hospital, and I commended the nurse because the dude fucking ran. It's like, can I help him now? And the cops threw him back.
Comes from the trainer who conducts the training.
You fucking medical professionals, nurses, EMSs, all the techs, you do a fantastic job.
Don't apply to restraint techniques. He said the knee on the neck is not...
For the most part, our first responders and the people who staff our first responding agencies are amazing, excluding cops.
Depending on the level of resistance you get.
But I would say that about any organization where there's whole departments being busted for covering up child molestation.
Because when people are handcuffed, they can thrash around and continue to be dangerous to themselves and others. He talked about the ground defense program because it's safer for both the suspect and the officer.
He is trying to justify a man that is already dead.
Control a subject without, and therefore replacing the need to punch or strike.
By saying, oh, well, the rules say he can still thrash around if he's handcuffed, even though we already killed him.
That he personally trains officers to put a knee over the shoulder.
I need to quit speaking like that because Twitch is gonna
the neck. And he described
gonna fucking pull me down.
As routinely trained by the Minneapolis Police Department.
I'm quoting them.
He testified that there are circumstances that an officer would need to use his weight to continue to control a subject. he recognized the concept of awful but lawful, right? Sometimes the use
He's
of force
saying
is just not that attractive.
that he would need to use his weight. When we saw one cop hold his legs, have him in a Texas cloverleaf-like position, he's handcuffed.
One way people can resist is through their words.
Fucking Chauvin has his knee on his neck, and he's pulling his arms.
Again, and vice versa. He discussed how officers are trained not just to focus.
He's justifying this on the thought process that he may become resistant.
Officers, that if you're fighting with a suspect and that person then becomes compliant, it is a legitimate consideration for the continued use of force to control a subject. That if a subject overpowers more than one officer at a time.
Oh wow, that's a weird line of logic. No wonder a cop can shoot a kid that complies with the orders and turns around and puts their hands
I
up.
understand that superhuman strength is not.
Oh, well, he dropped a gun next to the fence.
There are no Supermen or Spider-Men.
Apparently, having a gun in your hand will get you shot, so of course he dropped it next to the fence. What?
Someone under the influence of certain types of control.
If he even had a gun.
Exhibit this behavior, they become stronger than they normally would.
I'm aware they recovered one at the scene.
Pregnant mom lifting the car off of someone, right? It's not literally describing us.
Well, I mean, at this point in the timeline that we're talking about, he's already goddamn dead. This motherfucker is talking about the use of force continuum.
And the Minneapolis Police Department specifically trains that. He trains on neck restraints. Minneapolis Police Department has a specific written policy on the use of neck restraints. And
Oh, I'm sorry. That slipped. I don't know how that got up there.
Neck restraint or a chokehold. He talked about how you need to cut off the blood supply for a neck restraint to both sides of the neck. He talked about how someone whose heart rate is beating faster, they go unconscious quicker, less than 10 seconds. He described the human factors of force. That is, how does the use of force affect the officer himself, his cognition, his abilities, his mental and physical.
I can't believe that we have a document, i.e. the Constitution.
MRT.
It's a list of things that the state can't do.
He described that sometimes.
And then people get up and make legal arguments that, like, oh, he was okay to do this because, like, oh, some theoretical
Minneapolis will train officers
fear for his life.
Circumstances. An officer can hold a person in the prone position until the scene is safe. And he's done it himself.
I think the entire thing was
You
unconstitutional.
have to take into consideration the presence of bystanders, where officers are located, and the environment that they're in. Lieutenant Mercil agreed that there are circumstances where I talked about this a little earlier ago, where you have to make a decision. Is it worth the risk to take the handcuffs off to perform medical aid?
No, you just let them die.
Put someone in a recovery position. Depending upon the safety of people, including the crowd.
Because remember, he was accused of a counterfeit $20
Crowds
bill.
can make situations chaotic.
And even the cop described it as, oh, we're charging him with forgery.
That does not mean that you cannot use force. Right? Doesn't mean that you cannot use force. Simply because someone isn't stabbing you or punching you or shooting at you, it doesn't mean that you can't use force.
Now, that is true in a legal sense, and I think that's wrong.
Minneapolis police.
I don't know how many stories I've read about military personnel
force that we've looked at a couple of times
who join the ranks of police officers and can't believe that there is a lower standard for engaging people, engaging American citizens who have legal protection from the Constitution, granted to them by the Constitution, of what the state can't do to them.
Information has to be taken. You have to look at it from the totality.
They have a lower threshold for use of force than our military.
You have to look at it from the...
Because our military has to abide by the goddamn Geneva Conventions.
Officers are human beings, capable of making mistakes in highly stressful situations.
This fucking country.
In this case, the totality of the circumstances that were
I'm pretty sure I ran off the dude that was asking if I was a centrist.
in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt.
Oh, hell yeah.
About being on the panel, right? They have 5 officers on a panel to assess whether uses of force are reasonable. Sometimes it's 4 to 1.
Well, that's the way right-wingers look at it. But I'm convinced they've only read one amendment. They've only read like part of it.
The use of force is not an easy thing to consider.
Shall not be infringed. Oh yeah, what's the rest of it?
You know, again, I'm sorry, I'm long-winded. There are a couple of other
Dude, you're cool.
Very briefly, I promise.
I actually wasn't expecting you to go this long-winded.
First is that concept of.
I think about 2 hours is perfect for a closing argument.
With respect to counts 1 and 2, you have to address Mr. Chauvin's.
I haven't really been keeping up with. This dude's only been going about an hour, hasn't he?
To the instructions.
Thus far.
Words have meaning.
Yes, they do.
Means that the defendant either has the purpose to do the thing or cause the result specified, or believes that the act, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal and that are set forth.
But a quick story. I did consider myself far more. I drifted towards the center when I was in college, amazingly enough.
I see this very
because my other degree besides broadcasting was philosophy. And I became like obsessed with being like logical and everything I say has to be cogent and sound, and I didn't insult anybody, I didn't use any profanity. That's fucking changed a lot. But I got out of college and I was working with this right-wing radio host, and he was just like, everything he did was dirty as fuck, right? But like he had on the Secretary of State to talk about how the
perform an act. Did he
the state has been accused of discriminating against black voters. He had on the Secretary of State.
What considerations do you have?
And the Secretary of State said, well, we can't be discriminating against black voters because in 2018 it was the highest turnout of any election ever, and which is the truth. But they didn't mention the 11 court cases that were currently pending against the state for discriminatory practices such as shutting down driver's license bureaus in predominantly black neighborhoods while requiring ID, shit like that. So he goes and he uses the Secretary of State's quote in a newspaper, or not a newspaper. It's called Yellowhammer News, an Alabama news site. News. But he wrote it as an opinion. It's like passed off as news, and then he shared that back out of his own interview with the Secretary of State, and then shared that out from the news site and said, "See,
do something purposefully."
The Republicans aren't being discriminatory against black voters.
Body-worn cameras,
and it's the whole media operates on that. It's like a symbiotic relationship.
Videotaping you, where you know.
So here he is. They would put him on the TV station I worked for, where I did production.
Where there are surveillance.
They would put him on as their political analyst. This far right goddamn nut job that's doing the bidding of the Republican Party was a neutral political analyst on a TV station.
He said, "I'll sit with."
After we would get finished recording his shit, everybody would gather around because I would point out everything wrong with his arguments, and then I would destroy him.
I won't do nothing to hurt y'all. No, sir.
Like, multiple people were like, I want to watch this on TV, and I'm like, dude, you need to work with me. But he wouldn't work with me because he doesn't want to be called out on his bullshit. Right-wingers will wall themselves off. I still man myself. I want my chat to tell me if I'm wrong on something and show me the facts. Prove me wrong.
None of y'all, man.
Give me the strongest right-wing debater you can. Have them call in, get in the Discord, or I'll go on their show. I don't give a shit.
Okay.
I will go on any stream, any show. I will debate anybody about any topic. Politics or religion, mainly, because I don't really know much about anything else.
Mind, I don't believe me, officer.
Take a seat.
I'm not that kind of guy.
I'm pretty stupid when I can cook.
I'm gonna die in here. I'm gonna die, man.
You need to take a seat right now.
And I just had go.
How prophetic. How and the defense is playing a video once again of a man saying, "I'm gonna die here," to prove that his client didn't kill him. Weird.
3 times. I'll turn on the air conditioning. Is that evidence of intent to apply unlawful force? Officer,
Well, that wasn't the issue, sir.
that Mr. Floyd is under arrest.
Please, man. Leave this to me.
Is he going to jail? He's under arrest right now for forgery.
And once again, the cop accused of fraud in the tens of thousands.
Officer Chauvin.
This dude died over a supposed counterfeit $20 bill. This is America.
Including punches, kicks, elbows, right? All of these tools were available to Officer Chauvin. That is not an intent to purposefully use unlawful force. They call for EMS within 1 minute of putting him on the ground.
I've been trying to wait until they break for recess, but I've got to take a whiz and refill my bong. I will be right back.
He believes that Officer Chauvin believes that Mr. Floyd's ability to speak means he can breathe, and they say it repeatedly. Remember? Excuse me. They tell him to relax.
You're the arrest guy.
All right. Oh my God.
So you go to jail.
I can't believe this.
Officer Chauvin is never swearing at him. He's not calling him names. All of this stuff that we've already talked about, and I don't need to go through this again. All of this stuff that we've talked about throughout the entirety of this circumstance does not reflect an intent to purposefully, intentionally commit an unlawful use of force. All of the evidence shows that Mr. Chauvin thought he was following his training. He was, in fact, following his training. He was following Minneapolis Police Department policies. He was trained this way. It all demonstrates a lack of intent. There is absolutely no evidence that Officer Chauvin intentionally, purposefully applied unlawful force.
I tried to make it quick. This is the part I've been waiting
Chauvin
on.
is also refocusing the other officers.
But I'm totally not stoned enough for this shit.
They need to do things to pay attention to Mr. Floyd.
Let's get him on.
Should I put his stuff in the car? No, we need to get him in the ambulance. Let's refocus, right? Officer.
Yeah, because you just killed him.
No intent to purposefully use, or he did not purposefully use unlawful force. These are officers doing their job in a highly stressful situation. According to their training, according to the policies of the Minneapolis Police Department, and it's tragic.
Well, I will agree to some extent that they were indeed doing their job as they were told to. I think that's part of the problem.
They go to the hospital.
But I mean, clearly his supervisor didn't think he was doing his job as he was trained to.
Call their supervisors. Was this an eminently dangerous act? Was putting Mr. Floyd an eminently dangerous act? We've heard a lot about the prone position. Consider just the basic prone position. People sleep in the
How was it not an eminently dangerous act? We saw the results.
Massages in the prone position. The prone position in and of itself is not an inherently dangerous act. It is not an inherently dangerous act. A prone position during restraint.
I like to get waterboarded with a pussy on my face.
It is routinely trained and used by the Minneapolis Police Department.
But that doesn't mean that I would want to be in that position actually getting waterboarded.
Right?
Horrible analogy.
By Dr. Fowler. 1,269 cases, use of force, one death of a person not in the prone position. Right? These are people, they're looking at people in the prone position. 4,828 consecutive force events. No significant clinical effects on the subject's physiology. Right? We can look at all of the other studies trying to determine this question is putting a subject in the prone position, even with officers on top, even with weight on top of the person, is that inherently dangerous? And the research says no. The practical experience says says no. The prone position, when applied through a use of force, is not an eminent because there is no evidence to support the notion that it is highly likely, that's the standard, highly likely to cause death. There's reasonable doubt about that.
Oh, I didn't say it was highly likely to cause death.
So let's talk
I would say that it is a low percentage that it causes death. But if it is a low percentage that it causes death,
but I have to
it shouldn't be used if there's any percentage that it cause death.
The state neglected to read perhaps one of the most important sentences from the instruction, and why you must read the instruction carefully. Yes, the defendant is criminally liable.
Fucking smothered to death,
all
exactly.
of the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes. If such intervening causes were the natural
result of the defendant's acts. Yes. Thank you for pointing that out.
Were the natural consequences of the defendant's acts, he's liable.
Yes.
Think about it in this example. Police officer arrests somebody. He puts that person on a hot August afternoon in the back seat of a squad car, rolls up the window, turns on the heat, and leaves the person in there, right?
I've seen that happen. They do that.
Officer put him in there and is responsible.
I've seen them do it more than once.
Of his actions. But consider
I think cops do that on purpose.
This officer arrests someone.
Call me cynical.
They go into the back seat of the squad car. They're sitting in the back seat of the squad car, and they have a heart attack. They have a pulmonary embolism. They have a brain aneurysm. Something happens to that person that was not the
it happens
consequence of being
far more often than you'd like to think.
Just a physiological something that happened to that individual. The officer's not liable because it's not in the natural course of events, and it's not the result.
Wait a minute, did he just say
of the defendant's act? Right? So again, read the entire instruction.
So if a cop puts somebody in the back of a car,
is that it goes through,
and they leave the windows up and they turn the heat on in August and they shut the doors, they're not held liable for that.
That the defendant's action.
But if a parent accidentally leaves their child in the back of a car in summer because they're worked to death through our fucking late stage capitalist hellscape,
and called numerous witnesses to try to convince,
they're held liable for it.
Asphyxiation.
So cops have a different standard. Cops are above the law, is what this motherfucker is saying.
The singular cause of death. And why is that? It's because actions that happened before.
That's what he's describing. He is describing that the cops are above the law, and that they are not accountable for any of their actions.
Not the natural consequences of the defendant's actions. You have to focus on the consequence of the defendant's acts. And so the state has tried to convince you beyond a reasonable doubt that the stress of being arrested,
I cannot wait to hear what the prosecution says back to this.
produced as a result of Mr. Floyd's
I'm on the edge of my seat.
resistance played no role. This is what they have to try to convince you. There's no role of that physical exertion. Played no role in this death. They're trying to convince you beyond a reasonable doubt that Mr. Floyd's heart disease played no role in this case.
I'm not trying to convince any. I'd say his heart disease did play a role in his death. Sure.
Played absolutely no role in the cause.
Hypertension may have played a role in it. There are a lot of contributing factors.
Reasonable doubt that Mr. Floyd was not experiencing excited delirium that contributed to the cause of his death.
But when you put a knee on somebody's neck for 9.5 minutes and they have all those factors, it's going to kill them.
Was not.
They would be alive otherwise. Therefore, it's murder.
The state must convince you beyond a reasonable doubt that Mr. Floyd's toxicology played no role in his death. Right? The state would have to convince you,
is he admitting
beyond
that?
a reasonable doubt, that a combination of these pre-existing issues did not contribute to Mr. Floyd's death. That is
once again, I think that's a straw man. They don't have to prove that they played no role.
To testify that the singular cause of death here is asphyxiation. Because
I don't think it has to be proven that that's the singular cause of death.
as a result of the police,
it's the most pressing cause of death.
Liable for the natural consequences of that restraint, of his actions. But if any of these other factors come in...
Was it the prosecution went about 2 hours.
If any of these other factors were substantial contributing factors of Mr. Floyd's death...
So they've gone about the same amount of time at this point in time.
The natural result of the restraint. If a person has...
Yes, it's the other way. He's trying to say that the over-restraint played no role in his death.
In the context of the police restraint... It's not the natural consequence of the restraint. It's the natural consequence of the deceased's actions.
So heart disease is the deceased's actions?
6 experts. Really 5. But I'll include Dr. Baker.
Ooh, he threw some shade. I don't know what that's about because we haven't been watching the whole thing.
Dr. Tobin said that you need to apply common sense to the evaluation of the medical testimony. He testified that Mr. Floyd died exclusively from positional asphyxia, coronary artery disease, hypertension, controlled substances. They played absolutely no role in the death, according to Dr. Tobin. The state called Dr. Eisenschmidt, a toxicologist.
Once again, I'm kind of doubting that's what he said. This seems like a straw man argument. But I also don't know this to be fact because I didn't keep up with the whole thing.
A whole bunch of other
I kind of watched the highlights.
that may or may not have involved an overdose. Right? Remember the ratio where you said, well, no, these are cases, they may have died of something else. They may have died of a gunshot wound, but they had fentanyl in their system. So he gave you these strange statistics, but essentially attempting to try to convince you that these levels are insignificant. People drive their cars around, right? And that therefore
they were trace amounts
in the death of Mr. Floyd. Third,
that's what they love to say, amphetamines, but it was like trace amounts. It could have absolutely been he was taking Benadryl or some shit.
Was not.
I don't know which medicines exactly have amphetamines in them, but there's several over-the-counter.
Coronary artery disease.
I think Benadryl is one of them.
None of that comes into play. He called Dr. Thomas, a pathologist, to testify how she interpreted what Dr. Baker meant. How she concluded that Dr. Baker simply said that the cardiopulmonary arrest is the basic way everybody dies. And she interpreted the reason why Dr. Baker put those...
Well, yeah, everybody's heart stops.
On the
That is kind of like, when your heart stops beating.
For statistical purposes. You put stuff, the CDC...
Or is it the brain? But that's getting a little too philosophical, isn't it? When do you really die? When your
Controlled
brain
substances
stops
played no
functioning,
role.
or when your heart stops beating.
Hypertension played no role. Coronary artery disease played no role.
Or has science answered that, and I'm a
call
dumb
Dr.
fuck.
Baker. We'll talk about Dr. Baker in a minute. And finally, the state called Dr. Rich, a cardiologist who concluded that despite a 90% narrowing of the right coronary artery and a 70%
I would think so.
in the left anterior
He's making these definitive arguments that they said, oh, it had nothing to do with it.
hypertension.
No.
Mr. Floyd had a strong
I would say, like any reputable doctor would talk about contributing factors.
existing and coexisting conditions.
But I mean, we're discussing like what was the cause of death, and it was Derek Chauvin's knee on the motherfucker's neck for 9.5 minutes.
I submit to you that the testimonies of Dr.
I don't see how that's refutable in any way.
and Rich,
And I think that this guy's argument shows that it's not.
reason and common sense. It's astounding.
Okay, yeah, it's the neurological shit that makes somebody like a lie.
Right? Because Dr. Baker is the only person who actually performed the autopsy in this case. He's the only person who performed the actual autopsy. He told you that he specifically avoided watching the video because he didn't want to bias or influence his autopsy. He specifically testified that there was no evidence of asphyxia. There were no evidence of petechial hemorrhaging. There was no bruising to the neck or back above the skin, under the skin, or into the subcutaneous muscles of the neck and back. And he would expect to see those things in a case like this. There was no finding that pressure was applied to the point of Mr. Beck to cause these injuries. There were no injuries to the structures of his neck.
Well, that wasn't the claim they made.
Finally did review the video. It didn't.
I think they claimed that it wasn't the knee, it was the
structures of the neck because
street in the corner of the
turn his head.
pavement pushing up against his chest that
He
restricted
saw
his
no
breathing.
fractures to the structures of the neck, including the.
But that was the cause of the knee
There were
being
no
pressed
soft
against
tissue
it.
injuries to the sides of Mr. Floyd's neck. There was no hemorrhaging or injury to the hypo.
So yeah, that's his argument right now that like because
no
his
evidence of life-threatening injury to the neck or spinal column of Mr. Floyd. There was pulmonary edema.
he didn't crush him with his
lungs, which could be caused by the resuscitative efforts or fentanyl. There's no evidence
whoa.
changes to the brain.
Or not pressing him up against the sidewalk.
Brain injury
To where it was like, as the one medical examiner testified, it was like he had a lung removed.
He said it was an incidental finding. He said his heart was enlarged. Mr. Floyd's heart was enlarged. Right? Dr. Baker, Dr. Thomas, Dr. Rich, and Dr. Fowler all agreed. He found narrowing of the right coronary artery.
And that made the Grinch the hero.
He found 75% narrowing of the left anterior descending artery. He's the person who did he sent out the toxicology samples. Fentanyl level at 11 nanograms per milliliter. Methamphetamine at...
How much is that? Can somebody tell me?
All of these findings that are ultimately relied upon by all of these other experts were done.
And why would you want to get pictures of everyone who defended Chauvin?
determined that
Would
the
you
manner
want to
of
take
death
them
was
soup
a
for their families, perhaps?
Homicide.
Maybe bring them a nice twisted tea to have with their soup.
Medical definition of homicide. It is to be emphasized that the classification of homicide for the purposes of the death certificate is a neutral term and neither indicates nor implies.
I know fentanyl is strong shit. I know that the one time I did it, my dad ripped open a patch. It was like I didn't even know what the fuck I was doing. I'd never even. This was back in like 2004, 2005. Never even heard the name before. And he has me stick out my finger and just a big goop. He's like, here, swallow this.
Is no more compelling.
And I have never in my life been that high.
Through consideration of all available.
And it was like 8 o'clock in the morning when he gave it to me. And the rest of the day, I had the worst headache.
Factors. Cardiopulmonary arrest, complicating law enforcement, subdual, neck.
I know that shit's not to be fucked with.
Other contributing factors are arteriosclerotic and hypertensive heart disease, fentanyl intoxication, and recent methamphetamine use. The term complicated in this is important because Dr. Baker was able to give you...
As I understand it, it's not a significant amount in his system.
Dr. Thomas speculated about what she thought Dr. Baker meant. Dr. Baker was able to tell you what he meant. He defined complicating as an
But I'm not sure. He said the levels, and I don't know enough to even fucking know what he was talking about.
On the heels of that intervention. And he gave you a specific example. He described a person having a hip surgery, and a blood clot comes loose, and that blood clot causes a death. The hip surgery didn't cause the death. The death was caused by the blood clot that complicated the surgery. So as I understand his testimony, what Dr. Baker was saying was that there was an unexpected result. The death of Mr. Floyd occurred during an event where you would not generally expect such a complication, subdual and restraint. He specifically testified, Dr. Baker specifically testified that if he put it on the death certificate, it played a role in the death. If something is insignificant to death, you don't put it on the death certificate. So Dr. Baker's conclusions that Mr. Floyd's arteriosclerotic and hypertensive disease played a role in the death of Mr. Floyd. Dr. Baker concluded that Mr. Floyd's fentanyl intoxication played a role. Dr. Baker concluded that Mr. Floyd's recent methamphetamine use played a role. Right? Dr. Baker described that this death of Mr. Floyd was a multifactorial process. A multifactorial process is how he defined it.
But nothing played more of a role than Derek Chauvin's knee.
Played any more of a result?
No. One did. Derek Chauvin's knee.
Mr. Floyd's death.
Like we're talking about like a pie chart of percentages, and the things you just like mentioned were just factors contributing to it. Chauvin's knee is like 75% of the fucking chart. Apparently, the others wouldn't have even been factors had the knee not triggered all the issues.
And they did not like Dr. Baker's conclusions. And you can see the process.
Is Dr. Baker the one that is being sued for apparently faulty testimony in Massachusetts, I think? I think that's where they got him from.
Talk to a pulmonologist.
Don't hold me to that on any of that shit.
Talk to an emergency room doctor. Not within my area of expertise. Talk to a cardiologist.
One of the defense's witnesses has a pending case against them.
His findings didn't support the notion
for testifying some bullshit in another case.
And so the state did that. They went and hired Dr. Chauvin, right? A pulmonologist. Now, despite all of the information that Dr. Baker has concluded or found during the actual autopsy, Dr. Chauvin concluded emphatically that Mr. Floyd's death was the result of positional asphyxia, right? The pressure of the asphalt, pressure of the...
So this was the family's independent examiner, right?
All of this resulted in hypoxia, low oxygen to the brain. Mr. Floyd was asphyxiated through positional asphyxia. Remember at the beginning of my remarks, I asked you to perform an honest assessment of all of the evidence in the case. And I'm going to submit to you that with no other witness should this be more carefully analyzed. I want to illustrate two brief things that Dr. Tobin testified about, and I want to illustrate how I think that these demonstrate a bias, because you still have to consider.
Peace out, my friend. Pleasure having you in the chat.
I'm going to call it the finger and knuckle testimony and the toe.
I hope there's an America for you to wake up to.
You may remember this slide. Right? But this slide shows George Floyd pushing his fingers against the street to lift his shoulder off
God's work.
The street. That he was pushing his knuckles against the tire. Right? He described what he interpreted.
Yeah, the pictures from the autopsy of his face and his knuckles. I had not seen those until this morning.
To free the right lung to help him breathe. Look at the timestamp.
I couldn't believe it.
Taken from the body-worn camera here. They were taken at 8:19:35. 15 seconds after Mr. Floyd was placed on the ground. Yet Dr. Tobin that he also explained that Mr. Floyd went on to breathe for an additional 5 minutes and 51 seconds until he took his last breath at 8:25. He neglects the fact that at this point, this is the point where we just saw, when Mr. Floyd is taken out of the car and he is actually in the side recovery position for about the first 2 minutes of this.
Yeah, that's where he's saying thank you and talking to the cops, and we saw that he was being completely cooperative.
Not moving. Mama. 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 Mama.
This is after they've
On my right side.
put him down up against the sidewalk.
You're the best guy.
All right.
Yeah, you can see Chauvin grabbing his arm there.
I can't breathe.
There he is trying to push himself up so he can breathe.
Reese, I love you.
Chauvin is pulling his arm.
I can't breathe for nothing, man. It's so good, man.
Why is he pulling his arm like that?
Mama, I love you. I can't do nothing.
Yeah, EMS is on their way.
My face is gone. I can't breathe, man.
Oh, God.
Please. Please let me stay in. No. Please, man, I can't breathe.
Get up on the sidewalk, please. One side or the other, please.
What is up, Rocky?
My face getting bad.
Okay, so we get his legs up.
Oh, that's all right.
Nope, just leave him.
Oh,
Just leave him.
God.
Just leave him. Yep, just leave him.
We're coming up on 5 hours into closing arguments.
Look at my face, man.
The Derek Chauvin murder trial.
You take. This illustrates how
The defense is probably coming to a close here in the next 10 or 15 minutes.
you can.
We'll have a 20-minute recess.
Pushing his body up to try to breathe.
God, this is hard to watch, yes.
But when you look at the evidence compared to the rest of the evidence,
That's one of the main reasons why I didn't do the whole trial.
you see a person who is
First of all, a lot of the shit got my content taken down for when I did cover it during the show.
is touching the ground and the tire at times. You cannot take
Demonetized for having graphic violence. Thank you. It's the state.
because much like the use of force, cause of death has to be considered within the totality.
And also, this is...
And then you may remember
It's hard to sit through all this.
This is Officer Chauvin's foot off the ground. And he described how at this precise moment,
The defense is doing a great job of making the prosecution's case. Yes, thank you for showing this picture.
to the neck of Mr. Floyd. So let's look at this time in the context of the other evidence.
His whole nose was follow them. Why you just sitting there? He ain't doing nothing now. Put him in your car.
At least 30%, right? You can see him pressing up against him. You can see it. You can see he's not just like resting it there. He is pressing it into him.
Was it half a second, a quarter of a second, right? But when you take a single incident, a frame, a single frame, and you add the drama, and you make all of the assumptions, right? Officer Chauvin's...
This motherfucker, he's talking about single frames. He opened his argument when he actually got to the facts. He did a lot of process when he first started his argument.
Presumptions.
He started by showing us frames
based upon theory
of the time leading up until Floyd was on the ground. He didn't start showing us video until the struggle in order to justify the use of force. And he's talking about how just showing one frame, he did exactly that in his own argument.
Sort of adjusted forward and touches this car, right? You can make a lot of informed decisions.
Wow.
How
he showed the 1 minute of the struggle in the vehicle.
Shifting on my left foot.
He showed it from 3 different angles, 3 different body cams, and then showed it from across the street and it was like, look at the car rocking.
And you can see the placement of the toes.
But the prosecution had just played the 12 minutes leading up until that, where Floyd is 100% compliant with them, talking with them.
You cannot take a single frame and draw conclusions. You have to look at the totality. And remember, he said he spent
the exact argument I made about his argument.
His entire testimony is filled.
I'm honest, I did not expect him to go this long because I didn't think that he would. I think he's digging himself a hole.
Be misled by a single still frame image.
But hey, he came up and he said he's going to be long-winded because he's only got one shot at it. Because the prosecution does get to rebut this.
We have to talk about the toxicology. Again, we're not suggesting that this was an overdose death. Right? It's a multifactorial process, as Dr. Baker said.
Everyone deserves a good defense, but boy, howdy, I would have not taken this case.
In this case. And you need, because again, we had Dr. Eisenschmidt who testified that he found...
And that's what I wonder, did somebody jump to his defense, or did Chauvin have to shell out the big bucks? Not that the cops can't raise the money
know about the actual toxicology
for their other fascists, as we found out with Kyle Rittenhouse.
Per milliliter of fentanyl and 0.19 nanograms of methamphetamine. Those are the principal two findings. And additionally, what we know is that the byproduct of methamphetamine, which is amphetamine, was not reported at the levels. Doesn't mean it wasn't technically there, but it was not reported. So
Meat Memory would be a good band.
Values, which signifies that the methamphetamine use was recent. Hence, in Dr. Baker's death certificate, he included the recent methamphetamine use because there was no...
Did it say methamphetamine or did it say amphetamines?
The history of Mr. Floyd's use of controlled...
And how would they know the difference? How would they know that it wasn't over-the-counter?
It's not a character problem.
Medicine.
Millions of Americans suffer from the opioid crisis, right? I mean, it is.
Yeah, it's not something to die from.
This country is facing, but it is significant to understand the history, not just
been there, done that, brother.
Long-term history, but his long-term history provides us with insight on how his body physically reacts to methamphetamine.
My buddy, producer Dave, has a magazine.
Opioid use within the context of a law enforcement encounter. We know from the testimony of Courtney Ross that Mr. Floyd struggled. We know he had been using controlled substances habitually for some time. We know
we make no illusions about what's going to happen.
Mr. Floyd,
should there be a not guilty verdict, right?
Substances said they were Percocets. He was startled by the police, like he was in this case. officer drew his gun in that case.
And make sure all the cops have
Resulted
soup
in a blood pressure of
for their families.
216/160. I mean, that's not just high. That is skyrocketing high. We know from Miss Ross that in March of 2020, they purchased some pills that were supposed to be Percocets, an opioid. But they were clearly
I love
knockoffs.
soup.
She described that. They were clearly knockoffs. She described how those pills made her feel. They kept her up all night, right? The introduction of the methamphetamine. We know from Miss Ross that in March of 2020...
Cutting Percocet with methamphetamine? That doesn't make sense. Something doesn't sound right about that story.
In that instance, she said his
I say as a...
body hurt. His stomach hurt. We know, based on, again, from Miss Ross,
informed
that he was
observer.
clean and sober for some time while they were in quarantine. We know that Miss Ross again described taking about a week before a similar pill to the one that they had back in March. Kept her up again all night, right? She said she felt like she was going to die. We know, again, from Miss Ross,
Why we need to
pills were purchased.
legalize the real drugs so people quit trying to make this
She
synthetic
described
shit.
going to a hotel. While Mr. Floyd went into the hotel, she was on the phone with him. She heard Maurice Hall's voice. We know Mr. Floyd was with Maurice Hall on May 25th, 2020. We heard from the store clerk, Christopher Martin. He described Mr. Floyd as being high. His responses were delayed, right? He may have been, standing around. He may have been standing up. He may have been able to have communications. But Mr. Martin clearly described him as being high.
You're being a lot harder on him than I am.
We heard from Shawanda Hill that when they got back into the car, right, they had a conversation for a few minutes, and suddenly Mr. Floyd...
He's not done a good job, I will admit that.
...has become important. That he's had trouble. They had trouble waking him up.
It has been somewhat embarrassing, yes.
Wake her up. Wake Mr.
But once again, like, what...
Keep him awake.
In his defense, in defense of the defense here,
Heard how Mr. Martin described...
what the fuck argument do you make?
Back to the car.
What, I hadn't thought about it from this perspective. Like, what argument could I make in defense of Chauvin?
He kept putting his head back. And
I don't know if you can come up with anything better than what he's doing.
we know from Peter Chang's body-worn camera that Maurice Hall also described that Mr. Floyd was
at one point in time, Chauvin looked up and he had a smirk on his face. Like, he really thought what he said was good. And I
that whether Mr. Floyd was chewing gum while he was in the store, we can also see he was eating a banana. Right? You bought a banana.
What? You want me to jump in the poop waterfall? Is that what you call a chocolate fountain? Or is it literally a poop waterfall? Do I have Poop Boy back in here? Eating a banana recreationally. Honestly. They made an issue about a banana? Well, I don't get it.
So we know when we look at this picture, right, there's something in Mr. Floyd's mouth. Is it gum? Is it banana? Is it drugs? Nobody knows. Right?
It looks like he's scared to death that a gun just got pointed at him.
Bananas or gum in this incident. We know.
I love bananas.
Pills in the car.
I feel like they go bad too fast. Like, you have to eat all the bananas the first day you get them. Tomorrow it's going to be a brown banana and it's going to be yucky.
Methamphetamine and fentanyl.
And it makes me sad.
That's what was in Mr. Floyd's
So I
system.
don't have. I live by myself, and it's one of the things about fruit. You can't, like, you get a bunch of bananas.
pills that were found.
Not in Mario Kart, it's not, sir.
At some point, Mr. Floyd was handcuffed. His hands were behind his back. It would have been physically impossible to put anything in his mouth at that point. And we know that in the squad car, 320 were pills. We know those pills were analyzed. We know those pills consisted of fentanyl. We know those pills consisted of fentanyl and We know those pills consisted of fentanyl and methamphetamine. We know that Mr. Floyd's
That's some weird fucking
DNA was found on those pills.
Time dilation bullshit.
How much fentanyl does it take to kill?
Oh, God.
This is from the Minneapolis Police Department's training. Approximately 2 to 3 milligrams. Smaller than a penny. This is from the squad car. You can look at these pictures closely.
I remember the story I told earlier. I just did like a whole photo with my dad on my finger, like 2004 or 2005.
There is a video of Mr. Floyd.
It was like 100 milligram patch.
Is being subdued.
And I probably did.
Restrained by the police.
10-15% of it.
Reaches into his bag.
It was a.
He's looking through.
Quite the dose.
We watch it, and then he throws something. Right? We know that Mr. Floyd had drugs in his mouth. We know that some percentage of that.
We don't know that, actually.
Consumed.
And that's also a weird thing to argue.
We don't know how much he took.
Presumption of innocence.
Right? We don't know when he took an earlier dose in relation, because fentanyl had actually started to.
Because I will remind you, he started his closing arguments talking about the presumption of innocence. The presumption that at no point in time did Mr. Chauvin give Mr. Floyd.
Experts to minimize the timing and the amount of illicit drugs that were found.
Oh, how'd that picture get up there?
Bloodstream. It is just simply incredible to me. It is incredible to me. Every single doctor testified that relevant to the absence of signs of fentanyl overdose weren't present because he was alert, he was talking. But it ignores what Shawanda Hill and Maurice Hall says, right? That he was all of a sudden asleep and difficult to wake up. It ignores the fact that the combination of these two drugs, methamphetamine is a powerful stimulant.
See, there's the speedballing argument.
Is a powerful sedative. They use it for surgeries. Every single doctor dismissed outright. No, nothing about this case. Well, it was only 0.19 nanograms per milliliter. It's such a small amount of methamphetamine in his system. It's a vasoconstrictor. It causes the heart's arteries to constrict even tighter. Doesn't matter. Every single doctor just brushed it aside. Said it would have no.
You just said it was such a small amount.
I ask, would any of those doctors prescribe illicit methamphetamine to their patients? Would they give it?
They probably have, sir.
Would they give it to their elderly parents with a 90% blockage of the coronary artery, the right
Oh,
coronary?
probably not in that case.
I guarantee you.
But I'm pretty sure they prescribe it every day to children with ADHD.
Recommend to my patients that they take any amount of illicit methamphetamine. It is.
Well, see, but when a doctor does it, it's not illicit. It's the same thing. But you put that illicit on there, then it's not illicit. You see, like.
Not come into play here.
Half-hour break for lunch. I don't want to interrupt your argument, but
Thank you. I apologize. It's
members of the jury, 30 minutes for lunch, please. Thank you.
Oh, wow.
We're now in a break here in these closing arguments in the state of Minnesota versus Derek.
I'm hungry myself.
Judge Cahill is calling them to just pause, calling attorney Eric Nelson to pause to wrap up once they come back. It's 2:10 in the afternoon in Minnesota, 3:10 here on the East Coast, and so the jury.
Yeah, fuck the lunch. I didn't think they were going to break. I thought.
Here's what's yet to come. Eric.
I thought the defense was somewhat.
The prosecution can address jurors one last time before.
Somewhat close to finishing their arguments.
This is a special report.
The judge's blood sugar must have been dropping.
Casey. Let's go to my panel of guests. Rhonda Colvin, Eugene Scott, and James Homan. Thanks to all of you for being here. James, I want to start with you. This defense is actually lasting a lot longer than many people anticipated it would, because the defense has been fairly perfunctory prior.
I didn't expect it to last that long. I thought they were going to be 30, 40 minutes and out.
Eric Nelson is trying to drive.
Because one of the things that you
Where is he trying to pull at these threads?
He is really repeating himself.
Yeah, Libby, the main
one of the things that you run into is, like, if you just roll on and on and on, you're really going to turn the jury against you.
Officer would do that. You can't just look at the 9.5 minutes that he had George Floyd under his knee. That you have to look at the 17 minutes leading up to that. You have to look at what he saw and put yourself in his shoes.
It was very odd that he just cut him off for a lunch break. I was kind of expecting, like, oh, Judge, I'm 10 minutes out or something. But apparently he still got way more that he wants to do, because he just kind of looked at his book.
The jury instructions in sort of the maximalist way possible.
This delicious food Mr. Floyd will never be able to enjoy.
Sort of
God damn.
Reasonable doubt is the highest standard that there is. Higher than the
you're right, residue
standard to take away your children and that kind of thing. And basically, he's trying to present this to the jury as, if you believe that everything I'm saying is unreasonable, then you can vote to.
All right, I'm going to leave the stream going. I'm going to step away for just a second so I can grab something to eat real fast.
Now, it makes sense that he's saying that. He's the defense lawyer. That's not really what the jury instructions say, and that's why it will be really interesting to watch, coming up after the lunch break and after Nelson finishes, the prosecution's refutation.
Yeah, James, I want to stay on this for a moment, because the way that Eric Nelson is talking about it, he's telling the jury that the state has to prove, prosecutors have to prove beyond a reasonable doubt, that any of these other factors, like heart disease or hypertension or drug use, played no role in the death. And that's not what we've heard the bar of proof is. I was frankly a little surprised that the prosecution didn't object, but perhaps they're saving that for their opportunity to rebut what Nelson is telling the jury right now. Your thoughts on that?
Yeah, absolutely. And I think the prosecution knows they have the rebuttal. They also know that the jury instructions are written out in black and white, that the jury will have them. The judge is going to reiterate them at greater length after the lawyers have finished their presentations today, before they start their deliberations. And so yes, but you're right that it is kind of, it is what he's just saying is the standard is not the standard, but he's trying to emphasize some of the phrases that the prosecution didn't emphasize, to say you have to look at the whole jury instructions. But even that is still, frankly, extraordinarily misleading about what actually is the burden of proof for the state when it comes to the most significant charge, which is second-degree murder.
All right, let's bring in our crime and courts reporter, Keith Alexander, now. Keith, thank you for joining us. What is your analysis so far of these closing arguments?
One of the things that really jumped out at me, when I talk to defense attorneys, I talk to prosecutors, one of the first things they tell me is that 40 minutes to an hour is as long as you have to hold jurors and tell them what your argument is. And so far, Nelson has gone on for over 2.5 hours. And that's very interesting. Also, what's very interesting to me is that Nelson has not really attacked, or let me rephrase, he waited until about an hour and a half or 2 hours into his closing before he actually began attacking the evidence. Usually defense attorneys come right out of the gate and they put up on a board, or they'll say, the prosecution is saying X, but the evidence showed Y. The prosecution said this, and the evidence showed that it's not the case. That didn't happen here. It was very interesting to see that tactic. Also, again, 2.5 hour close. Yes, the government does have more time to do a rebuttal, but how are jurors really paying attention to all of this information that's being thrown out at them by the defense? The defense kept saying over and over again, don't believe what you see. Don't believe what the witnesses said, because they don't have the full picture. So I'm wondering how jurors are really taking all of this information in. It is not until now when Nelson is really starting to attack the evidence piece by piece.
Keith,
I'm really glad that I'm not the only one that thought all those
so much of the
things.
video and the footage. I mean, he was trying to sort of show and highlight different things, but ultimately, it's so.
He really didn't start attacking the evidence until way in like.
This is guilt or innocence because you're.
I think he said an hour. I don't think it was that long. It's about 40 minutes, 45. But I have no sense of time. I'm a stoner.
So we didn't see a whole lot of it played. We saw it played sparingly by the prosecution, but the defense is playing a lot of it.
Libby, you like reading my notes right here in front of me. I was going to say the exact same thing. You're hearing the audio. You're hearing this man in his dying breath call out for his mother again, over and over. Basically said, I'm done. He realized he was dying. And you heard that over and over again. You saw the video over and over again. And
I don't think the defense did themselves any favor playing that shit.
You're saying, is this wise? Just like you said, Libby, is this wise to continue to put this video and the audio in front of the jury over and over again? And the defense attorneys who I talked to said, they would never do that. They would use still.
I'm glad they did.
To show that the foot was off the ground. They would do various things, but you would not use the video and the audio at times even more so than the prosecution. So it was very interesting to hear from the defense attorneys who were saying that was not a smart or wise or astute strategy.
Yeah, let's bring Eugene in on that. I mean, Eugene, really, it's the jury that has to decide guilt or innocence here. But they, just like us, are living through this, reliving it, watching this footage. And Nelson's asking the jury to not just take those 9 minutes and 29 seconds, but think about the 16 minutes preceding it, think about all the context leading up to it. And yet he is playing elements of those 9 minutes and 29 seconds again and again. What's your analysis of that?
Well, it appears that Nelson believes that time spent before those 9 minutes could somehow justify Chauvin's actions. And he wants the jury to understand that and to also believe that. The case that he is trying to make is that 9 minutes with the knee on Floyd's neck was not an isolated time. It was not an isolated incident. The challenge that he has is that even without, even with additional footage and more context, which he continues to lean into, so many law enforcement officers and professionals and academics who understand force and witnesses understand and believe and know that the way that Chauvin behaved was not the way that law enforcement have been trained to behave or are expected to behave according to other Minneapolis police departments. And so what Nelson is trying to get these people to understand is that despite the testimonies of so many people who actually know better, if they see more, perhaps they will understand why Chauvin acted the way he did, and hopefully for them, that will lead to a verdict that benefits Chauvin.
And Eugene, we sort of had a foreshadowing of this by prosecutor Steve Schlescher earlier in the day, this concept of George Floyd having superhuman strength, or the fear that Derek Chauvin had that Mr. Floyd could have superhuman strength. And we saw that sort of foreshadowed by Steve Schlescher, who tried to say very directly to the jurors that that doesn't exist. That's not something real. Really almost saying out loud the sort of whispered or hidden suggestion that this very tall, very athletic black man would somehow be this mortal risk in the mind of Chauvin, not just because of his size and his weight, but also, frankly, Eugene, because he's black. And so let's talk about how Eric Nelson is trying to show the threat that Derek Chauvin believes George Floyd posed.
Well, by showing that additional video, the video, you know, showing a highly vocal and emotional Floyd, it's meant to communicate to jurors that perhaps he was uncomfortable.
Yeah, but we saw Chauvin walking up and he was being all nonchalant about it.
He was so black and he was so emotional, and the challenge to
Chauvin
that,
at no time, other than when he pulled out his pepper spray,
to face is that
even
there's
looked
a
like he was
strong belief
fazed by
among
anything.
people, as has been verbalized through these witnesses, social media, and outcries, that if you believe that people like Floyd are just so in need of
it says right-wingers are morons.
because of who they are and how they look, then
You can get the
perhaps
shirt from the
it's not
freaking
best
shop.
field for you. And so if Nelson is able to convince the jury that Chauvin acted in a way that was understandable or permissible or even acceptable, this could have very real implications regarding what is acceptable in policing in Minneapolis and perhaps beyond the Minneapolis greater area and the state.
Rhonda, I'd love your analysis on anything else you'd like to say about that, as well as sort of the medical testimony that we're eventually getting to here, the medical excuses that we hear Eric Nelson trying to lay out.
Yeah, well, what I've been thinking is that Nelson's closing argument here is coming after Steve Schlesser this morning said, believe your eyes. That's what he told the jury over and over again. Use your common sense. But Nelson is coming in right now and saying, are you really sure what you're seeing is what you're seeing? And he gave a lengthy description during his closing argument about his vantage points in the
Yes, I'm sure what I'm seeing is what I'm seeing.
jurors. And that changes the perception versus the perception.
I love rocking my right-wingers and morons shirt.
The jury and
I highly
people
recommend
also
it.
watching this
Link
to
in the
maybe
description.
question what we've all been very familiar with the scenes of this video. So this is also something he's done before too. Before, when he questioned some of the witnesses,
I've got all
he
new
would play
merch
some
coming
video
now.
and would say,
We've got Troll
are you
Biden.
sure that Chauvin's knee is on his neck,
on,
or
let
is
me
it
show
really
you.
on the back? And then he would ask some witnesses, are you familiar with video bias, that you're not really seeing the full picture if you just look at one angle? So he is really playing this idea that, yes, there is so much video forensic evidence, but it's all coming from different
New shirt
angles,
on the freaking
and
shop.
you just
Troll
seeing what you
Biden.
want to see. So that's something that
Nancy
has
Troll
came up
OC.
before today. But two, I believe it was Keith's point.
And so much
I don't
more.
think it's insignificant that Nelson is going this long, and I think that really stood out to me, because if you remember his opening statements, they were brief. If you look at the number of witnesses that
I'm amazed anybody will still
they
admit
wrapped up their case
that they love
in
George
about
W.
48
Bush.
hours, and to hear him go on.
I thought they all disappeared in
argument, I think,
2006.
speaks to his understanding of this moment, knowing that this is the last effort he really has. And he may even be understanding what a lot of legal experts have been saying about the state's case, that it's pretty strong right now. And I also want to point this out too. I'm not going to speculate, but this is the first time I think we've seen Chauvin with his mask off. And I think that also speaks to the moment, because this is him in front of these jurors who are going to be weighing his future.
A great point, Rhonda. We'll talk more about that in just a moment, but I want to follow on something that Rhonda talked about, which is this question of should you believe your eyes or not? Well, earlier today, prosecutor Steve Schlesser addressed that and said the jury should use common sense and watch the video evidence.
We've learned a lot about policies and procedures and tactics. You have to pull back and say, would, but for the defendant's actions pushing him down, would George Floyd have died that day? Was it drugs? He just miraculously die of a drug overdose in that time? Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense. Use your common sense. Believe your eyes. What you saw, you saw.
Rhonda Colvin, okay, so that was the prosecution, and then as you pointed out, we heard sort of the flip side of that, the defense trying to sort of analyze these moments, hone in on, is the foot off the ground, how long was it off the ground for, etc. I want to zero in on another aspect of this, Rhonda, which is the question of bystanders' role, right, and the people who witness this, their role. Eric Nelson specifically honed in on...
But it's a different kind of bootlicking in Ireland, isn't it?
That Dr. Tobin said he saw George Floyd was essentially taking his last breath.
Yes, I send my respects
Nelson
with
said, well,
by
let's look at
pressing
what
F.
else is going on around that moment. Let's look at how distracted and sort of dangerous seeming the crowd was to Derek Chauvin. What did you make of that?
Yeah, and he played that clip, and he said if you look at that moment, that timestamp of when Dr. Tobin said George Floyd gave his last breath, Chauvin got out his mace and shook it at the crowd, and that indicated that he was feeling a level of threat of this crowd. And Nelson also mentioned that the off-duty firefighter, that was also the moment she stepped forward to try to help or get closer to the situation. So Nelson is saying that Chauvin just assessed the situation in that moment, seeing that the crowd perhaps threatened him, threatened his ability to police the situation. And so Nelson is sort of turning the tables here on the eyewitnesses and their involvement, which again is something that we've heard him talk about before, that a reasonable officer would assess the situation, assess the environment, and use the force according to what he is seeing.
So, Keith, how does a jury weigh all of this, right? So, you've covered so many trials in the course of your career here. The jury's going to hear the wrapping up of Eric Nelson, and then they're going to get to hear the state, the prosecution, make one last case to convict Derek Chauvin. How do you weigh all of this sort of conflicting information and competing testimony?
That's a great question, Libby. A judge will tell the jurors, do not really focus on these arguments. Focus on the evidence. The past month of evidence that was presented before you. Focus on that. You took notes. Focus on your notes during the evidentiary part of the trial. And don't really focus too much on the arguments that are being placed here. But use your own mind, go back to the evidence that you saw that was presented to you. That's what most judges tell jurors to do. A couple of things that also just really jump out at me is that the whole, don't believe what you see or what you saw defense. A lot of people remember that was the argument that defense attorneys used in the Rodney King trial. Remember the video? The defense attorneys argued, don't believe what you're seeing on this video. These officers involved in this scuffle with Rodney King and beating Rodney King. Don't believe what you see. It really reflects back and it harkens back to the whole Rodney King case. And something else that you brought up that was a really good point, and Gene talked about as well. Race was very interesting that race has not come up yet. Everyone else is noticing it. We're noticing it. And I'm sure the jurors are noticing it. But you notice the prosecution stayed away from it. Even the defense, when Nelson talked about a lookout for the suspect, a tall man outside or inside of the store. Well, of course, race was used, a tall black man, but Nelson did not use race. That could really play into the minds of jurors that for some reason, everyone is staying away from race in this trial. And some jurors may try to figure out, well, why is this? What is going on? Particularly when race, for many jurors, believe that race is often an underlying influencer during these type of exchanges between suspect and a police officer.
Keith, stay with us because I want to play some tape for you. This is defense attorney Eric Nelson asking the jury to think about the fact that even police officers are human beings that make mistakes. Let's watch.
All of this information has to be taken, you have to look at it from the totality of the circumstances. You have to look at it from the reasonable police officer standard. You have to take into account that officers are human beings capable of making mistakes in highly stressful situations. In this case, the totality of the circumstances that were known to a reasonable police officer in the precise moment the force was used demonstrates that this was an authorized use of force, as unattractive as it may be. And this is reasonable doubt.
Keith, what's your analysis of Derek Chauvin's attorney?
So that was the crux of his argument right there.
At one point even saying that George Floyd's death was tragic.
Yes, it was very interesting to hear him say that. What basically Nelson is basically saying is that, my client was following the rules, and yes, mistakes happen, but he was following the rules, and he was following his training. And that's what he just kept arguing over and over again, based on what the information that came to him during dispatch, based on his training. It's tragic what happened to Mr. Floyd, but my client was doing what he was trained to do based on the knowledge of Mr. Floyd being as large as he is, the fact that
one that's wrong,
and flailing around, he was doing what he was trained.
And two, we should really reform policing if that's their training.
Against the whole intent. That's also part of why he was arguing this, that he wanted to stress to the jurors that there was no intent here. That even if you think that he was the cause of Mr. Floyd's death, there was no intent. And that's going to be critical, because if the jury comes back with a
okay, well, if there was no intent, then it's manslaughter.
They believe that there was intent for the assault. Remember, it's second-degree felony murder, the felony being the assault, which requires intent. So that's why he continued to harp on that there was no intent here. And so if there's no intent, there was no assault. If there's no assault, there was no murder.
I think it is highly unlikely, highly unlikely that there's a not guilty
Do you
verdict.
hear the defense attorney trying to really rebut any of them specifically? Like, is
hung jury
he
is
really
possible.
trying to push back against murder in the second degree, and then also the other one?
Manslaughter may be the most likely, that they return a guilty verdict on manslaughter.
Trying to convince the jury.
Well, his goal is obviously to get an acquittal on all three charges: murder, second degree, third degree, as well as manslaughter, second degree. But he's right now he's focusing on the intent, the biggest charge, which carries the 45 or
the
so
consequences
years
indeed.
Second degree murder, felony murder. So he's really trying to let the jurors know there was no intent here.
We're going to make sure we deliver some soup
what he was trained to do. So that's
the cops for their families.
Second degree murder charge. Now, in a third degree, which doesn't require intent.
You're probably right, Warlord.
He was doing what he was supposed to do based on his training and based on not only what he saw, but what the dispatchers saw when they came there with lights flashing, sirens going.
But it's possible that they all come in, they all agree on manslaughter, and then have to deliberate on second.
His size, and so again, third degree was not doing anything that was not appropriate based on his training. And the same thing with the manslaughter charge again, that he was not out there doing something that Mr. Floyd's death was not a result of an accident that was outside of what he was trained to do. So that's what he's really trying to get at, is that he should be acquitted, that Chauvin should be acquitted on all of these charges because he was doing what he was trained to do. The
longer it goes, the better it is for Chauvin, probably.
Information that was given to him, a request that he do in terms of restraining a large man.
If they come back tonight or tomorrow,
still at the scene of the crime. And so
then it was just they walked in. It was pretty much unanimous.
So there's no intent. There's no assault. If there's no assault, there's no second degree murder, and that he was really following his orders, following his training, and so that means no third degree and no manslaughter.
So, James, in fact, not only
what do you guys think? Is it likely tonight? Is it
doing what Keith just
is it
laid
going
out
to be
for
later
us
in the
and
week?
talking about how he was following his training. Eric Nelson's also making the case that
honestly, it seems like from the comments over the course of this trial taking place, people are not optimistic about the verdict.
Floyd. But Nelson ticks through some of the other options that he would have as a police officer, that he is essentially saying Chauvin did not do, right? He pumped the brakes.
It would suck if we get a shitty verdict tomorrow.
And he said no, and that gets to the intent point.
It feels weird to try to have a party, a 420, the holy high holiday tomorrow with all that's going on.
He knew
we're going to try to have a little fun.
These other three officers had their body camera on, and he saw that he was being recorded.
I think the Earth is a disc of ice that floats over a turtle's back.
They knew all these cameras were on them. And so that, again, this is just all he has to do is win over one of the jurors, raise some reasonable doubt.
And all of that resides inside of a filament.
He knew he was being taped. Why did he do it? But that's why the rebuttal is going to be so important, because that
I don't think that Chauvin thought he was in the wrong, and he didn't care that he was being taped.
Swayed by
all
that
cops.
kind of cascade of, well, why would he have done that if he, why not punch him? Why not kick him? Why not do these other things that he could have done? But of course, it comes back to this 9.5-minute tape where you can see, his knee, and even Eric Nelson had to keep showing that footage again and again, which is certainly not going to help his client. Because ultimately, especially on the lesser of those 3 charges, manslaughter, it's
ACAB motherfuckers.
Imagine Derek Chauvin getting acquitted based on the jury instructions.
It is, isn't it?
Seeing that video again and again. So I think his kind of a win for Eric.
I think acquittal is very hard to swallow.
Meet the standard for murder 2 and potentially murder 3.
So, Rhonda, we've been talking about how Eric Nelson has been playing a lot of video, and he has shown over and over again George Floyd fighting and refusing, begging not to be put in the patrol car.
Creed, you probably shouldn't say that on Twitch. That will get you a visit from law enforcement, especially nowadays.
And then Nelson even showed that video of the vehicle sort of rocking back and forth as the officers were struggling with George Floyd. Contextualize that for us in terms of both Nelson's strategy and also how that may play to the jury.
Yeah, Nelson pointed out that when Chauvin arrived on the scene,
everybody is just on heightened alert. If you didn't know, there was a rapper that took like his promotional guy out in New York City. They had a T-shirt cannon on top of their Humvee. Boy, did the cops fucking swarm them.
He had been with the police department for the longest. The other officers that we will see go on trial.
Well, I got news for you, Rocky. It's not legal where I'm sitting right now.
On the force, so. Nelson is saying, as an officer who was taking that into account as well, that the other officers didn't have as much experience, he comes on the scene, he sees this chaos, he also sees a group of bystanders standing there, so he's taking all of that into account in his decision.
I've got multiple friends who have been saying that we need to get our vests and our boots, our combat boots ready.
That critical thinking, that this was the scene
yellow
he came
vests.
onto. It looked chaotic, and that's why he acted as he did.
Well,
yes, tomorrow is 420. It is the Troll Patrol Live 1-year anniversary spectacular and 420 celebration.
And an officer may know that sometimes people fake injuries to avoid arrest. Let's watch that.
We will be taking the air at 4 o'clock Eastern Time tomorrow.
His training.
We are going to celebrate 420 all across the country.
And many people.
I'm going to smoke out of a different bong every 420. I'm going to break out my gas mask. I'm also going to drink. I don't ever drink on the stream.
A medical emergency.
I think it's happened, twice?
Arrested. Unfortunately, that is the reality.
I'm going to drink on the stream tomorrow. I have a 6-pack of Angry Orchard.
How many times does someone my heart hurts?
I have some hard apple cider.
Emergency. Insert whatever emergency. Right?
It would fucking suck.
Want to go to jail?
Because I want to burn something tomorrow, and I don't want it to be the country.
Training into experience, and you heard Lieutenant Mercil specifically say.
Don't want it to have to be
that they
all the police
breathe, but they are talking.
Precincts across the country.
If they're talking, it means they're breathing, right?
Eugene, let's go to you for this line of logic that Eric Nelson is presenting, because he did show repeatedly that.
I don't know if I would call it logic at all.
Sort of how Derek Chauvin was not responding.
Seriously, his conclusion was that cops are above the law. There is nothing a cop can do.
Force wasn't excessive, and he seems to be arguing
that isn't acceptable.
What Floyd was saying was that my breathing is in jeopardy. I cannot breathe as clearly as I would be in any normal situation.
I was not expecting this to go this long at all.
The fact that Floyd was not able to breathe as clearly as he would have because there was a knee on his neck for 9 minutes. And so whether or not Chauvin was acting in a way that actually took away.
Yeah, I don't know what the logic is, and I'm sure people fake medical issues to try to get out of arrest.
Was harmful.
But I mean, it doesn't work that way.
Thought it was reasonable. So many other professionals.
I just ate a salad. Where were you?
That it wasn't, and that is what.
Right when the judge broke for lunch, I ran. I put together a salad. I came back. I wolfed it down real fast.
That so many people.
I'm good to go
saw
now.
with their own eyes
I'm getting high again. I'm not high enough for this shit.
We've gotten from our colleague Holly Bailey, who's of course one of these reporters.
Well, it was like the last of my lettuce. It was the last of the cucumber. Like the end of it was kind of.
James, let's talk through
old
what
too.
we know from the pool.
It had some fried onions in it, and it was my homemade blue cheese dressing.
And she's writing that the jury began to look weary, according to the pool report.
So it was just a thrown together because I went over there and was like, "What can I fucking eat real fast?"
And at that 2-hour mark.
Oh, I've got blue cheese dressing in a bowl. I can just throw some shit in there.
Now, we did see Eric Nelson sort of apologizing a couple of times. And
yeah, it was just the last of my lettuce. I'm going to need to get more lettuce
because I was reacting to them seeming.
I kept meaning to order groceries because I wanted sour cream because I've got a panini press grill thing now, and I've been making quesadillas on it, and they're fucking awesome.
Had these breaks to help,
but I didn't have any sour cream, so I kept holding off on.
So it seemed a little abrupt when the judge said, "Okay, wait, we got to take
making my quesadillas because I wanted sour cream."
I'm sure that's exactly.
By the time I ordered groceries, my fucking lettuce had went bad.
He interrupted. It had sort of felt like Nelson might be getting close to wrapping up a couple of times there, and it is interesting, when you think about the morning speech too.
I could have sworn he was getting ready to bring it on home.
And paying very close attention for the first.
I was also surprised he didn't stop the judge. Like, okay, I'm almost finished. Hold on.
It started to get repetitive, and the jury does sort of start to tune it out. To some degree, Nelson wants to use that to his advantage to create this perception that there are all these holes or gaps. He obviously doesn't want to be so boring that he antagonizes.
What would I go to jail for?
But he wants to make it just seem like there's this mountain of reasons to be skeptical.
I don't leave the house. I'm here in my own prison.
That one or two of the jurors picks up on one or two things. Essentially, what Nelson's closing argument has felt
like. It's actually not true. I went out to a pawn shop the other day.
A bucket of spaghetti against the wall to see what sticks, and hoping that one of those little threads can.
I can just order more lettuce. That's not a big deal.
Case clearly, ultimately, that
I feel sorry for people that don't have
kind of bored.
Grocery delivery.
But that's something that Nelson is certainly acutely aware of, which we gathered from his repeated apologies.
That would have been like the whole reason I had kept my vehicle.
Yeah, Keith, tell us more about sort of this.
When I got rid of it.
Here. I mean, if you're defense,
I can get groceries delivered. Why keep a vehicle?
The prosecution in terms of trying to, just give jurors something to hang on to when it comes to reasonable doubt.
You use the word hang. I think that is what Nelson is shooting for. I think he's shooting for a hung jury. I think he's really hoping that at least one.
He is looking for the one person on that jury
be a holdout for.
That is a cop cocksucker apologist, bootlicking son of a bitch that is looking for any reason.
Throwing all the spaghetti against the wall and see what's
any reason.
Drugs. I mean, is it the heart condition? Is it the fact that the crowd was intimidating the police officers and the EMT?
I should have never sold my truck.
Didn't do anything.
That is the worst decision ever made in my life.
The juror, if you think one of these reasons,
I should have kept the truck.
In the death of Mr. Floyd, then you cannot convict my client. That's what Nelson is shooting for. But again, as I said before and previously, even the judge,
I would have still been driving my truck back and forth
those other factors
to the grocery store to this day.
That Chauvin also played a role, you can still find Chauvin guilty. However, if you believe that the heart condition was even greater impact than the knee or the drug condition,
here we go,
a larger role than the knee, then yes, you can't.
I'm certainly not high enough for this shit.
There, because Judge Cahill is back, but thank you so much. Let's go back to the courtroom now.
I apologize again. I promise I'll try to speed things up here again. So
he's still got a while to go. Damn. Shit, I'm gonna have to get comfortable. Fuck.
Anybody technical issue?
I'm sorry, Rocky. Well, at least you're here with me. You know I'll mock whatever he's saying. Talk about bullshit. I was gonna stream my my little run through of Resident Evil 8 demo the other night.
So we'll just go off notes instead of the PowerPoint. Before the break, we were talking
poor guy.
Controlled substances and the role that they were the levels that they were found in, the role that they may have applied or contributed to Mr. Floyd's death. And I was suggesting to you that it is, again, this death needs to be looked at. Mr. Floyd's death needs to be looked at as Dr. Baker described.
Oh man, Schumer's speeches.
This is the way that
I do not like Schumer's speeches at all. He's fine in little doses.
The brain controls.
But to listen to him talk for 20, 30 minutes is just, oh my.
And to simply come in and say, this particular substance.
Like you look up the term shitlib in a dictionary
when
and
taken
you see
in
Schumer's
combination
face.
with each other, when taken in combination with a person who has blockage in the heart, substantial, significant blockage in the
I can take him in press
we know
conferences.
that these
I
drugs
cannot
play
take
a
floor
particular
speeches
role
by Schumer.
in how the blood circulates, to just poo-poo it and say it has nothing to do with anything is just really a preposterous notion. Yet Dr. Baker, Dr. Fowler, and Dr. Thomas have all certified deaths at levels less than 11 nanograms per milliliter or 19 nanograms or combination.
Well, okay, I would take him 100% over Dick Durbin because I agree with him more on policy than Dick Durbin.
It didn't necessarily contain any of the other issues that were confronting Mr. Floyd on that day.
Or at least as of late.
Again, every other doctor that has
Chucky Boy has been at least signaling
Mr. Floyd's
a turn to the left.
Forensic pathologists define coronary artery disease resulting in death. Death can occur with 70 to 75% blockage. That is sufficient to cause a person's death. Every pathologist who testified in this case has indicated likewise that they have certified deaths with those types of blockage and attributed it to the coronary artery disease. Yet here again, this has played zero role. Dr. Rich testified Mr. Floyd had a healthy heart. Coronary heart disease, not.
Oh, fucking Kristen Cinema in 2006. I had the biggest crush on her. Oh my god!
Already heart.
She was my waifu. Holy shit! I do not know what has happened to her.
Body, not relevant. What is adrenaline?
And she posted a picture over the weekend of like her drinking sangria, and her ring said like "fuck off" or some shit, and she's like,
"Didn't happen."
Oh my god, she's so pretentious. What the fuck?
Ignore significant medical issues that presented to Mr. Floyd, and the failure of the state's.
I'm man enough to admit my mistakes, Rocky. That's why you should. Why you should consume my media. I'm man enough to admit that I was president of the Young Republicans when I was a senior in high school, and that I had a crush on Meghan McCain.
Now,
Meghan McCain and I are the same age. I was a John McCain supporter in the 2000 primary.
Resulting in going to the brain, low oxygen to the brain. Dr. Fowler.
We all make mistakes. It's okay.
Death through hypoxic death, but
now my wafu is Rashida Tlaib, so I think I've moved up in the world.
Arrhythmia. The reasons that Dr. Fowler
or Madison Star Moon
brain hypoxia are because number one,
you guys
hypoxia
have been over at Echoplex and know who Madison Star Moon is.
Symptoms. The brain demands
She and I have been dating for a while now.
It takes 20% of our oxygen to function the brain, even though it's it's a smaller percentage of our body. It is the most sensitive to the loss of oxygen.
In the late 2000s, I had a gigantic crush on Benazir Bhutto,
which was not exhibited, right? Because if you compare the testimony about whether Mr. Floyd was intoxicated, well, he didn't exhibit any confusion.
Former president of
restlessness.
God, I don't know if it's called president. It might be a different title. Might have been prime minister.
Also a sensation that can be caused by a sudden cardiac arrhythmia.
Amy Klobuchar is the biggest fucking Karen in the Senate. Honest to God.
Incoherent speaking. Not
Hold on, I might be able to think of one worse.
Someone is experiencing hypoxia to the brain, as Dr. Tobin stated.
Nah, Klobuchar is probably, because I wanted to say Susan Collins.
Ventilation or respiratory rate.
But Susan Collins actually seems nice.
It is a completely normal.
Oh God, that's. Cinema is like she's not a Karen because she's a millennial.
The timeline in this
she's like in my generation. I see Karens as like a late Gen X baby boomer kind of thing.
Mr. Floyd speaks.
Cinema is like a Molly. That's a millennial Karen.
If you can speak, you have oxygen in your brain. At 8:24:09, he again verbalizes, "Please, I can't breathe," indicating at 8:24:09 that his brain has oxygen and there is no impairment to his airway. 39 seconds later, Mr. Floyd goes limp.
Cinema's a Janus.
A person can hold their breath for 39 seconds, right? That does not result in hypoxia in 39 seconds. 27 seconds later, according to Floyd, takes his last breath. It's a total of 66 seconds, 1 minute and 6 seconds from the time that we know there's enough oxygen in his brain to speak. No occlusion to the airway at that point. 66 seconds from his last word.
And like, what do you guys think? Has the jury just completely tuned out?
Is consistent with a sudden cardiac arrhythmia.
I'm sure it was like the shittiest take possible on something.
Of brain hypertrophy.
She's got that club mentum.
Dr. Fowler's final analysis was that Mr. Floyd died.
She's totally going to run again, isn't she? She's going to be in the primary next time.
Atherosclerotic and hypertensive cardiovascular.
Oh, maybe not. Maybe not.
Restraint by police. Other significant.
If Biden runs again, she won't be. But if it's an open primary.
Ketamine intoxication, possible CO, carbon monoxide exposure.
Like, look, we've all tuned him out, and we were paying attention before the break. Surely the jury is doing the same thing, right?
No, nothing was ever.
Oh God, you just described the most horrible ticket.
Is concerned. We don't know if the car was emitting carbon dioxide, carbon monoxide.
Honestly, because I would take Warren, I'd take Booker, I'd take fucking anybody over those two. Buttigieg and Klobuchar are about the worst the Democratic Party can muster.
He puts it in gear.
At least Manchin has like a good.
Never touches that vehicle, and he gets the car.
Now, at least I can make a case for Michelle Obama because she is a likable individual. You can look at polling data and say, okay, well, at least there is something there for her.
The superseding cause that was discussed.
I don't think Michelle Obama would be on a ticket with Kamala Harris because of.
That comes after the Defendants Acts. Alters the natural.
I think the Obama family has egos. I don't know that Michelle would ever want to be a political figure.
Let's look at the medical timeline here. We know that EMS was called.
Do you think that Kamala Harris is sitting there thinking like for sure she's going to be the first woman president?
21 and 35 seconds.
Because it's that kind of hubris.
We know that EMS responded
that like bit Hillary Clinton in the ass.
Based on the videos at 8:27 and 27 seconds.
I was just saying on the Democrats, and you got it backwards. It would be DeSantis Cotton.
It takes approximately.
DeSantis is the front runner right now. Absent Trump and the Trump effect, DeSantis is the front runner.
The ambulance pulls away from Cup Foods at 8:30.
I've been calling that for weeks.
Fire responds to...
I have seen a coalescence around DeSantis like I have not seen around any political figure in a long time, and it honest to God boggles my mind.
The 3-minute expectation of Ms. Hansen. But
I don't get the appeal of DeSantis.
Blocks away to 36 in Park.
God, yeah, you fucking DeSantis is fast as fuck.
And 8:33. That's 1.5, and we know that because there are 2 exhibits.
That's what that's why he worries me.
3 that were introduced.
He is Trump but competent.
1 paramedic and officer laying in the back.
Because that's the thing, is like we are so fucking lucky that Trump was just a complete fucking idiot.
3 minutes to get to...
And he turns on everybody.
And the resuscitation.
If he had schmoozed with some people and had some support...
Mr. Floyd, per Dr. Tobin, at 20:35.
If he was a smart motherfucker and not just completely up his own ass all the time, we would have lost this fucking country.
7 minutes and 46 seconds after EMS responded to...
Oh, God. There are so many bad people on the Republican side that could be picked. Like their whole pool of stars. I'm glad Gates is getting taken down.
36 in Park at 8:48 and 23 minutes. It arrived at HCMC at 8:53.
Boner himself is a legislative terrorist.
So it took about 5 minutes to get from 36th and Park to HCMC. What if you...
I saw him on something the other day.
If EMS...
And he was like, both sides have their... the far right and the far left are both to blame. The far right and the far left, blah, 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 blah. We both have our crazies on both sides.
I am not suggesting to you.
You've never heard anyone call him Boner?
Suggesting to you that the ambulance paramedic...
I honest to God think I stole that from Randy Rhodes.
Raises the prospect...
She was a... she still is. She's on YouTube. She's a political talk radio host out of Florida.
Administered Narcan.
And
would not have...
Oh yeah, you're over in Ireland. Yeah, she was on Air America Radio. I had Sirius satellite radio, XM, whatever the fuck.
Importantly,
all through the 2000s.
In this analysis,
I used to travel for work, so I had satellite radio. I used to listen to talk radio nonstop.
Stressful situations that they believe to be right.
And since I've been a radio personality since I was 16, and I love fucking political talk radio, I couldn't ever get a actual radio station to hire me, so
what should have happened?
I can do it myself.
Lots of them.
And I can cuss and shit. Ha
We have to analyze this case from the perspective of a reasonable police officer at the precise
This is so much better.
Totality of the circumstances when it comes to the use of force. We have to look at the cause of death to determine...
You know, I haven't heard much from John Barrasso.
...of asphyxia or...
I'm sure he's a dickhead.
...other contributing factors.
Well, like you asked that question, you know which senator is such a fucking dickhead?
Were set in motion before...
Like, you could have just, like... John Kennedy.
The bad heart.
Fucking Ben Sass.
Hypertension.
We can go on and on and on.
These things existed before Mr. Chauvin arrived. The struggle. What role did the struggle...
I honestly am not a fan of very many senators at all. We don't have...
Mr. Floyd's heart...
I can name one I really like. His name's Bernie Sanders.
19 over 160 in a situation...
There's a few others I don't mind so much.
Ingested drugs. He didn't die that day.
We keep saying the literal words. We can just go on and on and on. Ted Cruz is horrible.
Presumption of innocence.
Josh Hawk, God, fucking Josh.
Proof beyond.
I used to be worried about Tom Cotton, but like he is kind of a yokel and doesn't.
None of these.
He's playing folksy because all these guys are fucking Harvard, Yale shit. They're all elitists.
That is not reasonable. And when you, as members of the jury...
Yeah, I haven't been paying any attention to Eric, have I?
When you review the entirety of the evidence, when you review the law as written, and you conclude it all within a thorough, honest analysis, the state has failed to.
You know who I want to get rid of? Dianne Feinstein.
And
That woman needs to be booted from the Senate.
Mr. Chauvin should be found not guilty of all counts.
Oh shit! Here we go.
Thank you.
That was it. Well, how long have we been back from lunch? Why didn't he tell the judge he only had 10 or 15 more minutes?
So we're going to send you back to your room for probably about 5 minutes.
Yeah, why didn't...
We're watching here to see what the judge is doing. We'll bring that to you if it's something that we can broadcast audibly to our audience. This is live coverage from the Washington Post, a special report covering these closing arguments in the trial of Derek Chauvin. Yet to do today are the final rebuttal from the prosecution.
You make it, well, I mean, he tried to plead guilty and the Trump Justice Department rejected him.
They go into deliberations and will be sequestered.
Now, I don't know if there were any other...
For a curative instruction, there's no need to go into chambers. What's your motion?
Your Honor, the state request.
Oh, you can be seated, but we need you near the microphone.
Thank you, Your Honor. Your Honor, the state requests a curative instruction as to the issue of intent. I believe that the counsel made a misstatement of law when he indicated and argued that the defendant had to intend to apply unlawful force, as in he had to intend that the force he was applying to be unlawful. That's not a correct statement of the law pursuant to Dorn at 887 Northwest 2nd, 826. The state need not show that the defendant meant to
Perfectly reasonable objection.
that she would violate the law. But that is what
I don't know if it's actually an objection.
Argued before the jury. And so we're requesting the court give a curative instruction to the jury.
Curative instruction.
As follows. That it is not necessary for the state to prove that the defendant intended to act unlawfully, only that the defendant intentionally applied force to another, that this application of force was unlawful, and that this application of force resulted in bodily harm. I believe that is a correct statement of the law.
Which is contrary to what the court instructed.
You know, that does kind of look like Keith Ellison.
Set of instructions.
Your Honor,
you might be right on that
the
one.
court's instruction was that the intentional infliction of bodily harm requires the proof that the defendant.
No, maybe he's a little too young to be Keith Ellison. I think Keith Ellison's a little more
force
gray.
To another person without that person's consent.
But probably somebody from the AG's office.
Bodily harm. You did not instruct that the defendant need to intend that his force be unlawful, merely that he intended to apply the force, which was unlawful.
I'm going to deny the request for curative instructions. I will reread
denied it.
Rebuttal statements of judge and attorneys, which starts at the bottom of page 2 and goes on to page 3, which specifically states that if an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. I'll reread that, turn it over to Mr. Blackwell, who I assume will answer this exact question, or this exact issue in his rebuttal.
We do ask the court's guidance on another issue, and that is when Mr. Nelson argued, quote, Mr. Chauvin thought that he was following his training. There was no testimony from Mr. Chauvin, and he didn't argue that they could infer that. He argued that they thought that. Placing that in context puts us in a difficult position in that we can't comment on his failure to testify, but that statement is directly at odds with the evidence in the record.
Mr. Nelson, any response?
Read the quote, Steve. Excuse me,
Mr. Chauvin thought he was following his training.
What was the context I said that in?
Well, it was in your use of force discussion, and you were talking about a reasonable officer following his training. You indicated that Mr. Chauvin thought he was following his training.
Well, I mean, I thought it looked like Ellison at first, but then, I think Ellison's a little gray.
I don't recall saying it, Your Honor.
He's got gray in his hair.
Even if you did, it was drowned out by a reasonable officer. I think it's a reasonable inference to draw from the evidence that exists. Even his statement to Mr. McMillan essentially was an indirect way of saying he was following his training, it's a reasonable inference for counsel to argue from the evidence. And to respond to that specifically by saying there's no evidence would in fact be commenting on his right to remain silent. So bind the state is all.
Oh, it's fully black. Okay. I haven't.
The other issues you can talk
since
about.
He
quoting what the elements.
He was in the
are
Senate,
on
right?
assault
Since he
in the
left the
third degree,
Senate.
and also anything else that you think was a mistake.
No, he was in the Congress.
I will read them the statements of judges and attorneys if you wish. And actually, before I do that, do you want me to read that?
Yeah, he was in the Congress. I had to think about it for a second. I haven't really kept up with him since he left Congress.
I don't want to force it on you, but that would be is to remind them that any statement of the law that differs from mine should be disregarded.
And it would also ask that you reread the instruction on causation, because I believe that what Mr. Nelson argued was that the state is required to prove beyond a reasonable doubt that the other issues that he spoke about had no effect, right? Had no causal connection, and that is not the law.
I'm not going to single out that instruction and re-instruct on that. I'm just going to read him the general one, that if it differs, and I'm sure Mr. Blackwell is going to point out in great detail how Mr. Nelson misstated that.
Yes, Your Honor.
All right, bring the jury back.
Well. I mean, I thought they were reasonable requests. It looked like the judge
jury's coming
denied
back
all
in,
of
and
them.
then we'll hear this rebuttal by the prosecution. Interesting to hear what the judge will allow and will not allow. It sounds like it's up to the prosecution.
I didn't like the way he talked to
on what they should consider. Let's listen.
Because I haven't watched the whole trial, but I will say we watched the clip of the one witness, the young lady who was a EMT.
Essentially about the nonsense.
And he was a real asshole to her.
In this case, and it is improper.
I know what you're going to say. We'll hold that thought. Be seated.
But also, I do not envy any of these people, in all fairness. Like, the immense pressure everyone in this is under. I mean, except Chauvin.
You may get the state's rebuttal.
Like, everyone in the legal system involved with this.
Before Mr. Blackwell begins, I'm going to reread one of the instructions. And that is specifically that attorneys are officers of the court, and it is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard that statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement.
Damn, you've really been keeping up with this.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Last lawyer, I think, talking to you with closings will be...
This is the first time I've heard him speak.
Won't be too long. I'm going to start talking to you about what I call the 46th witness. You actually have heard from 45 witnesses on the stand, but there is a 46th witness. And this witness was testifying to you before you got here to the courtroom. They testified over everybody else's testimony on the stand. It's the only witness that will be talking to you when you're back in deliberations. And that witness, ladies and gentlemen, is common sense. Common sense. We'll continue talking with you all the while, because while you've heard hours and hours and hours of discussions here in the closing, ultimately it really isn't that complicated in what it is you have to decide with respect.
I like him this far.
The excessive use of force and the issue of causation. In fact, it is so simple.
And he seems incredibly likable.
The child did understand it when the 9-year-old girl.
Just first impressions of why you might want to put him up.
That's how simple it was. Get off of him.
Especially if you're coming up on a jury that's really tired.
To continue
3 weeks of this shit, and then Nelson taught for what, 3 hours?
Who is handcuffed, who is not resisting, who is not breathing, who doesn't have a pulse, and to go on and do that for another 3+ minutes before the ambulance shows up, and then to continue doing it. How is that a reasonable exercise?
Oh, really?
In the use.
He just seems so likable.
You can believe your eyes, ladies and gentlemen. It was what you thought it was. It was what you saw. It was homicide.
He's a plain talker. I think he was perfect for the rebuttal.
Assessment. Look at all the evidence. Consider all of it. Reasonable officer. Reasonable officer is not magic words that you simply apply to Mr. Chauvin, and then he becomes a reasonable officer because you applied those words. Reasonable is as reasonable does. And here what you saw wasn't reasonable, and you didn't get the whole truth. Notice how when you had the discussion about reasonable officer,
Chauvin's mask is back on.
The whole narrative cut off before we got to the point that
As
Mr.
the Washington
Floyd
Post reporter pointed out, that might have been the first time that we saw Chauvin without his mask.
He didn't have a pulse, and that Mr. Chauvin
got it back
was still
on
top
now.
of him, even when the EMTs showed up, and he still didn't get off of it. How is that what a reasonable officer does? And then if you look at the totality of the circumstances, which you heard so much about,
I
tell you exactly.
I love people that fight for the wrongly accused.
Talking about reasonable officer. Now, you heard any
The
number of
Innocence
other
Project is one of the
and looking at the totality of circumstances and trying to do an
organizations that I'm on
You
monthly
didn't get the whole story either.
recurring donation
You got bits and
to.
pieces and parts. And I call them a story, ladies and gentlemen, because it's either completely not true or the facts have been altered in order to make a point to you, which also makes it a story. What you're going to reach when you all deliberate is a verdict. Verdict is a Latin word that means the truth. You're not going to reach a story when all is said and done. You'll be getting at the truths. Why are we engaged in telling stories when we've heard evidence, facts from the stand? Why is that? But you just heard a number of them. I'll give you a few examples of the stories. You were just talked to about how safe the prone position is. And you've heard this in the trial. The prone position is safe. Here are the Canadian studies. After everything you've heard, you already know now that not a single one of those studies ever examined anybody who had a knee on the neck. You know that. You also know that about these so-called prone studies. None of them.
I didn't know it because I haven't watched the whole trial, but I'm glad you brought that up because that was one of my questions.
That is, how is the oxygen actually being affected by putting somebody in the prone position and any amount of weight on them? They never even measured it. You know that too, although that wasn't brought up when you were being told about the studies to show that the prone position is safe. You heard again about excited delirium. There was not a single witness who sat in that chair.
Seriously, I love this guy.
Who told you
He needs to run for office.
Mr. George Floyd suffered from excited delirium. Not one.
I would donate to his campaign.
Of the criteria for excited delirium is the person's impervious to pain. They don't feel pain. They're not people saying my neck hurts, my knee hurts, everything hurts. They're not grimacing because their wrist hurt for excited delirium. That's a fact. If that's a fact, why are we talking about it? Why isn't that said if you're going to be hearing about excited delirium? Then we turn to Dr. Baker, for example, where there's a discussion of homicide, and you were told that homicide was a medical term. That's not what Dr. Baker said. Dr. Baker said homicide means killed at the hands of another. It means at the hands of another is what homicide means. At the hands of another. And he was pretty clear.
The legal term, isn't it? It's not a fucking medical term.
He said it was cardiopulmonary arrest, complicating law enforcement, subdual, restraint, and neck compression. And he did explain what complicating means. He said it means in the environment of. So it reads as though it's called cardiopulmonary arrest in the environment of law enforcement, subdual, restraint, and neck compression. What you were just told, and that was attributed to Dr. Baker, is that somehow he meant that this was an unexpected result. It was an unexpected
Seriously, this motherfucker came up here
law enforcement, subdual,
juxtaposed to Nelson's word salad
restraint and neck compression
that went on for 3 hours, and he's going to be plain talking 20 minutes, boom.
Not the mind of any police officer. It is not what he said. They were simply words that were put into his mouth, but you check your notes on what his testimony actually was.
Now, Blackwell has been nailing it, man. Like, he's won me over so
You've
much.
heard now for the umpteenth time in this trial What is the evidence on autopsy for asphyxia? If you're looking at the body tissues, you've heard it from witness after witness on the stand. I even pulled out big, giant, thick textbooks that even Dr. Fowler, the defense own expert, says these are reliable authorities on it. Every one of them says that in half or better of the cases where somebody has clearly died from insufficient oxygen, you don't see any evidence in the body tissues. Ladies and gentlemen, that's a fact. Now, if this is supposed to be about performing an honest assessment, looking at the totality of the evidence, how is that not mentioned to you in summarizing the evidence? How is it not mentioned to you? And I can't even stop there, because you were also told about the law that applies to this. You first told by Judge Cahill, and no question that was accurate. But then you were told by Mr. Nelson, no question that was not accurate. I'll tell you what I mean. When he was talking about causation, and he talks about fentanyl, heart failure, hypertension, and he said that we have to show beyond a reasonable doubt.
Blackwell is amazing. This is my first exposure to him.
Played a role. That's not the law. And you don't have to believe me. You'll be able to read it yourself. You'll have the instructions.
This is the perfect juxtaposition up against Nelson's fucking bullshit to just come up, plain talking, lay it down,
substantial causal factor,
short, concise, sweet, perfect.
Doesn't have to be the only causal factor. Doesn't have to be the biggest substantial factor. It just has to be one of them, a substantial factor in the cause of death. And the instruction will say that the fact that other causes contribute to the death does not relieve the defendant of criminal liability.
Yes.
The other factors.
And he has addressed everything perfect.
I think that was called other factors. And he was clear. Those other factors are not.
Jim Cornette calls it verbal flu.
Cause was cardiopulmonary
verbal fluovia or what?
Release, subdual, restraint, and neck compression.
No, I haven't.
Point blank. When I got back and got him to question him again after Mr. Nelson was finished, all I did was ask him about what he had written in his certificate on the case. Cause of death, cardiopulmonary arrest. Manner of death, homicide at the hands of another. He was crystal clear on it. He did not equivocate.
Crystal clear.
But what you have gotten here is a number of what I'd call stories. That once you analyze them and you once you analyze them and against the facts and the evidence that you've heard, you'll see what I mean. Take, for example, the notion that Mr.
Now, when they had the children on the stand, they turned the camera away, but you could still hear the testimony, right? Is that what happened?
Was just coincidental. He just happened to die at the same time, in the same place, of factors completely unrelated.
I'll go back and check some of it out.
To what Mr. Chauvin was doing with his subdual, restraint.
What I've seen of the prosecution, they've done an excellent job.
Gentlemen, and defies common sense. I'll show you what I mean.
But this is like, the entire plan for the stream was to, like, we really dove into opening arguments, kind of analyze those, and then we
if we just
picked up the highlights throughout the week, then we picked up the closing arguments this morning.
14th, 1973, and just made it a dot on a page. And we looked at over his lifetime. You'll see here, if we look over 10 years, 20, 30, 40 years.
Yeah, it was the other guy with the S. What's his name?
That means that Mr. Floyd would have lived up to that day 17,026 days.
Schleicher. Yeah, I've only really heard him speak.
Corresponds to May 25th. Only one of them. All the rest of these days, all the rest of these dots, represent days that Mr. Floyd was living. He was breathing. He had a being. He was living. He was breathing and had a being with every single disorder that Mr. Nelson has chronicled.
Mm-hmm.
Each and every day. You know, with his struggles with opioid addiction, with his high blood pressure, etc. Every single day, except
you hope Chauvin has to unmask?
May 25th, that tiny little speck of a dot, and not even that whole day. Because as we know, there was a 10-minute segment, 9 minutes and 29 seconds, that he didn't survive. So in one day's time, there are 144 of those, 10-minute segments. And only one of them was the reason that Mr. Floyd failed to survive. And what happened in that space? Well, you know what happened. Ladies and gentlemen, that's where there was deadly force applied by Mr. Chauvin. We know it was deadly force because we heard from Officer Zimmerman on the stand, who told us it was deadly force. He said it's deadly force because it's force capable of killing a person, which makes it deadly.
I am feeling a lot more confident that he is getting convicted of something after watching closing arguments.
Ladies and gentlemen, once you see what Mr. Floyd was subjected to with this deadly force in the prone position.
Exactly. That's why I think he was the best bet for closing arguments.
And the use of this kind of deadly force.
The plain English, breaking it down.
It affects your breathing.
Juxtaposed to just fucking.
It affects your breathing. Makes it harder to breathe.
It's called the shotgun fallacy, where you're just trying to throw as much shit as you can.
Because you don't want to affect their breathing. Low oxygen.
I think it should be called the birdshot fallacy.
There is evidence of low oxygen, ladies and gentlemen, that is medically unassailable, medically. Take, for example, the fact that Mr. Floyd had an anoxic seizure. That is,
somebody did that to me the other day. They wrote a fucking
not breathing, and the body
insane amount of words on Facebook, and I just kind of laughed. I was like, "Yeah, your stupid shotgun fallacy."
Low oxygen.
Excuse me, making it up. I was like, "No, I didn't."
And that is what causes the anoxic seizure. But not only that, he suffered.
And this guy is so likable.
And you remember we talked about the PEA, the pulseless.
I want to have him over for dinner.
PEA. The common cause of PEA is low oxygen. You can't fake it. You can't make that up. There's evidence of the low oxygen, and it would have been what would have proceeded from
Sir, please come over and I will make you a baked ziti.
Of deadly force. And this deadly force took place, as we know, within the 9 minutes and 29 seconds. Now, you heard the statement that the state is seeking to ignore significant medical issues, and nothing could be further from the truth. What you heard from doctor after doctor, whether it's Dr. Langenfeld, the ER physician, Dr. Rich, the cardiologist, Dr. Tobin, that you've heard so much about, Dr. Smock, so many of the doctors you heard.
Dr. Spock.
That here's, and Dr. Baker also, and Dr. Thomas, here's where they all converge.
What am I drinking? I am drinking a Dr. Enough.
That there was a use of force.
This is a drink that is only available in East Tennessee.
A number of things medically for Mr. Floyd.
I had company for WrestleMania, and she brought me a whole case of the drink that reminds me of where I went to college.
And he's no longer breathing. Now,
it is a Sprite
that this
type beverage.
Mr. Floyd was subjected in the subdual and the restraint by Mr. Chauvin.
It's Sprite with minerals and caffeine in it.
To explain Mr. Floyd's demise.
And you can only get it in East Tennessee.
What about his oxygen levels? Did he have insufficient oxygen? That's not something I can calculate as a forensic pathologist.
Oh, Nelson can go fuck himself. He's going to be able to treat himself, though, because I'm sure he got paid a shit ton to do this.
Dr. Fowler. And Dr. Thomas said the same thing. But
I'm going to drink tomorrow on the stream.
Pulmonologist in every case.
Not only am I going to get stupid stoned, I'm going to drink.
Who did the calculations? Who could tell you how much oxygen was in Mr. Floyd's body? And not only that, he could tell you that when he's put into the prone position, that his oxygen would have decreased by 24%. He can tell you that when weight was put on Mr. Floyd's back, the oxygen diminished to 43%. He can tell you that with the weight on his back, that the hypopharynx would have narrowed to 15% or lower, making it difficult for anyone to breathe through. He was able to tell you medically, scientifically. Not only could Mr. Floyd not have survived this
medically, scientifically
supply, but no human being could have survived it. Based on the science. Based on the science. Now, if it's dismissed as theoretical, which is a word I think I heard, theoretical, well, it's the same theoretical that Dr. Fowler said that he would defer to someone else to create because he can't do it. And that's exactly what Dr. Tobin did. And so here, ladies and gentlemen, we're only required to show you that Mr. Chauvin's conduct was a substantial cause, a substantial factor in Mr. Floyd's death.
Directly addressing the
automatically from
wasn't the only factor
low oxygen
that Nelson brought up, which
Ultimately,
didn't
the
seem
low
like a
oxygen
good
translates
argument.
into not breathing and the heart stopping because we have cardiopulmonary arrest. Did it first impact the heart, then the heart stopped first? Ultimately, they both stopped because we have cardiopulmonary arrest, all stemming back to the subdual, restraint, and neck compression from Mr. Chauvin.
I'm Chauvin listening to this. I'm like, God damn, I'm fucked.
Point. And then from there, the stresses, the strains on Mr. Floyd's body, the low oxygen, culminated in his ultimate demise and his passing away. So I want to address kind of several other points on the heading of what I think are stories that you've heard versus I think the truths here. You know, when the case started, I think you all were asked and talked to about there being two sides to every story. Two sides to every story. Which is one of the most dangerous things, I think, about the process of truth, because it suggests that everything...
I've pointed that out numerous times. I don't know if he's writing or if he's doodling or something.
That means there can be multiple sides to a story, and they can never be a truth or reality. Except
because every time we look over at him, he is just like scribbling furiously.
And not simply.
Except for one time during the closing, the camera took a shot of him.
Right.
And he was smirking and really enjoying his defense.
To take seriously this overarching mission of the police.
And I didn't think he should have, because it was not a good point that he was making.
Protection of the public as the highest values. But it is equally wrong. It is equally wrong to take this badge, which is a symbol of a commitment to a higher calling to serve the people, to use this badge as a license to abuse the public, to mistreat the public.
That's what they do.
To not follow proper procedures, to not render aid when you should administer aid. That's wrong. That's not a story. That's simply wrong. And the only two sides to that would be the W and the G for that being wrong. Now,
that's a good line.
You have heard statements to the effect of Mr. Chauvin being concerned about the bystanders and about others. Well, if you are looking at the totality of the evidence, you have to bear in mind that at all relevant times here, there were 5 grown men police officers right there. And 4 right there on the scene. And then you got Officer Chang, who was there too. There's a radio to call for backup if they felt it was needed. You didn't hear any evidence about any call for backup at all. Now, there was a concern here that Mr. Chauvin was concerned. And I won't say much more about body language than has already been discussed. And you'll decide.
He doesn't look concerned. He looks annoyed.
The face of one who was afraid at the time. Because he had all of the power at this point. He had the bullets.
Yep.
Guns. He had the mace that he threatened the bystanders with. He had backup. He had the badge. And he had all of it. And what was there to be afraid of here, particularly at
Not
this
a goddamn thing.
There were 3 high school juniors.
He was afraid of his little dick being exposed.
Going to the store to get candy. There was a high school senior who was taking her cousin to the store, a first responder on the scene. And there was Donald Williams, who wanted nothing more than to try to intervene, to try to save Mr. Floyd's life. Mr. Charles McMillan, a 61-year-old man that if I gave him a name, I would call him the mayor of the neighborhood. He just likes to see what's going on and to look out for things, but he was simply there.
Also,
to intervene.
Chauvin's attire has been blue on blue every time I've took notice.
Or concern or worry. You've seen what the face of fear and worry looked like that day at that time.
Is that a back the blue thing?
When Mr.
That's
George
the face
Floyd
of fear when somebody's pointing a gun at you for no goddamn reason.
Wrong move of his hand, one turn in the wrong direction, and it could be his last turn, that he could be shot to death over an investigation around a fake $20 bill. That's fear.
I can't wait to see his face during the verdicts. I hope it's guilty on all counts, and I hope I get to fucking
an unruly crowd.
I want to soak in his face when he sees it, when he hears it.
Gotten to meet 2/3 of ones who were there at that time. I described them earlier as a bouquet of humanity. And I call them that because they came in different ages, different genders, different races, and they all came together focused on the one thing, which was they saw that a human
I'll come if he cries.
Was suffering, and they wanted to try to.
I will ejaculate all over my fucking console.
They were not only symbols of the love and caring we want to encourage. But
I don't think he'll cry. I hope I'm wrong.
They were also symbols of what it means to respect this badge, because they were in a very difficult spot then. You saw them on the stand almost to the last one.
Oh shit, wrong one. Sorry.
You felt the anguish even a year after the fact. They felt torn between their love for the sanctity of life itself that had them wanting to intervene to try to save Mr. Floyd's life, and on the other hand, their respect for the authority that the badge represents, for the city, for the state. They were torn between it. Now, the ultimate proof of this is if those bystanders did not respect this badge, they could very easily.
I don't think we're that lucky.
And simply have removed Mr. Chauvin. Then
call me cynical,
about how reasonable,
but I don't think we're that lucky. What a wonderful 420 that would be.
We wouldn't have to have any of these
if we get to watch that live on stream.
None of them
and toke up while the pig fucking cries.
Tore them up inside. None of them did that. Instead, they called the police on the police. Instead, they picked up their phones to memorialize what they were seeing so that it could not be forgotten and so that it could not be misrepresented. Instead, they waited for their day to come in and talk with you. Not, ladies and gentlemen, to tell their story, but to tell the truth about what they experienced. They didn't deserve to be called unruly because they weren't. And
if they implied that the crowd of citizens that were just concerned for man's life were unruly, tried to blame them, tried to blame the crowd for Chauvin's actions. Disgusting.
Defenseless, helpless man is literally losing his life one breath at a time right in front of them, and there's nothing that they can do. If you love life, you get excited when you see life being taken, when that's your perception. That's what they were excited about.
Absolutely, it's going to be a while before any justice is served. But I was like, this motherfucker.
You might wonder what's wrong with him.
Even if he got off, I mean, he's not going to.
So you felt the pain.
I'm confident he gets convicted of something. Even if he got off, he's still facing tax fraud. He's going to jail. He's going to jail. Period.
They get told.
The use of the words.
Oh, we have an objection.
The fact of the matter is, ladies and gentlemen, that there can be no excuse for police abuse. And I'll be clear, ladies and gentlemen. I will tell you if I think there's a fact that's been altered. I will tell you what it is, and that's all I ever mean when I say story. But there's no excuse, ladies and gentlemen, for police abuse, and you've heard any number of these. So let me walk through some of them.
I don't remember who it was in my chat that was like, and this was like 2 or 3 weeks ago. I was promoting the 420 special. And they were like, how awesome would it be if he gets convicted on 420 and we get a party?
Jenna Scurry, who is watching the scene. And she said that the officers remained in the same
And I thought the trial would be over before this.
For so long on top of the body of Mr. Floyd.
But I was wrong.
That she thought the camera was broken and frozen. They weren't
distracted. That is indeed actually a possibility. And somebody called it like 2 weeks ago or 3 weeks ago.
Disturbed by the traffic or anything else. They had an officer there, Officer Tao, whose job it was.
But like,
just to fend off and keep away distractions, and could have called others if needed.
If it's a slam dunk, we might get it tonight.
Also, heard about the paramedics taking.
If we've got a holdout,
paramedics took longer to get there than was planned.
It might be weeks.
Should have been there within 3 minutes. And your common sense will tell you that the mere fact that the paramedics took longer than Mr. Chauvin may have thought is certainly not a reason to either use excessive force or to abuse or to be indifferent to the fact that somebody is no longer breathing and doesn't have a pulse, that the paramedics took too long.
This is all just common sense.
The paraganglioma, which was also referred to as an
I think that's he's getting convicted of something.
Significant it is.
I don't see how that it's not possible.
Paraganglioma, headaches. Mr. Floyd wasn't reporting headaches. So
if he gets murder third, I think that's justice.
That the hallmark is headaches and he didn't have them. If this is about getting at the truth, and as well,
if he gets manslaughter, okay, at least it's something.
The fact of the
matter
in
this country, it's rare to even get manslaughter.
There have been 6 cases in.
But yes, Blackwell has been fan-fucking-tastic.
Had a sudden death from a paraganglioma, ever. Period. Carbon monoxide. Now, other than Mr. Nelson,
how in the world does somebody have the screen name Adolf Hitler on YouTube? How is that even possible? I get demonetized for the littlest thing, and they let somebody have the screen name Adolf Hitler. What?
We're going to talk about carbon monoxide and give this a reasonable honest assessment. But even more to the point about carbon monoxide that you just can't lose sight of. Whose car was it, ladies and gentlemen, that if Mr. Floyd is being subdued on the ground by Mr. Chauvin, and if he puts his face in front of a tailpipe of a car that's spewing out carbon monoxide, why isn't that an unreasonable use of force by an officer? In your custody is in your care. It's not in your custody. I don't care.
Well, I will tell you what.
Your custody is in your care.
I don't know why you think that Chauvin needed to kneel on Floyd.
Apprehend someone on the ground, subdue them.
But I am well aware that Hitler had a much bigger drug problem than George Floyd could have ever had.
Here,
and he was quite fond.
Was ever even on, and you learned all you need to know, which was if he was suffering from carbon monoxide, as Dr. Tobin told you, you wouldn't be able to get a 98% oxygen saturation from the oxygen they gave him artificially. You heard about the fentanyl overdose, and with this one, you were just told, earlier that afternoon he was asleep in the car.
Oh, I've been how the fuck long have I been muted?
Somebody who dies from a fentanyl overdose.
Because I went on a whole rant about Adolf Hitler. How the fuck does
if you pass away
YouTube
from a overdose, you
let somebody have Adolf Hitler?
You are in a coma
as a screen name.
People are shaking you. It is to no avail. If we're doing an honest assessment of the facts, looking at the totality of the circumstances. If we're going to talk,
I have a smoker's cough from my many years of smoking. I'm not a smoker anymore. Before 3, 4, 5 years after I quit smoking, I still have the cough.
And even Dr. Fowler conceded it from the stand in terms of what a fentanyl overdose looks like.
It muted me in the middle of talking. How's that possible?
My neck hurts. My back hurts. Everything hurts. You can't win. I'm not
weird.
That's not what happens with somebody.
Yes, Hitler had a methamphetamine issue.
They are completely non-responsive and not reactive at all. Methamphetamine. Ladies and gentlemen, what meth? There was so little of it that it was below the therapeutic levels that are given. You heard that from the toxicologist, from NMS, the laboratory that Hennepin County sends off the medical examiner pathology, not pathology, but blood samples to test for tox. He told you it was a minuscule amount of meth that was in his blood. And then we heard
minuscule, and like they're calling it meth. I thought it was amphetamines, which could have been medicine.
The fact that what they were saying was a pill that he was taking in the car was just as likely chewing gum, and showed you just before he was in the car, he was chewing gum in the store, opened his mouth, you saw the same white substance in his mouth. But here's the deal about the pills. If we're really going to give this an honest assessment of the evidence, why are we talking about pills that are not in his system? We know it's in his bloodstream already. We know he struggles with the opioid addiction. Why are we talking about pills that we know were not in George Floyd? Why? You have to decide that for yourselves, ladies and gentlemen. Why
it's called a red herring.
You know what's in his bloodstream. What is the point? And you keep hearing drugs in the car, drugs in the car. And the drugs were one pill. One pill that was not in George Floyd. And then the suggestion that he was somehow taking it in handcuffs in the police car, which makes no sense. There was no evidence of George Floyd taking any pills in the police car at all. There was a pill found there. Only.
Could have been the cops' pills.
You heard references in talking about Dr. Chauvin.
Could have been planted.
Years of experience.
Call me cynical.
Studying the way people breathe. But, you know, Mr. Chauvin's not a medical doctor. He doesn't have these years of experience and hours to pour over records. He didn't need it, ladies and gentlemen, because you know who else is not a medical doctor? 9-year-old girl is also not a medical doctor. You didn't need to be a medical doctor to understand.
Well, the defense pointed that out.
When somebody's saying I can't breathe, and not just saying it, everything about
they went to great pains.
And when that ends, they
talk about how the bystanders didn't know what they were talking about.
A PhD, you don't need an MD to understand how fundamental breathing is to life.
Adolf Hitler was a habitual drug addict. How the fuck you come into a fucking chat and talk about habitual drug addicts when you yourself were a habitual drug addict and a complete fucking hypocrite about it?
You just a couple more of these because I can't even do
Italy boy.
There's so many. This concern that George Floyd would somehow come to again. He would come back around again. And they'll say, we didn't really mean superhuman strength, except maybe we really did mean superhuman strength because he's going to have all this extra strength now and he's going to do dastardly things. Now
that's why 4 cops all over him while he was handcuffed was reasonable. A reasonable officer.
15,000 autopsies. And not a single one of them testified about one instance ever where somebody who didn't even have a pulse somehow spontaneously came back to life, broke handcuffs, and rampaged the city. It's the facts of this.
I was about to say it's called the Lazarus effect. It does happen. Like, it's very, very rare. But no, they didn't break handcuffs and rampage the city, though. That I know of. I might be wrong.
He would come to with no pulse and rampage the city. That's the sort of thing you see in Halloween movies, ladies and gentlemen. Not in real life. Not in real life. The idea that Mr. Floyd suffered from a sudden death, which is what Dr. Fowler was saying.
Oh, that was Jason, sorry.
Now he'll say that Mr. Floyd had a fatal arrhythmia in the end. That's misleading in a way because, as you've heard...
The fucking cop! You talk about George Floyd committing crimes. The cop was committing fraud.
The heart stops and the lung stops.
Tens of thousands. You committed crimes against humanity. You're Hitler.
Now, is there any evidence that there was an arrhythmia as the primary cause of his death, unrelated to the subdual, restraint, and neck compression on the ground? Zero.
Adolf Hitler criticizing somebody else about crime.
Zero. In fact, his heart was in such normal condition.
I love the internet.
Dr. Baker, during the autopsy, didn't even have a need to photograph it intact because it was so normal. Now, Dr. Rich did not say anything akin to George Floyd having a normal heart. That's not what he said. what he said.
Hey,
was
Hitler,
that
don't forget to subscribe.
he had a strong heart. And
Give
what
us
he
a
did
like and share out to your friends as well.
Patients all the time who may be in need of transplant.
I want all your fashy friends to show up,
Get a
please.
normal blood pressure. And he talked to you about how,
If you have any and you're not a lonely incel.
time, explains how it is that his body and its the arteries that serve the heart were able to compensate in the case of Mr. Floyd, and such that he did not die of a fatal arrhythmia, and there's no evidence that he died of any kind of a heart abnormality. Just two more of these things I just want to clarify.
You're Hitler.
There was a lot of discussion about the police conduct. The situations can change rapidly from moment to moment. And on this, I don't want you at all to lose sight of, again, the facts here. That for the 9 minutes and 29 seconds, the problem was there was nothing moving or changing, no matter what. Whether Mr. Floyd was calling out for his life, whether he was motionless with an
I mean, like Hitler, I would explain the U.S. Constitution to you, but you don't believe in it anyway.
No moment to moment.
So it makes no difference.
You're hearing that as representative of this case. It is not representative of this case, does not meet the facts of this case at all. So the fact of the matter is, ladies and gentlemen, the use of unreasonable force.
For anyone that may be consuming the audio-only version of this, somebody by the screen name Adolf Hitler did indeed just pop into chat.
Mr. Floyd. Now, you were told with respect to the law that the state needs to show that Mr. Chauvin intended to act unlawfully or to break the law. Look at your instructions. That's not accurate.
I don't think he has any regard for the law.
In fact, acted unlawfully, but not having to prove that he intended to act unlawfully. We need only to show that he intended to do what he did.
Which this was the point they wanted the judge to point out, and the judge left it to the prosecution to elaborate.
And that we will show.
As a rebuttal to the defense.
And we own that burden. So there really aren't two sides to the story about whether this use
looks like he's getting ready to bring it on home here.
Unreasonable. It was not authorized by the Minneapolis Police Department. The pressure on Mr. Floyd's neck did affect his ability to breathe, and I know that you were told when Mr. Nelson was just here that this was not a choke. It was not a chokehold, and that Donald Williams had suggested or so testified. And if you remember that testimony,
the prosecution went first this morning. They took about an hour and a half originally, and then they get a rebuttal to the defense.
How that even works. And while
but yeah, he did take 3 hours.
Donald Williams never gave that up.
I think it was over 3 hours.
So there aren't two sides to the story as to the unreasonable use of force.
And Blackwell wouldn't have took 45 minutes if there wasn't 3 hours of shit to rebut.
In just a few minutes, you saw it when Mr. Chauvin did not let up and we didn't get up. Even when he passed out, not breathing anymore, he doesn't let up or get up. When he knows he doesn't have a pulse, he doesn't let up or get up. Even when the ambulance comes, he doesn't let up or get up even then. They have to come up and tap him before he will let up and get up off the body of Mr. George Floyd. And they try to resuscitate him in the...
He's on top of a dead man.
He never regains consciousness. He never breathes again. His heart never pumps again. And Mr. George Floyd was deceased. So finally, ladies and gentlemen, I will sit down in a minute, but I wanted to save till the end what I thought was the biggest shading of the truth or what I call story.
Object to that, Your Honor.
You'll disregard
Whoa.
shading the truth.
Well,
It's exactly what you did, though.
Largest departure from here, the evidence. I'll show it to you. You were told, for example, that Mr. Floyd died. That Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
I have no clue. Well, I mean, Nazis just pop up everywhere, anywhere. There, you know, the internet is full of them. It's not like I attract them. I mean, I try to attract right-wingers because I want them to show up and try to make me look
Members of the
stupid.
jury, if you have any question about any part of the testimony or any legal question after you have retired for your deliberation,
What I've left out is I post all my shit on BitChute and Parler and Rumble and shit. So
it will take some
Adolf
time to
Hitler
answer
popping
any
it
questions
up
because I
isn't
will have
any
to consult with
surprise.
your lawyers and receive their input before answering your question. I do not say this to discourage questions, but only to advise you that it will take some time to provide you with an answer. As I told you, you will take with you into the jury room.
Acting surprised that fucking Hitler's. I am surprised that Hitler's on YouTube. I'm amazed they allow him to have that screen name.
All the laws that are necessary for you to know in order to decide the case. I cannot give you a trial transcript. No such transcript exists. We count on the jury to rely on its collective memory. You have been allowed to take notes during the trial, and you may take those notes with you into the jury room.
I mean, don't go away. Subscribe. Stick around on the channel and you might learn something.
Or those of another juror. The notes should be used as an aid to your memory and not as a substitute for it. It is your recollection.
I am confident that I can let any right-winger come on here and spew whatever the fuck they want to spew, and I can counter it and make them look like a fucking idiot.
Another juror. You should not give any greater weight to a
You will not see that confidence from right-wingers or even other lefties or shit libs that
We
are
all
on
have
the
feelings,
YouTube
assumptions, perceptions,
and the
fears,
Twitch.
and stereotypes about others.
I will go on
biases we are
anyone's
aware of,
stream.
and others we might not be fully aware
I will
of, which is
take
why they are
anybody
called implicit
on
or
one-on-one.
unconscious biases. No matter how unbiased we think we are, our brains are hardwired to make unconscious decisions.
Chauvin,
We filter what they say through the lens of our own
given the
personal
facts,
and background. Because we all do this, we often see life in
is a much bigger criminal than George Floyd ever
like
was,
ourselves or who have had
committing
life
fraud to the tune of tens of thousands.
We can also have biases about people like ourselves. One common example is the automatic.
It doesn't matter to Adolf Hitler, but this is about defending the Constitution. I read the
Bias
Fourth
can affect our
Amendment.
thoughts, how we remember what we see and hear, whom we believe, or
The Fourth Amendment
how we make important
protects George Floyd from having
jurors,
guns
you are being
pointed in
asked
his
to make
face over the
important
accusation of a $20 counterfeit
must.
bill.
One, take the time you need to reflect
The
carefully.
Fifth Amendment protects George Floyd from being executed in the street by the state, which is
Think about
exactly
why
what
you're making
happened.
The decision you are making, and
The
examine
defense's argument boiled down to they think cops are above the law and can do no wrong.
if the people involved in this case were from different backgrounds,
So anyone that believes in the Constitution and the rule of law
older or younger,
is on the side of a guilty verdict for Derek Chauvin.
religion or sexual orientation,
Point blank,
still view them
end of
and the
story.
evidence the same way.
Period. Dot.
3. Listen to one another. You must carefully evaluate the evidence and resist and help each other resist any urge to reach a verdict influenced by bias for
Closing arguments have wrapped up. The judge is giving
each of you have different backgrounds
instructions to the jury.
in light of your own insights, assumptions, and biases. Listening to different perspectives may help you to
Yes,
better
fraud
identify
is a long criminal history.
these hidden biases may have on decision making. And 4, resist jumping to conclusions.
How is Adolf Hitler going to come in here and try to play arbiter of morality.
Prejudices, sympathies.
It makes no sense, sir.
Or unconscious biases. The law demands that you make a fair decision.
As a bigger criminal than Adolf Hitler?
Your individual evaluations of that evidence.
And I don't care what the average person off the street may think if they've been propagandized to worship the fucking cops like the fascists they are.
You must select a jury member to be foreperson. That person will lead your deliberations.
But I would think if you're making an argument about popular opinion, I'm pretty sure the popular opinion in the United States right now is that Derek Chauvin is a murderer. And last time I checked, murderer is a bigger criminal than a drug user,
but only after
or even somebody who may have pointed a gun at a pregnant woman's belly.
You should not hesitate to re-examine.
I'm thinking that's where it's ranked.
If you become convinced they are erroneous.
I might be wrong. You can present evidence to the contrary.
Simply because other jurors disagree, or merely.
Yes, Hitler's in the chat.
Now, a single verdict form for each count has been prepared for you.
I got asked what I'm doing on my YouTube channel, and it's like I make fucking informative content.
The foreperson should mark the appropriate choice of the
let Hitler stay because Hitler will learn something.
Filling in the foreperson's juror number on the indicated line, and then signing the foreperson's name on the second line.
Well, I mean, Chauvin doesn't think he did his job because he wanted to plead guilty in William Barr.
So there's very little to add. Just an X, your juror number of the foreperson, and the foreperson's signature. The order in
rejected his guilty plea because Trump thought it would help him in the election.
Is strictly alphabetical.
Speaking of Hitler.
It should not in any way be considered as indicating which choice is the correct choice. When all the verdict forms are completed, the forms should be placed in the provided envelope.
Oh, yeah, well, I mean, who am I to judge trolls? I'm just amazed YouTube lets him have that screen name. That's blown my mind.
Read out loud in the courtroom in your presence.
YouTube doesn't let me do so much
During
shit.
your deliberations, you must not let bias, prejudice, passion, sympathy.
But yet you can have the screen name Adolf Hitler.
You must not consider any consequences or penalties that might follow from your verdict. You must not be biased in favor of or against any party.
You did subscribe to the channel, right, Adolf?
Disability, gender, race, religion.
Did you give us a like? Did you share us out to your friends?
Age, national origin, or socioeconomic status.
I want all your Nazi friends.
Must be based
Bring them to me.
And the law that I give you. Your like or dislike of any witness, attorney, or party should not have an effect on the outcome of the case. The state of Minnesota and the defense.
I love emasculating dumb fucks.
That you'll consider.
Nothing like a Nazi party.
Apply the law and reach
or a giant gathering of dumb fucks.
Of what the consequences might be.
Thank you, sir. I appreciate it.
Must be absolutely fair. Remember that it is fair to find the defendant guilty if the evidence and the law
just thanked Hitler.
On the other hand, it is fair to find the defendant not guilty if you are not convinced of his guilt beyond a reason.
Happy early birthday, by the way, Adolf.
The case is in your hands as judges of the facts. I am certain that you realize that this case is important and serious, and therefore
throwing a big party tomorrow, not in your honor. No. It's the holy high holiday. There you go. The judge is ready. Man, he really does look like a Mr. Potato Head, doesn't he?
Swear that you will keep these jurors together, separate from all other persons, and that you will not allow anyone to communicate with them or overhear their deliberations. That you will not make any comment to them about the law or the facts in this case, and that you will not disclose to anyone except this court anything which you may learn from their deliberations.
I do.
Thank you. Members of the jury, you're going to go with the deputy now back to your usual room. Including jurors 96 and 118. You, however, will be diverted to my office.
Now, I'm pretty sure they're in Central Time.
Part of the deliberations, but I would like to talk to you a little bit, so...
it's possible they're just going to go ahead and break for dinner, and they're going to come back and deliberate afterwards.
Deputy instructions. All right.
What's up, Ace? Am I left wing? Yes, very much. I'm so far left. I'm on the side that gives you your guns back.
Be seated. We're still on the record.
This is a matter of the Constitution. George Floyd's Fourth and Fifth Amendment rights were violated.
Was in the process, I think, of making expressing a concern or an objection to counsel's argument belittling the.
Okay, so they have taken the jury out, and the judge is clarifying.
I think we dealt with it sufficiently during the objections during the rebuttal, so there will be no additional instruction in that regard.
I do believe that it constitutes prosecutorial misconduct, and is
what
basis for grounds for a mistrial.
Okay,
bullshit.
I think the use of the word nonsense was what you're talking about originally.
Originally, Your Honor, but then in rebuttal there were repeated comments about how we were, and implications that we were shading was one example, that we were creating Halloween.
Well, fucking Chauvin murdered him. Yes.
Stories, and that was a repeated comment.
And the argument that he was just doing his job is bullshit, because the Constitution protects George Floyd from exactly what happened that day.
After the court instructed him to use the...
So the state cannot execute somebody with their knee on his neck.
Fabricated facts. And so there were multiple references to that, that we were shading the truth. Right? I mean, and again,
the prosecution does not agree that Floyd had a heart attack. You do not know what you're talking about.
Governed by State versus McDaniel. And the final argument to the jury of prosecutors governed by a unique set of rules.
Like we've been watching this stream now for 7 hours.
And even those
we're aware of what the prosecution's argument is. I don't have to look it up. I just watched it. We watched the whole fucking 7 hours.
Justice system, which mandates
we heard their case in its entirety.
Criminal punishment, but as the representative of the people in an effort to
that is not what they said at all.
For example, that when a prosecutor argues that a defense is meritless, she cannot belittle the defense either in the abstract.
You can't come in here and tell those of us who have been watching this for 7 fucking hours now. Others who are in the stream have watched the entire trial. I've just kind of covered the highlights on my normal show.
Constitute prosecutorial misconduct.
I'll note for the record that I overruled the first objection when Mr. Blackwell used the word story because it was isolated and in its context it did not seem to me to be belittling. However, the continued use of it, I did sustain.
It is not incorrect.
An objection that counsel made to the use of the word.
Also, you are referring to a medical professional.
Also, on shading the truth, that I sustained the objection and instructed the jury to disregard it.
That was not the first coroner's verdict. That was not what he said. A heart attack.
Misconduct that would result in a mistrial. I think it was adequately addressed by the court's instruction to disregard. All right. With regard to other matters we have, I think there were some bench conferences that that are fairly historical that you wanted to memorialize, but also a new motion based on events this weekend. Mr. Nelson.
Correct, Your Honor. Your Honor, as the court is aware, and as prior to coming into court this morning for closing arguments, we had an in-chambers discussion about events of this weekend, specifically referencing that an elected official, United States congressperson, was making what I interpreted to be.
I get my panties in a wad over anyone who has their rights violated.
Threatening and intimidating a jury, demanding that if there's not a guilty verdict, that there would be further.
And all Hitler had to do was not turn on Stalin, and he could have conquered the world. But Hitler was a dumb fuck
given the fact that
and a meth head.
This jury has not been sequestered. It has been my position all along throughout the course of this case that this jury should have been sequestered at the outset. The jury has not been continually told to stay away from media, only media about this case. There is a high probability.
Oh wow! So he's upset they weren't sequestered through the whole thing.
Seen these comments, are familiar with these comments, and things that have happened throughout the course of this trial. I mean, it's unfortunate that there was another situation that
they are sequestered as of right now.
But obviously, Your Honor, we also, as I mentioned previously too, one of the jurors does live in the city.
Of course, he was. He was having a panic attack. That happens quite often. We know exactly what happened. We watched all the video.
Go ahead.
Now I'd have to go back and double check my notes. So, Your Honor, I mean, I just think that the sum total of this trial happening in such a public context, number one, Number two, while all of this, I mean, the media attention is profound. I have admittedly stayed away from 99% of it, but that has required me to stay away from all media. I mean, this case has made. I
don't know about all media. It's not like you have to turn on Netflix and you're going to hear about the Chauvin trial.
I was advised of 2 television shows in the course of the past few days that specifically involve references to this particular case and the reactions of the characters in these stories to this particular case. This jury has, despite all best efforts, has been bombarded with information relevant to this case. It is impossible to stay away from it unless you literally shut off your phone or you shut off your TV, you shut off your computer.
He's asked for a mistrial already and been shut down.
Well, to be fair, the last few times I've advised
now
him,
he's asking for a mistrial again.
Pure and simple.
Right, but if you can't even watch your favorite Thursday night television program and it comes up, I mean, this is...
If you watch Young Rock, how are you going to know about the Chauvin trial?
Felt that this jury should have been sequestered from the very beginning.
Understood.
To make that clear. And so I had moved, based on this, again, for a mistrial. The idea is that it is a public trial. I think the court has...
They should have only been allowed to have DVDs and Hustler magazines.
Is so profound. It is such a... it is such a modern comparison. I mean, it's such a modern problem to have where literally I walked from this courtroom into the courtroom where I've been permitted to stay. During the course of this trial, I've received...
Be sure to subscribe, Ace, and if you're a Amazon Prime subscriber, you get a free Twitch subscription every month. You can, please, use it on me if you're not going to use it anyway.
But my phone gives me alerts on things that just happened. I mean, you can't avoid it. And it is so pervasive that it is... I just don't know how this jury... It can really be said to be that they are free from...
You get an awesome troll emote for subscribing.
U.S. representatives threatening acts of violence in relation to this specific case.
Oh my God!
Well,
they're bringing up Maxine Waters.
May have given you something on appeal that may result in this whole trial being overturned. But what's the state's position?
Your Honor, the state's position, first and foremost, and this is a concern I raised at the beginning of the proceedings, well into jury selection, is that we can't allow statements like this, vague statements, to be considered a part of the record on appeal. If there's a specific statement that a specific U.S. representative made, then there needs to be some sort of formal offer of proof with the exact quotes of the exact statement or some kind of a declaration. And I'm sure Mr. Nelson can do that if he thinks that that's something that's appropriate. I don't know that this particular representative made a specified threat of violence.
Who cares if she's the nicest person on the planet? She gets shit done.
I don't know what television shows.
If you're looking for someone who's a nice person, you are in the wrong stream. I am a severe asshole.
Vague allegations.
And I love being asshole. I love being a asshole.
That's being offered
to dumb fuck right-wingers and Nazis.
Matter, through the jury selection process,
I get off on it.
The court has provided instructions, has determined whether or not...
Maxine Waters is amazing.
The law presumes that the jury follows the judge's instructions, and the court has instructed the jury today that they're not to let any outside influences or public opinion sway their deliberation. And the law presumes that they would be capable of doing that. And so,
I don't give a shit.
Any sort of specific offer of proof or information in the record without any specific evidence that this particular jury was influenced in any particular way, I believe that...
You're on the side of Hitler. Hitler is commenting in the chat right now, and you two are on the same side. And you're coming in here and be like, oh, you love Hitler. What?
Such an evolving situation. Obviously, I spend my weekend preparing for closing remarks, and I certainly can supplement the record with news articles. I can supplement the record with the storylines of the particular shows that were brought to my attention. So I'm making it to note the record at this particular point, and I can certainly supplement them.
Yeah, you can.
I don't give a shit about your disingenuous critique. No, not at all.
I'm aware of the media reports. I'm aware that Congresswoman Waters was talking specifically about this trial and about the unacceptability of anything less than a murder conviction, and talk about being confrontational.
A troll tag team. That sounds kinky.
The press articles about that. This goes back.
Would you be into a troll tag team, Curiouser?
I wish elected officials would stop talking about this case,
Curiouser enough for that?
especially in a manner that is disrespectful to the rule of law and to the judicial branch and our function.
The judge is getting pissed.
They want to give their opinions, they should do so in a respectful and in a manner that is consistent with their oath to the Constitution, to respect a co-equal branch of government. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions, and that there is not in any way a prejudice to the defendant beyond the articles that we're talking specifically about the facts of this case. A congresswoman's opinion really doesn't matter a whole lot. Anyway, so motion for mistrial is denied. With regard to, there was a report that counsel were made aware of a few days ago that a juror may have been talking to a major media outlet. We checked with that major, and it appeared right from the beginning that it was third-hand hearsay telephone game.
It was bullshit.
That media outlet.
Project Veritas! The convicted felon!
Check out any veracity.
The motherfucker is caught doctoring videos over and over again. We've watched so many Project Veritas videos and laughed at them.
I passed that
Oh, dress up like a pimp and try to get fucking Acorn taken down.
Memorialization, but we also have to talk about a Blakely waiver.
Yes, Your Honor. So a couple of things. In terms of the memorialization of the sidebars and the objections, we had previously provided, and we had suggested that we provided our memorandum of the objections that the defense had made at sidebars. I am going to propose, rather than just simply reading through and taking an hour's time,
you have no clue what her information sources are, and I guarantee you she's far more informed than you are.
And in consultation with...
Like, you came in here and proved you got no fucking clue what you're talking about. You made a bunch of statements that aren't true at all about this trial. You're doing what's called pigeon chess.
What the objection was and what the court's ruling. There's no need to repeat what the arguments were. The only thing that you need to preserve for appeal is what the objection was and what the court's ruling was. So I would encourage...
There is a fantastic quote by Sartre.
And figure that out. And
never believe that the anti-Semites are completely unaware of the absurdity of their replies. They know that their remarks are frivolous, open to challenge, but they are amusing themselves, for it is their adversary who is obliged to use words responsibly, since he believes in words. The anti-Semites have the right to play. They even like to play with discourse, for, by giving ridiculous reasons, they discredit the seriousness of their interlocutors.
To make a record of.
They delight in acting in bad faith, since they seek not to persuade by sound argument, but to intimidate and disconcert. If you press them too closely, they will abruptly fall silent, loftily indicating by some phrase that the time for argument is past.
We can print it and get that taken care of. But I can do an oral waiver now.
Dumbest fucks walking the planet.
So, Mr. Chauvin, you can take your
Smokey did not show up. That was a false alarm.
Mr. Chauvin, you're aware that during the course of these proceedings, the state has filed what's called the Blakely Notice, or a notice to seek an aggravated sentence, correct?
Yes.
I have explained to you...
They see Hitler everywhere, he said in reply to somebody with the screen name Adolf Hitler.
In the event of a conviction on any one of the counts here, correct?
Correct.
We've discussed those, and I have specifically advised you that you have a right to have a jury decide whether or not the state has proven those grounds for an aggravated sentence beyond a reasonable doubt. You have a right to have a jury decide if you violate it.
If you guys, Ace and Hitler, if you guys want to stick around, you can give us a call. You can hop in the Discord, and we'll have a little fun chat.
we can waive that right and allow, if you're convicted, we can waive your right to a trial and allow the judge to make those determinations. I've advised you about that, right?
Yes, sir.
Now, do you want a jury to make a decision about the proof required for the aggravated factors if there's a conviction, or are you willing to waive your right to a trial on those matters and allow Judge Cahill to make those decisions?
I'm willing to waive it.
The people making an argument in favor of the killer cop is talking about other people licking balls.
This is another one of the
zero self-awareness from these people.
This is a waiver of your jury trial right when it comes to aggravating factors. Normally, we would submit a verdict form with interrogatories with a question and yes or no options, and that's what generally the jury would consider. In order to say yes, the jury would have to be convinced beyond a reasonable doubt. The burden of proof does not change. It's only that I'm going to be the one who's
Oh, but WAPO said. Oh, but see, what the fuck does that even mean? Do you even know what sound argument means?
Constitute legally.
Do you know what makes something cogent or sound? I doubt you do.
From both sides on that.
You're literally making a straw man argument.
I will be answering those questions.
It's so hilarious to get called on fallacies by somebody who is actively making a logical fallacy.
I would ask that you file a written Blakely waiver in addition. All right.
I just have a question on the form that was provided, and we can, again, it's an administrative question.
Right, it's an administrative memorialization, so you can do that off the record. All right, counsel, I'm going to talk with basically give instructions.
What system am I within? You're the one defending the fucking cop. You're the one defending the status quo and the power structure. Holy fuck, these people are dumb. All right, do one of you want to call in?
Which is a striking and pivotal moment after millions marched across the world in George Floyd's name. Now, 12 Americans will decide whether Derek Chauvin broke the law.
Are one of you going to call in? Or are you going to hop in the Discord?
So after the jury left,
you going to try to have a debate with me?
On the grounds that
because you'll see who's within a system. Holy shit. What the fuck does that even mean?
Conduct, saying that he used belittling language. And he again brought up concerns about the attention on the trial and said the jury...
Kiddos, are one of you going to call in? 917-830-4359. The Discord link is down in the description or in the bottom right-hand corner of the stream. They sound like dumb fucks. Calling me, I am the establishment, when they're the ones taking up for the goddamn cops. My culture is a monolith. Your opinion's totally safe, controlled, and given to you by your masters. Who's my masters? What master do I have? I'm interested here. And who's giving me my opinions? This would be a lot easier if one of you would call in, hop in the Discord. Come on, you know you want to chat with me. There I am. I'm in the voice channel right now. Hop in my Discord. Come on. Tell me about my monolithic culture. A combination of Western liberals, bureaucrats, media people, institutions, everyone from the EU to the federal government. What the fuck does that mean? You got no mic? You got a phone? Give us a call. 917-830-4359. I don't know what that means. My masters. I'm one of the most rebellious anti-authority people you are ever going to meet. So saying I have a master of any sort is hilarious. I am proud to have made a living for myself doing things my way, by my rules. I literally work for myself because I don't like having a master. Fascist idiots, though, they love being a master to corporate America. They don't understand that a democratic government is the counterbalance to the corporate masters. How am I a soldier for hire? Who the fuck is hiring me? I am indeed a soldier for hire. You can hire me to produce audio, video, I'll edit podcasts, I'll turn your PDF into a video presentation for you. That's the kind of shit people hire me to do. You're correct. I'm an independent contractor for media work. That's why I'm sitting here in a nice studio and my graphics look so good, because this is literally what I do professionally. Oh, so you're not against corporate America? Who the fuck do you think has power? What, you think like there's some nefarious government agency that's acting on behalf of something other than corporations? You are welcome to not just listen to me. You can come give your own voice. I will give a platform to anybody. That is how confident I am in my position and how I can defend it. Oligarchs, business owners, you're right. I agree. I am against capitalism. I think capitalism produces fascist corporations. Oligarchs. Do you know what the word oligarch means? Then call. Come on, give us a fucking call. 917-830-4359. Let's hear your sexy voice. You seem to have a lot to say. I would like to have a friendly conversation with you. I would like to hash out these ideas. Let's really get down to business. Not business owners. Business owners. Do you know what the word fucking oligarch means? Do you know what the word oligarch means? A small group of people having control of a country, organization, or institution governed by oligarchy. I really thought there was something about money and power in there. But clearly, in a capitalist society, an oligarchy are the people that own everything. Plutocrats. A person whose power derives from their wealth. So you agree. Oligarchy. Oh no, you're saying I mean plutocrat. Okay. Why? What? My left-wing media? What does that mean? First of all, I've been in the media business for 20 years. I am the media, sir. So, in this country, an oligarch, a small group of people with power, wouldn't that be the business owners? What the fuck are you talking about? So who is this group of elites if it's not business owners? What? This is some nefarious group in the shadows? You just explained. You didn't explain shit. Is one of you going to actually try to have a debate with me? Because you guys are, you're failing miserably. Explain to me who the oligarchs in this country are, if it's not the business owners. News media elites, Hollywood elites, government elites. Would you consider the Koch brothers to be oligarchs? Charles Koch. Because there's this little thing that keeps happening. All these right-wingers, they get all their news from these like fringe news sources. But every time I take one of their little opinion pieces that they give me from like Fee or fuck, I can't think of one of the other blogs now. They all come back to Charles Koch. Well, CNN is owned by Time Warner. It's a corporation. I told you I have a problem with corporations. I don't know what you mean by he doesn't run media. He funds almost every right-wing entity. Time Warner is a publicly traded company. They have what's called shareholders, sir. Do you not know how any of this works? And once again, you're making my argument. I am against corporatocracy. I'm against corporate media. I'm no fan of CNN. I don't watch the shit. I have numerous times said people are more informed if they watch my stream than the equivalent amount of time on any of the cable news networks. Hands down. So I don't know what you're talking about. So you got a problem with CNN, you have a problem with AOL Time Warner. AT&T Time Warner, whatever the fuck it is now. I do believe people care what shareholders think. I believe you have no fucking idea what you're talking about. But I do appreciate you coming by the stream and letting us know your ill-informed opinion. Do give us a subscribe, a follow, a like, a share, all that good shit. You can check out the audio version of the Troll Patrol Live. Do not forget to tune in tomorrow night at 4 p.m. Eastern for our 1-year anniversary 420 spectacular celebration. It is going to be a hell of a show. I am not going to do a show tonight. I'm going to get prepared for tomorrow's show. If you are watching on Twitch, I'm going to send you over to iDan Simpson. He is a badass. I'll come in and hang out with you guys for a little while. Do not forget, tomorrow, 4 o'clock p.m. Eastern Time, the 1 year and 420 spectacular. We're going to celebrate 420 all across the country. We're going to watch Reefer Madness. I'm going to do my first stand-up set in well over 2 years. Be sure to tune in for that. So go ahead, light one up, tip one back. It's all right to have a little fun before you hit the sack. I'm Justin FREAKIN. We will see you tomorrow on Hitler's birthday on 420.